My name is Courtney Veal. I'm the director of the JQC, but I'm leading this prosecution on behalf of the investigative panel of the commission.
Okay.
I just have a few questions for you. Starting off with your experience prior to becoming Judge Williams' staff attorney. I know you explained you had family law or domestic experience, correct?
That's correct.
About how many years?
So like I said yesterday, I'm not good with math, but between 2017 and 2023 is when I did child support, divorces, and custody.
Okay. And was that all at the same law firm, or did you work at different firms?
Different law firms.
Okay. And during that time frame where you were handling domestic matters, how many times did you appear in front of Judge Williams?
More than 5. I mean, my last firm, we practiced in Fulton, so a majority of our cases were in Fulton. So, you know, by random selection, how the clerk's office assigns a judge, I mean, it was pretty often, along with the other judges.
Okay. And in at least one case that I'm aware of, you were on a string of emails inquiring of Judge Williams' office about the status of an order. And that case was Green versus Green. Do you remember that case?
That wasn't my case.
Okay. Were you an attorney on that case,
No.
or were you involved?
No,
Okay.
not on that case.
Okay. Well, what is the name of the case that, well, I'm sorry, was there a case that you recall reaching out to Judge Williams' chambers on?
Yes,
Okay, and what was that?
Dickley versus Moore,
Okay. And you were the attorney on that case?
the associate.
Okay. That case was filed in 2019. Does that sound correct?
Yes,
Okay. Were you a part of the team that tried that case in 2021?
yes,
Okay. And that case was tried in front of Judge Williams?
yes.
Okay. The trial was July of 2021. Does that sound correct?
Sounds correct.
How long did the trial last?
It was a day.
Okay. Did Judge Williams ask you all to prepare proposed orders?
Yes,
Okay. And did you prepare the proposed order?
yes.
Okay. Did you email it to her chambers?
Yes, I'm not sure if I initially emailed the first email, but it was emailed to chambers.
Okay. Do you recall about how many emails you sent communicating with her chambers about the status of that outstanding order?
I can't recall the number, but I do recall sending an email.
Okay. Do you recall sending several emails inquiring about the status of the order?
If several is more than 2, then yes.
Okay. And a final order had not been issued on that case at the time that you started with Judge Williams in July of 2023, correct?
I believe that's correct.
Okay. Did you do any work on that case after you started with Judge Williams?
No,
Okay. Were you part at all of drafting the final order that was entered January of 2024?
you mean when I was with my previous firm?
No, in your capacity as a staff attorney with Judge
No,
Williams.
I'd never touched that case. I never received an email. My firm knew not to copy me on those emails, so I never received those emails. I don't even know when the final order was entered because I have no part in that case since it was my case.
Okay. If the record indicates that the final order was entered January 18th of 2024, do you have any reason to disagree with that?
If that's what the record reflects.
Okay. So from the time of the final hearing to the final order, approximately 30 months passed in that case. Were you or did you become aware of similar delays in Judge Williams' office at the time that you began working there?
No,
That was the only one?
that's the only case that I had that I requested a final order on.
Okay. No, I'm talking about similar delays, not cases that you were involved in.
You mean with other people?
Correct.
I don't think I'd be able to answer. I don't believe I knew of any other cases.
In the spreadsheets that you told the hearing panel about yesterday, you indicated that you had built in a way to track all of the cases that had outstanding orders. At some point during your employee with Judge Williams, did you become aware that the JQC had notified her about multiple cases in which she had outstanding orders long beyond 90 days?
Can you repeat your question?
Did you become aware during your employee with Judge Williams that she had been noticed by the JQC about cases in which there was a delay in issuance of an order?
Not noticed, but I do recall just having discussion, but not noticed.
Okay. And what was the discussion that you remember having?
It was just a discussion that there were outstanding orders and that the JQC was involved.
Okay. Were those in any way prioritized?
I mean, all the orders were prioritized, but they weren't single. I guess the ones that are in the complaint weren't singled out. I mean, all the orders were prioritized to get done.
So there wasn't a special, column on the spreadsheet, or there wasn't any conversation about, hey, I've been noticed by the JQC about extensive delays in these cases. Let's prioritize these orders for that reason.
That wasn't the discussion that me and Judge Williams had.
Was that your recommendation,
What?
to handle it that way, to prioritize the cases?
The way that I prioritized them on my spreadsheet was based on when the last hearing was held. And so that's how they were prioritized on the spreadsheet.
So after the investigative panel or the director alerted you folks, these haven't been ruled on, you just got to them when you could, you didn't move those to the front at all?
So I wasn't alerted. When I joined her office, I've never had any contact with the JQC. So I came in doing my job as I was told to do it. And so the way I organized the orders were based on when the hearing was, and I made sure those orders were done. So if that's prioritized, and they were prioritized based on when the last hearing was done, and that's how they were ordered. And that's how they're ordered on my spreadsheet, based on the last hearing.
So you had no independent knowledge of anything the JQC investigative folks were doing or not doing?
That's correct.
Great, thank you.
Did Judge Williams ever go into that spreadsheet and highlight or note specific cases and take them out of the order that you had them according to, the last hearing?
No.
You testified on direct that your practice was that you would get orders to Judge Williams for her review generally within 30 days, and that she would get them back to you within 2 weeks, correct?
The orders that I drafted.
Correct.
Mm-hmm.
Okay. Was that always the case? Were there some that took much longer than the 30 days?
I mean, there were some that take longer than that, right? You have attorneys that want findings of facts. You have cases that go on for 6, 7, 8 days. So those obviously would take longer because there are a lot more thought that go into those orders other than the ones that are, not as in-depth or intense.
Okay. When you started, for the cases that had had final hearings before you began with Judge Williams, were you tasked with completing those orders, or was Judge Williams the one completing those orders?
For the most part, Judge Williams would complete those orders. I was not present at the hearing, so I wasn't very helpful. Of course, I would edit them based on how I know that she likes certain things, but when it came to fully editing them, I wasn't present for the hearing, so
Okay.
I wasn't much help, but I was the best help I could be at that point.
And so by best help you could be, you mean you helped with edits on the order that Judge Williams drafted?
I mean, not all of them, some that I thought I could help. I received a proposed order that was 40 pages, and I couldn't make anything out of that. So those were ones that I really couldn't help with because I wasn't present for the hearings.
I just want to be clear about Judge Williams' current caseload, and I understand that you all have different systems in place now to keep track of outstanding orders and whatnot. But you testified yesterday in the general, which is the civil piece of Judge Williams' current caseload. You said there were about 200 cases. Is that correct?
So it's civil and it's criminal. I handle the civil docket, and so I think we have about 230. I haven't run the new numbers. We run those at the beginning of each month, but I believe starting in June, it was somewhere between 230 to 235. I could be off a little bit.
Okay. Do you have any idea the number of criminal cases that are currently pending in front of Judge Williams?
I wouldn't be able to give an accurate number.
Are we talking about 100 or 400?
I wouldn't be able to give a number. That's the litigation manager, and this docket came from another judge, so I wouldn't be able to tell you that number.
All right. You testified on direct about Judge Williams generally, and you characterized her as kind, compassionate, and you indicated that she handles herself in the courtroom with grace. You also indicated that anyone who appears before her would feel the same. Upon what are you basing that opinion?
Just being her staff attorney and watching the hearings and how the hearings end and how attorneys just thank her for her time and her rulings and, presiding over the cases.
Okay. You agree with me that if there was an attorney out there or a litigant out there who felt as if they were not treated with compassion or kindness or fairness, those people would not necessarily come to you as her staff attorney and tell you, correct?
That's correct.
Okay. If I could have just 1 minute.
Anything else for Ms. Green, Ms. McFadden? Or I guess that was Mr. Banks' witness, was it? Or was it yours? Okay.
Just a few things. Good morning, Ms. Green.
Good morning.
Director Veal just asked you about the experience of litigants in front of Judge Williams. You were representing a party in front of Judge Williams, or you had several cases in front of Judge Williams. Tell the panel how you felt during your experience with Judge Williams.
My experience in her courtroom was a great experience. She handles her courtroom with grace. She's very direct. She asks the questions that she wants to be answered. And so she wasn't a judge that would, I use the word intimidate. As a new attorney, you have judges that, kind of scare you, make you cry when you leave. But she wasn't that type of judge when I was practicing before her.
The director asked you about the Diffley case that you were involved in that involved some follow-up with the judge following that matter. Were there any particularly complicated issues in that case?
Yes, it was a modification of child support, so there were a lot of financial components that were involved in that case that neither side agreed with, and so it was up to the judge to determine what the appropriate income and the appropriate amount of child support was to be.
I understand that you submitted a proposed order. You don't know what the final order looked like, though, whether that was the same order you submitted?
I don't even know what she granted. I don't know anything after leaving the firm.
Prior to receiving the final order, was there a temporary order in place?
Ooh, you're testing me. I'm not sure if there was a temporary order, but like I said, it was a modification of child support. So she had originally had a child support order that we were modifying.
What was the impact on your client of having to wait for an order?
I mean, she was frustrated. You know, she wanted the case to be over, and so she just expressed a lot of frustrations with me.
Were there serious financial implications?
Like I said, she was. I can't recall if, you know, if we filed any contempts or if he was not paying. I know that she was looking for an increase due to just certain expenses that, you know, she had and assumed that he had. But I can't attest to whether there were any financial, I guess, hardship is what your question is.
Hardship.
I can't attest to that. I actually don't recall because that case was so old.
Okay. I want to clear up a couple of things for the record. In your experience as representing litigants, have you ever waited longer than the 90-day time period to receive an order?
I'm sure I have.
So I'll be random here because I just want to clear up a couple of points.
Okay.
Currently in Judge Williams' courtroom or in her docket, are there any matters that are currently more than 30 days outstanding?
No.
Were you with Judge Williams when her grandmother passed?
Yes.
Did Judge Williams continue to work during that period?
We were actually in the middle of a divorce jury trial. So we concluded the trial. So yes, she continued to work.
In your experience with Judge Williams, has she brought kids into the courtroom?
She doesn't prefer young children. I mean, you know, if they're over a certain age and they're going to testify, but she does not allow children into the courtroom during divorce matters.
I mean, as part of community service efforts.
Oh, yeah, she does. Does a lot of community service. You know, we have the junior DAs that she comes and talks to once a week during the summertime, or she'll have other children, interns come and just, you know, watch the courtroom and, you know, she speaks with them.
At what age is the limit for coming into the court?
When you say coming in for a court proceeding or
You
just...
say children, I'm just wondering, what ages do you consider children?
Well, I consider children anyone under 18. You know, other people may say 20, you know, but for me, a child is someone under 18. And so she typically does not allow those children to observe those proceedings, especially if there is a custody portion of the trial.
Is that legal?
Is that legal?
Uh-huh.
I'm not sure I know any case law that would substantiate that, but I believe that, you know, a judge has the right to control and allow certain people in the courtroom, and I don't think that children under a certain age should be permitted into the courtroom watching a messy divorce or fighting over custody.
But whatever you and I think about it, what does the U.S. Supreme Court say about that?
I, off the top of my head, wouldn't be able to give you any case law with respect to that issue.
You never heard of the Presley case
No.
that even motorcycle cops know about? Okay.
Ms. Green, you testified about the systems and that your staff, the Judge Williams staff uses. To be clear, when you first joined Judge Williams' staff, there were systems in place, right?
Yes.
Your testimony was about adapting the systems for your needs.
Correct.
Judge Williams has an email protocol.
Yes.
What is that protocol?
So we are, how we work is that we're very customer based, right? So we answer the telephones, we respond to emails, and the email protocol is to respond to an email as soon as you can, but not later than 48 hours. Like I said, depending on if we're in trial, depending on other things that are going on.
Okay. One of the first major projects that Judge Williams had you work on when you joined the team was to walk the docket.
Mm-hmm.
Is that right? What does that entail exactly?
That entails me looking at every single case that is assigned to our division.
Every single, even if there are 600 cases?
Every single case.
About how many were there at that time?
When I started, it was, I think we looked at the numbers, over 700. And so I wouldn't walk it every month like I do the civil docket. I would walk it every 2 to 3 months. And it would just take it's a long process, but it ensures that cases aren't forgotten and that we're moving them forward.
Okay. That might be all I have. Just one second. That's all we have.
Okay. Anything else for Ms. Green? Ms. Beal? No. May we excuse Ms. Green at this time? Yes. Any objection? Ms. Green, thank you so much. You are free to go.
Thank you.
Just watch your step, please.
Yes.
Next witness?
Yes, you would recall Judge Williams.
Okay.
I'm assuming I don't have to re-swear her. Can we just remind her that she's under oath, or how would the hearing panel?
That's probably true, but it's not going to hurt to re-swear her, so why
Okay.
don't you just do that?
Sure. Judge, can you raise your right hand?
Absolutely.
Do you swear or affirm that the information you give this court shall be the truth, the whole truth, and nothing but the truth, so help you God?
I do so.
Okay, you can have a seat. Good morning.
Good morning.
So I know that you've previously testified at the first portion, and you talked a little bit about your background and your employment background, as well as your where you were barred. Please tell the panel where you were born and raised.
I was born and raised right here in Atlanta. I am a Crawford Long baby, which is now Emory Midtown.
Okay. And what area of town did you grow up in?
I grew up in Southwest Atlanta and East Point. I attended Venetian Hills Elementary School, Paul D. West Middle School, and Tri-Cities High School.
And do you have any brothers and sisters?
I do.
And who are your brothers and sisters?
Well, that's a complicated question. So on my father's side, Papa was a Rolling Stone, so I am the youngest of 10. On my mother's side, and there was a significant age difference between my mother and my father. One of the things I often tell people is that literally my father and my grandmother were born same day, same year, July 27th, 1941. So on my mother's side, I have one brother.
Okay. Do they all reside here in Georgia?
No.
Okay.
So my brother Jamal, who is my mother's son, he lives here in Georgia. We grew up in the same house together, grew up together. So people who really know me know that my father has other kids and I have siblings on that side. But if you don't really know me, you think I just have one brother and a sister, because those are the ones I tend to have a closer relationship with. And again, my father's children were all significantly older than me. So they were pretty much grown when I came along. I actually have siblings that would be my mother's age.
Okay. And you indicated you attended public school here in Georgia.
Yes, sir.
You went to Tri-City High School?
Tri-Cities High School.
And what year did you graduate?
Class of 2000.
Okay. And did you take a break before going to college?
I did not.
And you attended Howard University?
I attended the Howard University. I did.
Okay.
Class of 2004. My major was communications and culture with an emphasis on legal communications, and a minor in the administration of justice and sociology. And I had a minor in sociology / psychology, so it was a triple minor.
And what year did you graduate?
2004.
Okay. And where did you attend law school?
I attended Georgetown University Law Center, so just a couple of blocks up from Howard. I guess more than a couple of blocks, a couple miles away.
Did you take any breaks between undergrad and law school?
No, sir.
Okay. And what year did you graduate from Georgetown?
2007.
Are you the only lawyer in your family?
I am. Up until, so by way of reference, you'll hear me when I talk about my family, it's more so my mom's side of the family. My father died when I was 7, so I didn't really have much interaction with his side of the family growing up. They were in Tifton, Georgia. So on my mom's side of the family, I am the second oldest grandchild, so my grandmother's second grandchild born. And so I was the first one to complete, well, the second one to complete college, first one to complete a terminal degree. And my grandmother had like 30 grandkids plus, 36 grandkids. So 4 of us have advanced degrees.
Okay. But are you the only lawyer in the family?
I am the only lawyer.
Would it stand to reason then, therefore, you are the only judge in your family?
I am the only judge.
Okay.
Well, I'm the only one with the judge title, let me say that.
Okay. Tell the hearing panel, Judge, if you will, when did you know you wanted to become a judge and why?
So I've wanted to be a judge and a lawyer for that matter since I was 7. My mother used to joke and say that I was the only little girl who Matlock and the Golden Girls were her idols because those were my 2 favorite shows growing up. And so you would think that I wanted to be a defense attorney because Matlock was a defense attorney. But if you go all the way back to original Matlock episodes, Matlock was originally a prosecutor, and that was one of my favorite shows. So in addition to that, I had lots of exposure, both professionally and personally, as a child to the legal system, unfortunately. So my father, like I said, was murdered when I was 7, and nothing ever happened. So that was part of what sparked my desire to become a lawyer and to become a part. In my law school essay, I wrote that I didn't want any other little 7-year-old girl to feel the way I felt. So that was part of it. And then the other part was, my grandmother always says I was naturally that person who used to take up for other people and all that other kind of stuff. So my mother was an accountant. I'm good at math, but that wasn't my passion. Let me say it that way.
Fair enough. Has your goal from the age of 7 ever changed about wanting to be a judge?
No,
Okay.
no. And I was fortunate because as a child, I was exposed to lawyers and judges. And so it was also one of those things, because I saw it, I knew that I could be it. I knew that I could do it. So that's been my goal and passion since little girl.
And I think you indicated that your first job as a lawyer was a prosecutor in Philadelphia.
Yes.
And when did that start?
2007. So I worked in the Philadelphia District Attorney's Office for just shy of 3 years. In Philadelphia, you start off in misdemeanor court, and they start off in classes. So you actually start off with a 3-week training class. You're doing ride-alongs. They literally pass the drugs around in class so that you can see, touch, etc. Because, of course, if you're going to be prosecuting those types of cases, they want you to know what it is so that you can also ask better questions and more tailored questions. So I was there for almost 3 years in the MC unit and the juvenile unit.
Okay.
I'm sorry, MC means municipal court. In Pennsylvania, misdemeanors are punishable by up to 5 years. So a lot of the things that we have, a lot of the crimes rather, and statutes that we have here in Georgia that are felonies are actually misdemeanors in Pennsylvania. So you could say I had a misdemeanor and felony practice by Georgia standards.
And I know that you also served as a prosecutor in the Atlanta Judicial Circuit as well as in the Stone Mountain.
Correct.
And so if you can give a sense to the hearing panel of how many years that you served as a prosecutor.
Approximately 10 years. So I did approximately 2.5 in Fulton or the Atlanta Judicial Circuit. There I started off in the non-complex, but I was only there for like 2 weeks in non-complex, and then I went to complex. Actually, Judge Jack Golker was my very first judge. So I was in his courtroom for 6 months. And then I proceeded to the Crimes Against Children unit and then the Homicide unit. In the Crimes Against Children unit, and it was actually Crimes Against Women and Children back then. So in the CWAC unit and the Homicide unit, those are specialty units, so you carry more than one courtroom. So I had multiple judges that I was assigned to. In addition to that, literally, I've tried everything from low-level drug cases all the way up to murders. I was the youngest person in the CWAC unit and the homicide unit when I was assigned there.
How many, as your 10-year stint, or approximately 10-year bid as a prosecutor, how many trials did you try to verdict?
So let me start with jury trials. So I've tried over 25 jury trials to verdict. Certainly that does not include jury trials that we started and the defendant took a plea or something of that sort during the course of the trial. I never had a trial that was a mistrial or that we had to stop for some other reason. As far as bench trials, I've tried in excess of 500 bench trials.
And so that's a whole lot of bench trials.
It is.
So explain to the hearing panel how you have tried that many bench trials.
So as I stated in Pennsylvania, misdemeanors are punishable by up to 5 years. So the way that system works when you're in MC court, literally, it was nothing for me to have 70, 80 cases a day. And that was when I was in trial court. So that was not prelims. And so literally, you had to be prepared on all of those cases. And I was in the MC unit for 2 years. I was only in juvenile court for probably about 6 months maybe. So when I say in excess of 500 cases, bench trials, it was nothing for me to have literally 10 trials in a day, depending on the day.
Okay. I think you also have previously testified that you have some experience as a civil litigator before becoming a judge.
Yes.
And was that both for the plaintiff and the defense side?
Yes.
Okay, and how long did you serve as a civil litigator before taking the bench?
5 years total. So my very first civil job was at a firm in West Virginia called Bailey and Glasser. So I was actually recruited there from the Philadelphia District Attorney's Office. And there we handled, even though the firm was based in West Virginia, all of the cases that we handled were all across the country. That was also the start of the Toyota MDL litigation. And so I handled a lot of that litigation. We had one of the seminal cases. So that was at Bailey and Glasser. And then after I left the DeKalb DA's office, I went to Thomas Kennedy Sampson and Tompkins, which is a hybrid firm here in the metro area. It is also the oldest minority-owned law firm in the Southeast, I believe, but certainly in the state of Georgia. There, I handle civil defense cases as well as plaintiff's cases, wrongful death cases, some medical mal, but not a lot of medical malpractice cases. I handle, of course, tort cases, personal injury cases. I represented clients on the defense side who were always being sued, so I was in court a lot, in depositions a lot. And on the plaintiff side, I represented high asset cases, or high value cases, rather, as they call them, complex litigation. So the negligent security cases, those types of cases.
How about domestic work?
Yes, so I did some domestic work, but it was very limited. And the domestic work that I did never ever went to court.
That was going to be my next question. Did you have any experience in domestic or family law?
Very little, like I said. I think I handled a child support case. I handled 2 divorce cases, but they were, one was not contested at all, and the other one, they just needed somebody to help them work through the issues and do the paperwork for them. Also, like criminal defense work, I did just a little bit of criminal defense work, but nothing that ever went to a trial or court.
Okay. I want to switch gears here and talk a little bit about your aspirations to being a judge, and ask you specifically, prior to qualifying in March of 2020 to run for the seat that you currently hold, did you make any efforts to seek an appointment?
I did. I applied twice for appointment, never got an interview for either.
Okay.
What year was that?
You
You remember who the governor was?
I believe it was Governor Deal. I know I was at the firm both times, so it would have been between 2016 and 2020.
Was it for an opening, a replacement, or was it a newly created spot?
It was for Fulton County Superior Court, so it was for an open seat.
When you said you never got an interview, you mean you never got an interview with the JNC? Or
Correct.
you never got an, okay. So
Yes,
was it
ma'am.
one of those things where they had like a really big list and trimmed it down to a smaller list of folks to interview, or?
That would, so I know the first time, I don't know how many people applied.
Right.
But I did apply for that seat, did not get an interview.
With the JNC?
With the JNC.
Okay.
My apologies, yes.
Gotcha.
The second time, I don't know how many people applied, but I did not get an interview with the JNC.
Gotcha, okay.
you would agree that you're not alone in not getting an interview when you submit an application for appointment. You would agree with that, right?
I would agree with that, sir.
Okay. Why not simply submit another application for an appointment? Why did you decide to put your name in the hat?
The candid answer is when I looked at the landscape of the Fulton County Superior Court, the last person of color to be appointed to the Fulton County Superior Court was 2018. Prior to that, it was 2000, the year 2000. Again, I'd applied twice, and I felt like I had the experience. I felt like I had the qualifications. Certainly, I had appeared in that court before various judges practicing in that court. I'd worked in the circuit. My assessment was certainly that my background was far more diverse, even when we're just talking about the type of work that I did, than the folks who were getting appointed. And so it was my assessment that if I was going to be on the bench, I was going to have to run for it. The other thing is when you look at the Fulton County Superior Court, again, Superior Court, all but one of the judges of color were elected. So all of that played into my thought process. Whereas with the judges who were not of color, there are 12 of them, 10 were appointed, 2 were elected. So all of that factored into my thought process. And frankly, I felt like if I was going to become a judge and in that political climate, and I'm apolitical, which is, that's a side note, but in that political climate, I felt like the only way I was going to be able to become a judge was to run. The other thing is, when I say I'm apolitical, I don't mean that I don't vote and things. That's not what I mean. I mean, like, I am not that person who runs in the political circles. So I didn't have political connections either.
Okay. How old were you when you qualified for your seat?
I was 36 or 37.
And how old were you when you took the bench?
38. And so I was the third youngest judge elected to Fulton County Superior Court in its history.
Why did you decide to run against an incumbent?
Very interesting question. So when I decided to run, let me go back there. It was not my understanding that anybody was going to be retiring. There was speculation that some folks might be retiring, not because they had said it, but just because, you're looking at folks' age and you assume that they may be coming off when you look at their age and years of service, et cetera. So I wasn't sure. So what happened was in October of 2019, I decided to prepare myself in case, because there were murmurs that someone might retire or somebody might step off, and so there might be an open seat depending on when they stepped off and, that 6-month rule. So I decided to prepare myself. So that was October of 2019 when I filed my DOI, my Declaration of Intent. At that point, I had done my research on literally all 20 judges of the court to decide, okay, if I were to run against an incumbent, because by this point I felt like, based on what I'd observed, that was going to be the way to the bench for me if there was not an open seat. So I did my research on all 20 judges and decided who I thought would be good for me to run against. It was nothing personal. It was truly about looking at folks, their experience, my experience, looking at folks on the court. I did research. I talked to people about their experiences appearing before certain judges. I had certain folks who told me, oh, I support you, but if you run against this particular judge, like, I will not vote for you, right? This is a good judge. If you run against this judge, fine. So I had all of that data that I collected. So my intention, at that point, there was no open seat for me to run in. And literally, there was a judge on the Fulton Superior Court who the week of qualifications decided that they were going to retire. Well, literally, when I got down to the Secretary of State's office on Friday to qualify, there were 6 or 7 people who had already qualified for that seat and others who were standing there with me to qualify. So I actually prayed, went and called one of my kitchen cabinet members, as I call it, and said, hey, so at this point, I have the opportunity to either qualify for an open seat or to run against an incumbent. And by that point, I had selected Judge Reeder as the person I would run against. So I talked to that person, and they actually said, get in the open seat, get in the open seat. But like I said, I prayed about it, and my gut told me to run against the incumbent. And that's how I made that decision.
Okay. I want to shift now, before I get to the allegations again, I want to shift to some of the things that the hearing panel has heard through some of the witnesses.
Yes, sir.
I want to, you heard Janelle Bowl testify on yesterday.
I did.
You heard some of her testimony concerning the sealing of cases.
I did, and I don't know what she was talking about.
Okay, can you elaborate on whether or not you sealed cases without a hearing that come before you?
Absolutely, and I know Commissioner Hyde, this is your question in particular. I have never sealed a case, period, with or without a hearing, so that's
Okay.
first.
I understand when you say you've never sealed it, but you remember you didn't have anybody arrested either, you just had them put into custody.
No,
So
no,
I have
sir,
to-
that's what I was-
have to break down your statement. Are you saying you didn't lick the envelope and seal it? Or
No.
are you saying you never caused a document to be sealed?
Those were literally going to be the next words out of my mouth. I have never sealed a case. I've never caused a case to be sealed. I have never, nothing. I have had motions to had motions filed to seal a case. I've had hearings on those cases and declined to seal the cases because they were not for reasons that met the statutory requirements. So I've never ever sealed, caused to have sealed, or engaged in any practice of sealing
Because
cases.
it seems like it would be easy to prove or disprove.
Correct.
Either
You can
did
go
or
look at my
didn't.
record. Never
You go
done
to
it.
the clerk's office and you,
That's right.
gotcha.
And so even with the cases that I declined to seal, there is an order, Commissioner Lopez, there is an order with findings of fact. And there are multiple cases. I can even tell you the lawyers who they were on at least one of them. But I've never, ever done that. So I'm not sure what she was talking about.
Thank you.
With regard to, I think what Ms. Bowles may have been talking about is that there were two cases in particular that were sealed when I took on the docket. Those cases I did not unseal because my predecessor had sealed those cases. So that was something that was done before I even got there. So when she talked about having to do an order to, for the filing purposes, when a case, I can't speak for other counties, okay? When a case is sealed in Fulton County, the court cannot even file into the case, and certainly you don't get notifications. So in order to file, you literally have to unseal the case, file it, and then seal it back, so to speak, right, in order for filing purposes. And when I say unseal it, I mean you literally have to give the clerk's office an order that says, please file this document into the sealed case. They will file the document. The lawyers, whenever they have to file a document or want to file a document, you have to do the same thing. So that's the only thing that I can think about that she may have been talking about.
Okay.
I want to next turn to one of the issues about that came up about your re-upping your term there when you were assigned to the family division in Fulton County. Well, let me first ask you this. To the extent that you had a very limited experience in handling family law cases before you took the bench and were assigned to that division, what did you do to prepare yourself to handle those type of cases and to manage, I'm assuming you were aware of that massive docket there in Fulton County?
So I am the quintessential nerd. I am a constant student of life and all things. I actually enjoy going to CLEs. I was one of those folks who loved school. So one of the things that I did was before I even took the bench, because at that point they notified me that I would be going to the family division. Former Judge Reeder did not start off in the family division. When she came to the bench, she started off in the general civil division. And I know that for various reasons. One, because I'd done my research. Two, because I actually had a case that was assigned to her. So I know she did not start off in the family division. She transferred to the family division January 31st of 2020, right before the election. She took over Judge Brasher's seat. So at the point that I decided to declare against her, my understanding of how bench policy worked was not that I would be going into the family division, not that it would have changed my decision one way or the other. But once I was elected, and then in November, when I was talking to court administration and talking to Chief Judge Brasher, they informed me that because I was coined the least senior member of the bench, that I would be going into the family division. And to
They told
answer
you
your,
that in May when you won, or?
so I won June 10th, yes, sir, because that was COVID, so the election was pushed back to June. Judge
Okay.
Leffridge and I were on the same cycle. Those were the two seats. Hers was an open seat. Mine was the seat against the incumbent. Judge Leffridge, her race went to a runoff, so she did not win until August. I was sworn in December the 28th of 2020. Judge Leffridge was sworn in December the 30th. And so I inquired as to why she was more senior, quote unquote. And they told me the same story, that they picked a name out of a bowl, and that's how they determined it.
Who's they?
Judge Brasher and David Summerlin.
Is it unusual in your experience for a rookie judge to be thrown into the family division?
Based on my knowledge of the court, no one has ever gone straight into the family division upon first coming on the bench.
So you didn't ask these guys, why am I getting thrown into that?
I did, and they told me it was because I was the least senior person, and that's the person who was up to go into the family division. And so again, I'm the type of person who, whatever I do, I like to do it with excellence. So I took classes. I reached out to folks I knew who practiced family law and said, hey, can you give me a boot camp? Can you give me a primer, so to speak, in family law? Because I wanted to be prepared to handle those cases from day one. To Ms. Bush's point, before I took the bench, I asked them to pull the docket, them being court administration and Ms. Bush, because she was already working. I ran all of that through court administration. I looked at the docket so that we could also address how to best tackle, because they did tell me which docket I was getting, and it was not former Judge Reeder's docket. That docket was going to Judge Farmer. So I was getting FAM 3. Her division was FAM 1. So I did all the prep work, as I call it, to be able to also do a plan of attack for how we were going to get that docket down, because it was the highest docket in the family division. And so that's also part of the reason why when Ms. Green said that I was very proud, when I left the family division, it was the second lowest docket. So that's part of the reason I was very proud. So I did those. I reached out to folks, like I said, talked to folks, took a primer in family law. That the notices that I had, some of that was based on the primers. I talked to lawyers who practice in domestic across the state, not just in Fulton County, and said, hey, tell me some things that you think are helpful, not helpful when it comes to domestic. I also talked to lawyers who specifically appeared in Fulton, because Fulton is the only jurisdiction in this state that has a family division. So talk to me about the family division, and I had never experienced it or appeared in it. And then I also went down to the court and kind of sat in folks' courtrooms and observed. Well, when I say sat in courtrooms that were open.
All right. So when you went, you served in an initial 2-year term.
Yes.
And so that's lasted from the entire year of
2021 and 2022.
Okay. And so you had the opportunity to go to the general division of the Atlanta Judicial Circuit, or you could have elected to stay.
Correct.
You elected to stay.
I did.
Why?
So by that point, you're 2 years in. So I was just really, really getting the hang of things. Number two, this is my personal opinion. This is not opinion of Fulton County. We do these 2-year rotations in and out. And on a family case, certainly for some of those cases, they're just getting to the point of trial. And so in my humble opinion, sometimes it's a little bit unfair that they now have to start over with a new judge. And you have had all these temporary hearings and these motions, and you've gotten this familiarity. The family has built a rapport. And that's part of the one judge, one family system that we put in place. So part of it was, I say, because I enjoyed the work. I felt like I had a good grasp on what was going on. I knew what was going on. I knew the law. I knew the subject matter, et cetera. And then, of course, the cases, the people, right? When I got to the family division, or when I took the bench, the average case age was probably 3 to 4 years, somewhere in there, 2 to 4 years. Let me say that, because we did have some that were high 2s. But when I left December of 2024, my average case life was a year and a half. So I was also very proud of that we were able to cut the length, so to speak, of the pendency of the case.
How is it that the Atlanta Judicial Circuit, as you said, has the only one with family court?
Yes, sir.
The only one with these JO judicial officers.
Yes, sir.
How is it that at the Atlanta Circuit, is there local legislation that allows that?
There is, yes, sir. So there is legislation, and I don't remember, I think it's House Bill, I can't quote the number, let me say that. But there was legislation back in the 90s to create the judicial officer position. They are only allowed and slated to handle family cases, though, or domestic cases. They cannot handle civil cases, they cannot, well, regular civil, and they cannot handle criminal cases.
Because I haven't found that. I would be interested in looking at that.
I will certainly have somebody pull it and absolutely give it to you. And we actually looked last year at trying to expand the bill. So like I said, I have it. I just don't know the number offhand.
Fair enough. Let me ask, at some point, when you re-upped your term and you stayed there in the family division, did you at some point become the chief judge?
I did. I was next in line, as they say. So at that point, the most senior member was Judge Farmer, who had just rolled off as chief judge of the family division. And so then I was next in line. And the two, I think it was Judge Ellerby and Judge Newkirk. And I want to say Judge Newkirk had just come in. It might not. No, it was not Judge Ellerby. Or maybe it was. I don't remember. But I believe Judge Ellerby and Judge Newkirk were the other two judges in the division at that time.
Okay. I want to, if I can approach the...
Your chart says Judge Eaton, but I'm assuming that's after you had
Judge-
already gone by then.
Yes, yes, sir. Judge Eaton came into the family division 2024.
Right, okay.
So I actually, ironically, have Judge Eaton's old docket now. So Judge Eaton was followed by Judge Benton once she was appointed in the general jurisdiction docket. Judge Eaton came into family division once Judge Benton was appointed January of 2024. Judge Benton, when I rolled out and Judge Farmer rolled out, Judge Benton and Judge Adams came into the family division.
I'm putting up on the screen for your review your exhibit number 4, Carriage. You certainly are familiar with this document, are you not?
Yes.
Okay, and I know that this is from January of 2021, and it reflected you had a caseload of you inherited a caseload of 636.
Yes.
Okay. If I move this over a little bit, I want to ask you about some questions that came out on yesterday concerning post-family.
Judgment matters.
That's what I want to ask you about.
Yes, sir.
And so this is from January of 2021. Do you see anywhere on here of respondents for a reflection of the number of post-family judgment matters that you had when you first took the bench in January?
No. And so if you go to, I think it's July 2023 or July 2024, somewhere in those documents, you will see that there is a column added for post-family judgment matters. Part of the reason for that is because when I was chief judge, I noticed that data was not being captured on this sheet. And so this sheet does not reflect cases that are filed as a post-family judgment matter. So as far as non-post-family judgment matters, yes, I had 636. Oh,
I just moved it to July of 2023.
yes. So July of 2023 as non-post-family judgment matters. Oh, wait, hold on. So it's 2024 then, because this one doesn't say post-family judgment matters.
Oh, okay.
But
You
somewhere in
said
there,
23.
I said 23 or 24. I couldn't remember the year. My apologies. But the data was not being captured. So what I asked court administration to do was to add that column to capture that data, because that was a whole set of cases that were not being encapsulated in the data. The other reason for that is, of course, when we're doing our numbers for the AOC and trying to get new judges, Fulton has been on the list for forever and a day, and we keep dropping. And so one of the things I found was that all of our numbers were not being captured, specifically in the family division, because that's where I was.
Okay, let me put up July of 2024 and see if.
I think it's July 2024.
Okay.
But you should see post-family judgment matters added. Yep, right there. So that column was added
Okay.
to capture that data, which had not been captured prior to that.
Okay, it's not to say that you didn't have a number of cases in January of 2021 that included post-judgment matters.
Oh, I absolutely did. So when Ms. Bush testified yesterday that we had almost 800 cases, when I took the bench, she was not mistaken. She was not, it was not a misspeak. So the 636, again, that's without the post-family judgment matters. And so what happens is, even in the way that the cases are processed through the clerk's office, the cases that are regular cases, so to speak, regular domestic cases, they are automatically assigned a 30-day date. That's what that was capturing. However, post-family judgment matters, we actually have to pull the report every month to even see what cases are filed, and you specifically have to pull post-family judgment matters. So when I had Ms. Bush pull the numbers and pull the docket before I started, that was inclusive of everything, because to her point, she had learned how to pull the docket herself. And so there were almost 800 cases, including those.
Okay. And when you ended in December of 2024, you know, obviously you ended with a case count of
535, including post-family judgment matters.
Okay, all right. Are you proud of that?
Very much so.
Okay.
It took a lot of hard work from myself, my team. I did not do it alone. I think when y'all heard folks talk about the demands of the family division, it is not something that you can truly appreciate until you are doing it. So whereas in a regular civil case, you may have one order that you need to enter. In a family case, the average family case, you have at least 3 to 4 orders that may need to be entered. The complexity of the orders may be different. Certainly, there are a lot of different facets, right? And you're dealing with families, children, et cetera. So it's not a clear-cut, cookie-cutter case in any case, because there's no such thing.
Did you know early on, or did you know early on that your first law clerk wasn't going to work?
My first law clerk did work. That was Ms. Bush.
I'm sorry, then, the next one.
Ms. Bowles.
Ms.
I'm
Bowles,
sorry.
yes. So Ms. Bush was a fabulous, and I was intentionally and specifically looking for someone who had family law experience, because I knew that that was my deficiency, right? So Ms. Bowles, when I hired Ms. Bowles, that was when Ms. Bush left. Ms. Bush gave me a month's notice, which I greatly appreciated. She was a fantastic staff attorney. Ms. Green is a fantastic staff attorney. So when I put the position out, I actually did list the position. I had 5 applicants. At that time, the position paid approximately $70,000 to $80,000. They've since gotten a pay raise, but at that time, that's how much it paid. So of the 5 applicants I got, actually Ms. Bowles was the one who had the most diverse background. I had one person who had only done civil work at Big Law and had been there for 3 years. One person who was coming from the PD's office and had been there for 2 years. And then there was Ms. Bowles and one other young lady. The 5th person actually took a job out of state. And so what I did was, upon interviewing all 5 of them, I narrowed it down to Ms. Bowles and the other young lady. I then called both of them and said, hey, understanding that neither of you have been a staff attorney, and I did my interviews in person, because that's how I am, right? And I talked to them about the volume, the demands, and all of that stuff in the interview. Understanding that this has never been what you've done, and even with the family, doing family work, what would you do to help compensate for that? And Ms. Bowles gave me a phenomenal answer. She said that she had already reached out to a couple of staff attorneys, one in particular. She said that she talked to them about their job, their work, etc. She said that she'd already, of course, talked to Tangi, Ms. Bush, my then staff attorney, and she told me about systems that she would put in place and all kinds of other stuff. I knew that this was a job that someone needed to be very organized. I am also very organized and type A myself. So I knew that, and so her answer was what made me choose her. In addition to that, and being very candid, she had been practicing for 25 years. The other person had only been practicing for 3-4 years. So that was the reason I hired her. Now, going to why I'm sorry, you were about to ask me a question?
I was going to just re-ask his question, because I think...
When did it become clear?
Right,
that
that's what I was about to
out?
Right. So it did not become clear that she was not going to work out until around March, which is when I had that conversation with her.
March of
2022.
Well, you had more than, you were, in my view, you were very benevolent with her. Almost.
I was.
So you had more than one.
Oh, when I said that conversation, I meant the memo.
the memo.
Yeah, I was referencing the memo. So I had conversations with her before that, but they were always like, yes, sir. I was not aware of I was not aware of the severity, let me say it that way, until about February, right? Because that's also when folks would say, oh, we reached out to your chambers, we didn't get a response. And as Ms. Green said, I'm very big on customer service. I'm very big on returning people's phone calls. I hate calling places and talking to machines or somebody not answering. So that being said, that's one of my pet peeves and my rules in my chambers. So once I became aware, I sat down with her. So this was, like I said, about February. I sat down with her. The email thing was the first thing I became aware of. And so that's what she's talking about when I sat down with her and said, you cannot let your emails pile up like this. By that point, her emails were at 480 something unread emails that night. And so I sat down with her. I said, we are not leaving until we clear out these emails. I gave her some suggestions, some tips, etc. As you heard Ms. Bush and Ms. Green say, it's an adjustment, right? And so part of that was she was still in that first 3-month period, so to speak. So I was trying to say, okay, let's see if we can coach her up. Let's see if we can, because there were other parts of the job that she did phenomenally. There were other parts that she absolutely did phenomenally. And so what I noticed was that where she would improve in some areas, then she would not improve she would go down in other areas. So there was never any equaling out. So when we get to March, and may I see the memo? When we get to March, that was based on me having a conversation with her March 7th. I do not disagree that I should have fired her earlier. And I actually had intended, to fire her earlier. In June, I was about to let her go, and then her dad died. Because by this point, we had gone from March to June, and I was still seeing some of the same issues. I saw tangential improvement, but not substantial improvement. So by this point, she's been there approximately 6 months. Her dad died. That's on me. I felt like that was a bit heartless. So I did not let her go then. So then I was going to let her go in August. I had to let go of another staff member. So that's why she didn't get let go in August, because I didn't want to be in a position of hiring 2 new key staff members at the same time. So literally, I got that person in place. That person for the other position was in place, hired, got them up and running. So then I was about to let Ms. Bowles go, and my mother got diagnosed with cancer. The doctors told her she would not live to see the end of the year. So frankly, it was a matter of, I hate to say it this way, but the chaos that you know versus the chaos that you don't. And for me, I needed someone in that position who could at least help to keep the ship afloat, because I needed to step away. And, excuse me.
Take your time.
Okay, sorry. My mother and I were very, very close, and that threw me. Thank you. So, when we were at the doctor's office, and they told her she wouldn't live through the end of the year, I take full responsibility for everything I've done. But at that point, thank you, I couldn't. And Ms. Bowles was very loyal. So she did keep the ship moving. Ms. Walton, my litigation manager, Ms. Walton is phenomenal. My then judicial assistant, they kept the boat moving, right? There is no FMLA for a judge. And with the volume and everything else that we had going, like, I still was having court. I was going to all of my mom's doctor's appointments. Ms. Bowles really stepped up in that space. But again, I had conversations with her, and I said, listen, I appreciate you for holding me down, for lack of a better term, during this time of my life. And I told her, so this was approximately April now, February, March, April, somewhere in there of 2023. I told her, I said, listen, my mom's responding well to treatment. You know, she'd lived past what they told her she would live to. They told her that if she kept responding the way she was, that she would be a good candidate for the surgery, which is what they were trying to get her to. So I said, listen, we need to talk. This is April, excuse me, it's April. It's April because it was right after my mom rang the bell and before she's supposed to have her surgery.
April 23.
April 2023, my
Which is
apologies.
the same year of the memo.
No,
No, that's the next year.
this is the next year. So April 2023, when my mom rang the bell. So November 2022, same year the memo, to April 2023. Like, I was still holding hearings, I was still present, I was still out doing all of that, but I was not running and gunning like I had been.
Right.
So April 2023, after my mom rings the bell, I had a conversation with Ms. Bowles, because I also recognized that, yes, there were certain things that had gotten better, but it was across the board, this is not the job for you. And so I said to her, I said, listen, I'm going to allow you the opportunity to resign in lieu of termination. She then went on FMLA leave. That's when I started looking for another staff attorney. When she came back from FMLA leave, I already had my new staff attorney in place. During that time, by that point, we had additional funds, ORCA funds, that Ms. Veal referenced, but this was 2023. So during that time, I had a floater staff attorney who would come in and help out a couple of days a week. She was not assigned to me. She still had her other duties with Judge Emerson, with the other judges who were over there in ORCA. And then that's when June 6, 2023, Ms. Bowles came in and resigned. Ms. Green started July 6th, I think, or July, somewhere first week of July. She could not start in June. Otherwise, I would have started her in June immediately. So I was functionally without a staff attorney, a full-time staff attorney, for about 2 months, 2.5 months during that time. But I take responsibility. I should have fired her much earlier, but I didn't.
Okay. I want to ask a different question and just get your response to it that kind of highlights Commissioner Hyde's question. You heard Janelle testify
Yes.
yesterday. Some may walk away with the impression, based upon her testimony, that just in hearing her testify, that she was not qualified for the job.
Mm-hmm.
My question to you is that, how would you respond to that, and why didn't that come up, or you know about that, in her initial interview?
So she was qualified for the job. Be clear, the qualifications for the staff attorney job are 3 years of practice. So that's what the qualifications are, the bare line minimum. And as I stated, when I interviewed her, she had been practicing in her solo practice. And in my thought process, if you can manage a solo practice, then certainly you should be able to manage this, right? And especially for 20 plus years. I did look at the bar website. I didn't see any disciplinary actions. I actually did talk to people who I knew who knew her, and they gave her glowing remarks. And again, I'm not saying that Ms. Bowles has some great qualities. She's a good lawyer. She just was not a good staff attorney. And as Ms. Bush said, that's a different skill set. And so that's part of the reason I was also trying to help coach her up and help her get used to it, because I thought that she could do it. However, and I still think that she could do it in a different setting, but not this type of volume, not this type of pace either. And even if you look at the memo, March 14th memo, like yesterday she said that she was updating the outstanding order list every 2 weeks biweekly. That was not the case, because if you look at this memo, it specifically says that it is not updated. And so that's part of what I told her she needed to start doing, because my rule is that the calendars need to be audited within a week. Okay? So for instance, if we have court, and when I say audited, they're supposed to go back through.
I think almost every single one of her answers has been completely run on. And if we hope to finish this trial today, I would ask that the panel direct the judge to answer.
I'm happy to direct her.
Maybe, yeah, I was going to say,
Yeah.
thank you.
All right. And so let me now move to just the failure to rule complaints and ask you a few questions about that. Is that okay?
Sure.
Okay. I think you got the initial letter from the JQC concerning its investigation in February of 2022. Is that correct?
No, not on the failures to rule.
Well, I'm not talking about the failures to rule.
You said we were moving to the failures to rule. I apologize.
But I asked the question, is it right that you were first contacted by the JQC in February of 2022?
Correct, and I was on the Brandy Alexander matter.
Okay. And at some point, when were you alerted to the failures to rule?
July of 2023.
Okay. And at some point, did you respond to their letter to you concerning the cases that they had highlighted that gave rise to the failure to rule complaints?
I did.
Okay. Talk to the panel about how you prioritized those cases versus your other cases that were pending.
Sure. I was very intentional about not involving my staff in any of this. So what I did was I went through, because at that point, Ms. Green is my staff attorney. One of the first assignments I had Ms. Green do was go through and scrub the docket. And to scrub the docket or walk the docket, she literally has to type in every case number, go into that case, look through every single page. So it's a arduous process. When I got the letter, I believe that was maybe 2 or 3 weeks into her being there. I specifically went and pulled those cases because some of those cases I was not aware that an order had not been filed. I thought an order had been filed because I had given an order to be filed, right? Some of those cases had nothing to do with me, and some of those cases, one of those cases at least, the information was incorrect in it. So for those cases, I personally handle, which is why Ms. Green couldn't answer those questions for you, because I was very intentional about not involving my staff in anything regarding this JQC proceeding.
What do you mean the cases had nothing to do with you? I don't understand that.
I mean, I did not have a hearing on the case. So
Your name's on the door.
My name is on the door, but that case had happened before the judicial officer, and so Judge Williams never touched it. So there was a complaint in there, but it was not something that Judge Williams even knew about, let alone had any interaction with. So some of those...
But you brought up an interesting question. If you have a JO that works for you, the concept of the JO is foreign to me, and I'm not really sure who controls them, or like if I were a litigant in front of them and couldn't get an order from them, who am I complaining to? So if you have a JO that doesn't have isn't getting orders out, is that ultimately your responsibility because they're your employee? I mean, are you the one overseeing and making sure that they're also meeting the 90-day deadlines on their orders, or who's watching the JO?
Yes, for the divisions. So that particular case that was regarding the JO was not regarding an order that was outstanding. It was something about a motion that had never even been sent over to us. And in addition to that, the case was heard in front of the judicial officer. It was a motion for reconsideration. Our local rules say that motions for reconsideration go back to the judicial officer. So I had to do some research on that case. The other cases, one case was procedurally, it was incorrect. I guess the complaint was based on the notice. But in Fulton County, if a case gets moved or something like that, we don't go in and file an order saying this case has been moved. You just get a new notice. The other cases, I went and looked through and tried to figure out what was going on and why there was an order, not an order, etc. For some of them, I literally had to recreate the file because I had to recreate my notes and recreate the things to write the order. I did not have Ms. Green write those orders. I wrote those orders. So some of them got done then, and then I think it was about half or a little bit more than half of them. I don't have it in front of me to be able to say which ones.
Okay. Did you make efforts to prioritize?
I absolutely did.
Okay.
But your competent law clerk, Ms. Green, said you did not, and she did not, unless I misunderstood her testimony.
Yeah.
I understood Ms. Green to be talking about orders as a general principle, but that's perhaps because I know that I never shared with Ms.
I don't know
Green.
what general principle means. What do you mean by
My
that?
general operating procedures.
Okay.
I never shared with Ms. Green or anybody else in my staff any of those JQC letters. I never shared with them I don't talk about the JQC matter. I have intentionally insulated them from that.
But couldn't you have identified the cases without saying why? I mean, why did they need to know anything about the JQC? Couldn't you have said, check on case number 1, 2, 3? Why do you need to say, check on case number 1, 2, 3? Because I got a letter from the director of the JQC.
Because at this point, I need to figure out what's going on with the case. And so, yes, I can direct Ms. Green to do it, but I need to figure out what's going on with this case.
So why do you need to mention the JQC when you're asking?
No, that's not what I'm saying, Commissioner Hyde. You're asking me why I did it specifically.
Yeah.
Because I needed to figure out what was going on with this case. Because you also have to realize that at this point, I'm also I won't say not trusting, but I'm also like, okay, what is going on here? Because Some of this stuff, I don't know. One of them,
But
I
some of
knew.
the cases, even after you were notified by the investigative panel, it was months before you ruled even then.
Correct, because some of them I had to recreate what happened. I had to literally.
Did you notify the parties or the commission and say, I'm going to need a little time to recreate this?
I don't know what conversations Mr. Banks and Ms. Ville had, so I can't answer that. Certainly,
What about the parties? The poor people waiting on you to do something?
I did not have any contact with the parties.
Okay.
Okay, so again, I was working as fast as I could. In addition to that, with other cases that I was still handling, jury trials, et cetera, that I was in. So it's not that I was doing nothing, because some of those, like one of those orders, the proposed orders was 135 pages. If you look at the order that I filed, it was not the proposed order, and it was not anywhere near that. So it was also distilling. Now, part of this is I also admit I'm a bit of a perfectionist. So when you heard them talk about how I edit everything from head to toe, that's true, right? So part of this has also been in this process, me having to let go of some of that and just being like, you know what, it's not A work, but it's B work, so let's get it out.
But on any of these other duties that you were doing, the sanction from the General Assembly is not removal from office, is it? The failure to rule that you were notified by the investigative panel and you knew is the only issue you're dealing with as a professional judge that you can be removed from office from. Isn't that true?
I didn't know I could be removed from office from it at that point, Commissioner Hyde. If you recall,
Why is it anybody else's fault but yours that you
that's
don't know the
not
code
what I'm
section?
saying. That's not what I'm saying. You asked me what I knew. You asked me how I was operating, and candidly, I am being very candid, transparent, and vulnerable. I am telling you what I did not know.
Okay.
I could sit here and lie to you and say, oh, well, that's not the case. I did not know that. And so literally, I have 50 balls in the air, and I'm literally trying to work on everything, because here's the other thing. At that point, I don't want for there to be any more orders that are falling through. So I'm literally trying to triage whatever is over here that may or may not be done, which is part of the reason why I had Ms. Green go and scrub the docket. In addition to doing these, some of them literally, I did not have an order, a proposed order. So I had to write a proposed order. And it would be, in my mind, more efficient for me to write a proposed order based on what I recall at the hearing than to ask for a transcript from my court reporter, who is also doing all of this other stuff, and give it to Ms. Green and have Ms. Green review the transcripts and then write the orders. So it may not have been the best decision. It may not have been the most efficient decision, but it was not a situation where I was not trying. It was not a situation where I thumbed my nose or said, screw you all. That was not the case at all. And furthermore, let's be very clear. If you look at the orders that I entered, I don't rubber stamp orders. So I put thought into every single order. I try to make sure that my orders are common sense. That's also why my contempt numbers were down, why my post-family judgment matter numbers were down. They were so high before, and this is my humble opinion, because lawyers write orders for lawyers and the Supreme Court, not for the people who are having to operate in those orders day in and day out. So I take responsibility for that, but I did get them all out. I was working feverishly to get them all out, including literally working till 1, 2 o'clock in the morning. And that's part of the reason when you heard Ms. Green say that she would review them, it was because 2 o'clock in the morning, I'm not operating at my best.
Every judge I know works till after midnight usually on big cases. That's what being a judge is, isn't it?
I wish that was my experience, Commissioner Hyde, because most judges I know don't work at past 6. And that's not to say anything about them, but
Can we take a break?
I was going to say, this might be a great time for everybody to just take a breath and take a comfort break, so let's be back in 10 minutes.
Thank you, Judge.
Thank you. Have a seat. You look good. Thank you. All right. I think we're ready, Mike. Thank you. Good. Ready, Mr. Banks?
Yes, Judge,
Okay,
thank you
go
for
ahead.
that comfort break.
Sure, no problem.
Judge, I want to kind of still stay with the failures to rule just for a bit,
Okay.
and then we'll move on. You understand there are approximately 15, 16 failure to rule complaints in the formal charges.
15 years.
Okay. And have you been able to determine the percentage of those failure to rules and what percentage those cases make up of your overall caseload?
Approximately 1%.
Okay.
Where is that in proportion to other judges in your circuit? Do you get a printout on motions over 90 days similar to this?
No, sir. That data is not captured by anybody except the judge.
So you don't know what the other 19 judges could have 100 cases over 90 days. You would not know that.
Correct.
And you didn't find it during getting ready for this hearing.
I would not be able to capture that data, but for going to go speak to literally each and every judge.
Gotcha.
And I doubt they're going to tell me that.
The clerk doesn't have it.
No, sir.
On average, based upon, I think it's respondents for the summary caseload list.
Yeah, okay.
On average, how many cases did you close out a month?
100 plus.
Okay. On average, how many cases did you receive?
Approximately 100.
Okay. How, I mean, in your assessment of respondents for, how did your numbers compare to that of your counterparts there in the family division?
At times lockstep, and most times better.
Okay.
Most of the time I was closing out the same, if not more, than my counterparts.
You heard the testimony of Mr. Storch and Miss Reese, I believe. Do you recall? Was it Miss
Are you
Reese?
talking about Miss Reese or Miss Center?
I'm sorry, the other individual the JQC called.
Miss Reese was the lawyer, Miss Center was the pro se
Yeah,
litigant.
Miss Center, the pro se litigant. You heard the testimony of Miss Reese as well, Mr. Storch, and Miss Center, and how it impacted them based upon the failures to rule and the delayed rulings.
Mm-hmm.
How would you respond to them at this point, Judge?
The same way I responded from the beginning. It was not my intention. I apologize. Certainly having been in this position and having this over my head for the last 3 years, I get it, 100%.
As you sit here today, do you believe you have a system in place to adequately manage not just the general docket, but if you were sent back to the family division docket as well?
One, I would not be sent back to the family division docket under our rules. I've served my time, as they say, and so I can't go back under our rules. But for my time being up again, which wouldn't be for decades. As for a system, absolutely. I don't have any orders that are probably actually more than 2 weeks outstanding right now. And the one that comes to mind, the 2 weeks, is because I had that hearing right before the jury trial, and then this was the week after the jury trial. And they submitted their response briefs during my jury trial. So absolutely, the system works well. I tend to be a hand editor versus on the computer editor. So the binder system that Ms. Green and I came up with when we came into the general jurisdiction docket is working phenomenally.
Okay. As it concerns the staffing issues that you experienced, have you resolved those issues?
Absolutely. Ms. Walton is my litigation manager. She has been with me since 2021. And and she's great at her job, phenomenal. She's actually back in her element. She used to be a litigation manager in Fulton County State Court, so she's back in her element. Ms. Green is a fabulous staff attorney. We all have a great working relationship. So yes.
Okay. I want to talk to you about whether or not you have taken any additional training that covered issues surrounding case management.
Yes.
Okay. May I approach?
You may.
Handing you what is marked as respondents exhibit number 6. You recognize that document?
Yes.
And what is that?
This is my transcript from the National Judicial College as of September 23rd, 2023.
And are there any classes that are here on this? Does that accurately reflect the printout that you received based upon your CLE that you completed in 2022 through 2024?
Yes. Can we redact my cell number though?
We can.
Okay.
Okay.
Yes.
Okay. We can happy to do that. I apologize.
As of September 24th, yes, this is correct.
I move for the admission of respondents number 6 at this time.
Any objection?
No objection.
It's in.
Okay. Where on here does it reflect that you actually took something with respect to case management?
The managing complex litigation, decision making, enhanced judicial bench skills, advanced bench skills, procedural fairness. All of those specifically had a component of case management as part of the class
Okay.
or the CLE. And then I've also taken one since this that certainly are not on here.
As you sit here today, are you open to taking additional training concerning case management and other continuing CLEs to make you become a better jurist?
Absolutely. I am absolutely open to doing anything that makes me a better judge.
All right, I want to next turn to the issue concerning, is it Molly Denson?
Molly Dennis.
Molly Dennis.
Mm-hmm.
Let me just cut to the chase. You understand and appreciate that you didn't have the authority to do what you did, true?
Yes.
Okay. What was your intent, Judge, when you did what you did?
My intention was to try to help her, to see the error of her conduct, her ways. Do I believe that that her conduct rose to the level of contemptuous conduct? Absolutely. She was not asking her mom for Advil. Like, I am very intentional about watching people before I say anything, so not to jump to conclusions. When she talked about the deputy telling her to step out, is because she was literally laying down in the courtroom on the bench with her computer in her lap. That being said, and then there were some other things too, and I admonished them during the course of the hearing. That being said, I didn't want to put this young person who was essentially in the middle of her parents' fight in jail. So I literally was trying to not go that route and just teach her a lesson like, hey, you can't do this. Hey, you've got to be more mindful about your conduct.
But
So-
we can agree you did put her in jail.
I have not disagreed with that. In fact, I said yes.
Well, I think there was some confusion when I initially asked you about this. It made it sound like you didn't realize or didn't acknowledge that you had her arrested in your courtroom.
What I'm saying is, did I believe that her conduct rose to the level of contemptuous behavior? Yes. If I was going to put her in jail for that contemptuous behavior, do I believe that I should have had a hearing? Yes. What I am saying is, I was trying to not put her in jail and just trying to essentially say, hey, like scared straight for lack of a better term. That was not the right decision. So I guess I don't mean to come off as whatever it is that you're saying that that was confusing, because that was not my thought process.
Okay.
Did I?
I mean, I just want to make sure we agree that she was arrested in your courtroom.
I don't disagree with that, no.
Okay. And she was, at your behest, taken into the holding cell.
Correct.
Okay. All right. Thank you.
Do you understand? I don't know what we do with that. I was hoping you would explain it. I used the trooper rule. If a state trooper in Waycross did that same thing with somebody and handcuffed them and put them in a holding cell, the trooper would be fired, decertified, and prosecuted. So how do we handle, you've admitted falsely imprisoning this young girl without legal authority. So how do we deal with that?
I think you have to look at the big picture. One, I think intentions are critical, because it would be different if I just put her in jail and said, you stay back there, sit on the right street, or did any of that. That was not my intention. Those were not my actions. And so what I am saying is, this is not a situation where I was trying to be malicious. This is not a situation where I was trying to in any way deprive her of her civil liberties, shame her, do any of that. I was literally trying to help her understand her actions based on everything that was before me. Her tone, her behavior, the conduct that she admitted to on the stand. I was literally trying to help her see this is not the path that you want to go down. Now, again, scared straight, not a good tactic to take. I don't disagree with that. But that is the thought process and the mindset that I was coming from. Not a situation of go to jail, go back there, you've pissed me off. No, not at all. I was trying to help her.
You heard Molly testify about how this impacted her, how she has more of a distrust for the system in light of that encounter and experience. How do you respond to that, Judge?
I think it is always saddening when anybody has a distrust for the system. It was not my desire or intention to add to that. I didn't know about the things that were going on with her mom, candidly, as far as the court proceeding she was talking about with that. But that was not my desire. That is not my intention. In fact, I try to take a very transparent approach to the bench to help folks gain trust in the system. That's part of the reason I have conversations with folks, with litigants, with defendants who come before me, with folks, period, because I do recognize that people are very distrustful of the system. I do recognize that people are distrustful of lawyers, judges, etc. I get it, 100%. And especially being in this position, it is hard to sit in this position. It is very hard to sit in this position. And so it was not my intent. That's why I apologized to her. That's why I offered to have a conversation with her, to apologize further, to talk with her, to whatever the case may be. That's why I did that, because it was not my intention to have any negative impact on her, period.
Now, you said you apologized to her, and this is another source of our confusion, I think. You've not apologized to her, because she took the stand and said she had never heard from you and did not even realize there had been an apology offered.
I meant when I offered the apology on the very first day, I was instructed not to call Ms. Dennis and not to contact with her, and not to have contact with her, rightly so, and certainly given this the pendency of this, nor did I think it was appropriate for my attorneys to. So I don't even believe that they reached out to her, because I didn't, given the situation, I didn't want anybody to say that I was trying to do anything wrong.
So is it more fair to say that you would like to apologize to her because you have not yet done so?
That's fine, but I thought Mr. Banks said it to her too. He said, I apologize on behalf of Judge Williams.
He did. You did say that. I do recall that.
I mean, I had that permission to do so, but having said that, to your questions, I mean, I understand your point.
Okay.
Do you understand the point?
I don't have a problem with that.
Yeah, okay.
You talk about gaining the public's trust. So if you're a member of the public, all of these things you've done, or some of these things you've done are exactly opposite gaining public trust, aren't they?
Arguably, depends on who you ask, I guess, also, because, hold on, may I finish, please?
Sure, go ahead.
Because let's talk about all the things that I have done to uphold, gain, and strengthen the public trust. Nobody's perfect. I don't profess to be perfect. All of us can Monday morning quarterback. Have I made mistakes? Yes. Have I learned from those mistakes? Yes. I don't think it's worth me losing my job. Would I do it again? No. Have I paid penalties? Yes. Have I been in a position to do those things again? Yes. Have I done them? No. I don't even, like, literally lawyers will come and ask me to talk to me and I shy away from it. Family members have come to me. No. Have nothing to do with it. No.
I want to next turn, Judge, if I can.
Yes.
To the complaint surrounding your uncle and Bonnie Stinson and the case and the call. You recall testifying that you should have never made that call?
Yep.
Do you understand why you shouldn't have made that call, Judge?
Yes.
And why is that?
Multiple reasons. One of the things that I've learned as a judge, even though it's not the way I operate, certainly I do understand that other people operate in this manner, that because you're the judge, people sometimes feel a sense of intimidation or a sense of compulsion, let me say it that way, to do certain things, right? So even in a laughing matter, there are some things that people say, I'm like, nope, we don't even joke about it, right? So though I understand what my words were and what my intentions were, I understand how Ms. Stinson could have taken it differently. So that's one thing, right? The road to hell is paved with good intentions sometimes. And so it's just best to err on the side of not doing anything, right? So even in my personal life, there are things that I don't do because, as one of my mentors told me, you can never take the judge head off. So I don't.
Do you recall Bonnie Stinson's testimony whereby she said during the conversation that you had with her, you said, if the case came before me, you would dismiss it? Do you recall her testimony in that regard?
I don't recall those being her exact words, but I recall that sentiment.
Okay.
Yes.
Do you recall, as you sit here today, making that statement to Bonnie Stinson?
I don't recall making that exact statement, but I do recall saying that if what he's saying is true, then the case would probably be dismissed or something like that. That again, she could have taken to be those exact words. Okay. I don't recall what the exact words were.
Did Ms. Stinson, when she testified, did it refresh your recollection at all about what you exactly said? I think you've answered it, but I'm just going to ask you again.
I don't remember the exact words. I remember the sentiment. And part of that is I don't recall my exact words. What I do recall is saying something to the effect of, if what he's saying is true, then I don't see how there's a contempt or something like that. But I can't say that what she said were not my exact words, were my exact words. But I'm just telling you the sentiment and what I remember saying. I'm not saying that I did or did not because I don't recall those words being said.
You have no reason at this point, based upon Ms. Stinson's testimony, to believe that she's making that up, though, do you?
No, that's what I'm saying. I do recall relaying those sentiments. I don't know if those are my exact words.
Okay. Do you recall Director Veal, prior to Ms. Stinson testifying, asking you during your testimony about that specific comment, that you would, if this case came before me, you would dismiss it? Do you recall Director Veal asking you about that?
Yes.
Okay. Prior to Director Veal's question, had you ever heard that allegation before?
No.
As a part of your preparation of this hearing, did you review the discovery in this case?
Yes.
Is there anything about that allegation specifically in the discovery?
No.
Okay. Is that specific allegation charged in the formal charges?
No.
did the JQC, based upon your review of discovery, memorialize in writing anything that they discussed with Ms. Stinson?
No, the only thing that was in that file was the initial complaint, which was not by Ms. Stinson. Or the initial document. Let me not say complaint because I don't remember if it was that specific document.
Okay, so just to be clear, to the extent that there was a complaint involving your conversation with Ms. Stinson, what was in the discovery? Do you recall?
I don't recall if that, I reviewed it all. I don't recall if that one was an email or, I don't recall. So when I just corrected myself, there's a document called complaint. I don't remember if it was that document or if it was an email. But whatever it was, no, the information was not in there.
All right. I want to next turn to the email that your uncle drafted. Did you, in preparation of your testimony today, review your testimony from the prior proceeding back in May?
Yes.
Could we put that up on the screen? I don't remember what it said.
I don't know exactly where it's at.
Okay, well, we can get it later.
It's a joint exhibit. I just can't remember which exhibit it is. I got the notebook. Somebody can tell me the number.
Well, keep moving while we.
Okay. At some point, Judge, there were some testimony about who wrote the email. Did you physically write that email?
No.
Okay. Were you in the presence of your uncle at the time that email was generated?
No, we were on the phone.
Okay. Did you direct your uncle to what to put in that email?
Yes.
Okay. Do you know, did you hear him typing at the time that you communicated with him what to put in the email?
I don't know. That was the week my grandmother transitioned, so I do recall I was at her house sitting next to her, so I don't remember what I heard, honestly.
And Commissioner Hyde, were you asking for the testimony or the email itself?
Just that email.
Oh, okay.
Which J?
It's J31.
31. Thank you.
You're not disputing that you helped your uncle with the drafting of this email, are you?
No.
Okay.
I told him what to write.
Okay.
I never denied that.
Do you believe that was appropriate as you sit here today?
No, which is why I said nobody can even talk to me about anything legal, period. I won't even tell you how to fill out a form.
Did your uncle have help? Other than you, did somebody help your uncle?
I don't know.
You're the only lawyer in the family.
Well, I don't know because candidly I didn't see this email until discovery. I am the only lawyer in the family, but I'm not the only educated person in the family. In fact, his wife is a teacher. So I can't tell you about that physical drafting of the email. I can tell you what I told him to put in the email. I can tell you that I dictated the email, but I can't tell you anything about anything else.
What steps, if any, Judge, have you taken to ensure that this doesn't happen again?
I told you I don't even engage, period. Like, I will tell people you need to contact a lawyer. I will tell them where they can go, i.e. you can go to Atlanta Legal Aid, Atlanta Volunteer, whatever, depending on whatever they're telling me. Certainly there have been folks who said, can you look over this document for me? I tell them no. I don't engage at all, so to speak.
Okay. I want to next turn, if we can, to the Brandy Alexander.
Before you do that.
Yes.
This call is of some concern to me. Ms. Stinson was a fairly young and inexperienced attorney at the time, and did you not get the sense while talking to her at any point that this might be wrong, that a sitting judge is talking to literally a lawyer who's been practicing less than a year, I think at that point, and you know, what that lawyer might be feeling like talking to a sitting judge whom her firm has several cases pending in front of, talking about a personal matter. Did you not at any point have to be like, man, maybe this isn't right? The power imbalance here is pretty substantial from a sitting judge to a first-year associate at a firm. Did you not have that inkling during that phone call that maybe I shouldn't be doing this?
One, I did not know she was a first year or second year associate. I learned that through the discovery.
Okay.
Two, I was not aware that she had any cases pending before me at that time.
Well, you're aware that, I mean, the Shoemaker firm that's all they do is family law, right?
I don't know.
It is. I mean, and you didn't. Okay.
I don't know if that's all they do. I'm just trying to be honest. Two, I'm answering each component of your question, so not to give you a global answer that doesn't address each part. Two, what was I saying? Two,
You did
I did
know
not-
they had assigned
correct.
cases.
I did not know that they had an active case in front of me. Had they had previous cases, yes. Ms. Shoemaker had been a gall before me, actually. Three, as I stated before, like this is not an excuse. I've been encapsulated by trauma for the last 3 years. That was the week my grandmother was dying. I cannot tell you, like, I didn't even remember that I finished a jury trial until my lawyers reminded me of it. I've literally blocked that week out. So I can't tell you actively what I was feeling, thinking during that time, which is why I said I don't recall saying that, but I do recall those sentiments. So I can't say I didn't say those exact words. I don't recall, but I do recall the sentiment, because what I said to her was, this is what he said to me. I don't know if it's true. He's working on getting the documents. To the extent that that's what it is, then I don't see how there's a case, right? But again, I can't tell you my exact verbiage. Would I make that call again? No. Would I make any call? No.
Did she ever tell you, gee, I'm not comfortable? She didn't say I shouldn't talk about it to you, did she?
No, sir, she did not. And had she said that, and I'm not at all burden shifting or blame shifting. Had she said that, I would have apologized and said, I'm sorry, it was not my intent, and disconnected the call.
Do you understand how difficult it would be, though, for a law firm associate to have that conversation with a Superior Court judge? You do have a suck-up filter, I'm sure, that all judges should have, right? Lawyers
A
tell you
what?
how, a suck-up filter.
Oh, a suck-up.
They tell you how funny
Like
and
a brown
smart and
nose
pretty
filter?
and tall
I'm
and
gonna
thin.
object to that. I don't know.
Oh, I'm sorry, I just didn't hear what you said. I didn't understand when I
I mean,
heard you.
is it reasonable for us to think that this associate would say, Judge, I don't think you ought to be calling me, and hang up?
Mr. Hyde, I'm going to answer your question in the most honest way I can. I have now learned that. One of my deficiencies is that I think about the world from the position that I operate. I've said to judges, I don't feel comfortable with this conversation. I've said to partners in firms, I don't believe that this is appropriate, etc. That's not me. But I do recognize and understand that everybody does not have that type of personality. I mean, it should tell you a lot about my personality, the fact that I ran against a sitting judge when people told me I was committing career suicide. I recognize the suck-up factor, as you call it, right? Part of the problem with that is now I can't trust what anybody says to me, right? That's not in my inner circle. But I say that to say this. That's why I just err on the side of not doing anything. Because what I also recognize is that people can misinterpret your intentions, your actions, your words, etc. And especially as a judge. So there has also been this adjustment of understanding that people are going to treat me differently because of my title, if that makes sense.
So you would agree that life is full of twists and turns, would you not?
Yes.
And I know that when you made this call, it was during a very emotional and traumatic time in your life. You understand that, right?
Mm-hmm.
Okay, so
Yes.
my question to you is, you know, this is not going to be the only time where you experience a traumatic event, right? And so you have to tell the hearing panel judge, how do you ensure that during one of those other traumatic events that bound to happen, people die, people get in car accidents, I mean, people lose their jobs, all those traumatic events, tell the hearing panel why they should trust you to know that in the event that you are experiencing life's trauma again, that you don't make another call like this.
This is very personal for me, for multiple reasons. I don't think that I can experience a loss like the two that I've already experienced. And candidly, people talking about my strength as I've gone through this process. My grandmother and my mother and I were very close. Thinking about it brings me to tears, which is why I try not. And I'm actively going through the grief process. That being said, I have put in place barriers, boundaries. As you may recall, one of the things I said to you last time was my mother was one of those boundaries. So you had to go through my mother to get to me. Well, at 43, I guess she was 42, I am having to put some of those boundaries in place when it comes to my family in particular. I've had a conversation with my family. Don't tell me about anything. And in fact, there have been things that happened that I learned on the news, right? So they've respected those boundaries. That's one. Number two, I do not surround myself with yes people. My staff, I think they will tell you, they are not yes people, and I encourage them, hey, if you see something going left, if you see me going left, I'm human. We're all humans. Please come pull my coattail, right? Call the phone, do whatever. And that's something that I told them before, right? But I have reiterated that to them because I do understand that folks can feel like, oh, I don't want to say anything to piss you off, or I do understand that, right? So again, I reiterated that to them and said, listen, I don't want you all to be yes people. Like, yes, I am the judge, but at the same time, I'm also human. And if you all see something because I trust your judgment, in the words of Marta, see something, say something. So that's the second thing I put in place. Third, just being more aware and more intentional, period. Like, and it's not to say that I was oblivious before. That's not what I'm saying. But it has been an adjustment. And to take a breath, so to speak, or to take a beat. I'm that person who I try to get things done, be efficient, and all that other kind of stuff. And I've learned in this job that sometimes it's not about just getting it done. It's also about taking the moment and stopping before you act, whatever it is. So even on my bench, I have a little Post-it note. I now sit in Judge Newkirk's courtroom, and he had a Post-it note that I kept that says KYMS.
DMS.
Yeah, it is DMS, you're right. KYDMS. So that note is up there, right? And then I have another note that says stop, right? To just remind you to take a break.
Do I need to put that Post-it note on what is that? I didn't understand. What does that mean?
It might be an internal secret. I don't know.
Okay. Is it the
Keep
judge's?
your damn mouth shut.
Oh.
Correct. Correct.
Do I need to sit down? Obviously,
Well, and I say that for this reason. This is very short. Sometimes trying to do the right thing and trying to help somebody, because we're human, and you see cases come before you. You're not a robot, and you want to say something that you think is helpful or will be helpful. And I've learned that that's not the space that I sit in, and so I can't do that.
Fair enough. I know this has been an emotional time. We've been talking about some sensitive issues surrounding a very difficult time in your life. Do you think, have you sought any grieving treatment or therapy?
Absolutely.
Okay.
The whole time my mom was going through her treatment, I was in counseling.
Okay. Are you still in counseling?
Yep.
All right. I want to next turn, if I may, to the Brandy Alexander.
Okay.
Prior to making the call to Brandy Alexander, Judge, did you know that the case involved her?
Absolutely not.
Okay.
I thought that she was a Gaul. I thought she was calling about a Gaul case.
Once you learned that the case involved Brandy, did you speak to Brandy at all about the substantive merits of her case?
I did not speak to Brandy about the substantive merits of her case before or after learning that she was the litigant.
Okay. Remind the hearing panel again what you discussed with Brandy.
Logistics, that we could not transfer a case to a senior judge, and that because she had cases pending before me and I did not want to impact the integrity of those cases, that I would handle her case on the calendar before me versus the mass calendars.
Okay. As you sit here today, or as you were having the conversation, did you believe any substance of your conversation with Brandy provided her a strategic advantage over the opposing party?
Absolutely not.
During the call that you had with Brandy, did you invite Brandy to contact her lawyer and join the call?
I did. I asked her if she wanted us to contact her lawyer or for her to three-way her lawyer in such that I could explain to her the process.
Let me ask you this. Prior to making that call to Brandy, did you know who Catherine Franklin is?
No, had never met her. In fact, I learned her name on that call.
Okay. And so you didn't know that that was her lawyer at the time?
No, the Post-it note that I got, all it said was Brandy Alexander, senior judge.
Okay.
I didn't even know Miss Alexander lived in Fulton County.
After the call, did you instruct your staff, specifically Janelle Bowles, to inform the parties of your call?
I did.
Okay.
And I specifically told her what to put in the email.
Why did you invite her to call Catherine Franklin, her lawyer?
Again, I didn't see anything nefarious about saying this is the senior judge process. Senior judges cannot be assigned a case. Cases cannot be transferred to a senior judge. In my mind, it was purely logistical. It was not anything about the merits of the case, the substance of the case, etc.
Could the case have been transferred to a senior judge?
No, sir. And I think that that has been borne out by multiple people's testimony. Even when we have folks in Fulton County who have filed some domestic cases, those cases are not handled by senior judges. We transfer them out. And I don't want to say specific names, but I know that to be a fact, not only because I have engaged in the process as a division judge, but also as chief judge. Those were cases that were brought to my attention. And then I would go talk to Chief Judge Glanville about them and have Mr. Semlin go through the process.
You understand that the parties were never contacted about the call that you had with Brandy?
I learned that later, yes.
If I can just have a minute. At some point, did you receive letters of support before and after the May hearing?
The May JQC hearing?
Mhm.
Yes, sir. Before and after, I've received letters of support from the time that folks saw the formal charges, as well as folks who saw this hearing.
What kind of folks? Lawyers, community people?
Both, yes, sir.
And the lawyers that sent you the letters, they were just Give me an example of the letter.
I think Mr. Banks is about to enter them. Some of them did not come to me. Some folks reached out directly to Mr. Banks and Ms. McFadden. Some people did reach out to me, and I would forward those to Mr. Banks and Ms. McFadden. I've had jurors reach out to me and tell me what a great judge I was, and how they're rooting for me and supporting me. I've had folks calling, texting, etc. So it's been a combination, but lawyers, judges, community folks, lay folks. I actually saw somebody in the grocery store who was like, "You were my judge. I saw you on TV. I'm praying for you. I want you to be well and stay on the bench." So all of
These
that.
are lawyers that have appeared before you, I guess.
No, some of them no, some of them yes.
So the lawyers
Well,
that
let me say this: I have not seen the letters, all of them. So I'm only talking about the ones that I actually received.
So how do you handle now, since I guess we're about to see them, the lawyers that appear before you that, or will appear before you that have written these letters? Are you going to recuse on those cases?
Can I see the list before I answer? Okay, I think most of those letters are from domestic lawyers, so they wouldn't be appearing before me. But would I recuse? I don't. Depends on the circumstances.
Mhm.
I mean, I think it depends on the circumstances. I mean, even in this court's order, it said that lawyers have friends who are judges. That doesn't mean that they should necessarily recuse.
I understand. I just asked a question.
Oh, it's a case-by-case basis on everything, sir.
I know Ms. Veal is likely going to object, but I would like to at least identify these letters for the purposes of the record. Let me.
Seven.
R7 will be identified as a letter from Austin Berlin.
So before we read into the record for the hearing panel to hear all these lawyers that have written these letters, I have not agreed to the admissibility of these letters. I told Mr. Banks, I asked him if he was going to add some of these people to his witness list. Some of them are already on there, and that's fine. I understand they can testify, but I do not agree that these letters can just come in for consideration. These people need to come in and testify. And so I would object to naming off the lawyers who have authored them, so the hearing panel hears who the lawyers are, and I object to these being admitted into evidence.
Well, I have a right to identify exhibits that I wanted.
You can identify them, so that's fine. But I am sort of wondering how they're not hearsay.
Sure. Well, let me just say.
I mean, I don't know what they say, so I don't know the content, but
They're certainly hearsay. The rules of the JQC are not altogether clear about what standards apply at these administrative proceedings. And that's just, the rules of evidence don't, I mean, there's nothing in the JQC rules that say, hey, you are bound by the rules of evidence. And so, look, this is akin to a prosecution. She even, her words, not mine, do you understand that I am prosecuting this case against Judge Williams? Letters of support at any sentencing would be appropriate for this court to consider whether the person writing the letter testified or not. And I understand her objection, having said that, to the extent that the rules of evidence don't apply. These are members of the bar that have written letters, and I'm trying to identify those letters as a part of this record that she received to reflect her community support.
okay. Well, identify the letters, and then we can work through the objection a little further. I think let's just identify them for the record first.
R7 is again from a letter from Austin
Berlin.
Berlin, I'm sorry. R8 is a letter from Attorney Williams. R9 is a letter from Susie
Ockleberry.
R10 is a letter from M.A. Jackson. R11, Attorney Louise Wilson, Clark Wilson. R12 is from Paul Forson.
Who is not an attorney.
R13 is a letter from Attorney Tessie Edwards. R14 is a letter from Raya Ray. Those are the letters.
Yes, I have seen all of these letters.
All right, so he wants to you want to tender this?
I do. I move
correct?
for their admission.
Okay, so Ms. Veal, response.
I'll start with JQC Rule 8 provides that the rules of evidence are applicable in our proceedings, but it is the rules that relate to non-jury civil proceedings. So to represent that the rules of evidence may not be applicable to our proceedings is just incorrect. I object, they're hearsay, and I don't think that the judge should be allowed to talk about them, and I am asking that the panel not admit them and not consider them.
What's your response to Mr. Banks's somewhat novel argument that they're not being offered on the allegations, that they're being offered for sentencing purpose? In other words, because we have this sort of weird situation where we don't have a bifurcated, where we have a finding and then we have another hearing on sanctions. It's all kind of mushed into one. So what is your response to his argument that the panel consider it only for the purposes of sanction?
I mean, these are
sentencing?
character letters.
They are.
Correct. Any sentencing hearing I've ever been a part of, again, witnesses were required to come and testify unless there was an agreement that letters could just be admitted and considered by the sentencing judge. So my position would be the same.
Okay.
Yeah, I'm not saying that that's not her experience. My experience is a little different. At most of the sentencing hearings, both on the defense and the prosecution side, it is very commonplace for witnesses to write letters and to be there in support of their family and or friends and or the victim, and in fact to have, in some instances, if the district attorney's office or solicitor's office has it, allow a victim witness advocate read the letter to the court.
But that is completely different because that comes in as a victim impact type statement under the Victim's Bill of Rights type situation. I mean, I agree with you. I do think you're right. As a matter of practice, both sides will have letters in lieu of calling witnesses, and typically will do it by agreement. But I think that the reason it happens is precisely that, by agreement, just to sort of shortcut the process so you don't have 25 or 30 witnesses coming in to testify. But
And Judge,
Exactly what we're trying to do.
yeah.
If the hearing panel is going to permit them to do it, then I would like to be able to come up with some letters to present to the hearing panel in aggravation of punishment, since I don't have to bring all those witnesses. And I'll get those
What's your
together
response to that, Mr.
to present
Banks?
to the hearing panel.
Well, I will say the one letter was written on September 3rd, 2024, but the remaining letters actually are from individuals who, after the first proceeding, decided to write letters of support on behalf of Judge Williams. And so, to the extent that these occurred and were received post the ending of discovery, I mean, I didn't solicit these letters from lawyers. I mean, they started to appear in my inbox, and I provided them to the JQC under the Rule 22D in order to supplement discovery.
Sure.
And so, look, I could supplement the witness list, and then the hearing panel's discretion, I could say, hey, these witnesses have contacted me and want to support Judge Williams. I'd like to supplement the witness list and put them in the stand and call them as witnesses. For the purposes of time, however, I just thought it would be more appropriate to introduce the letters.
Well, what's your response, though, to Ms. Veal's suggestion that sort of a goose gander argument?
Yeah, you're keeping me on track. I mean,
can
I
she
guess I answered like Judge
turn
Williams
around-
answered.
Can she turn around and say, we've gotten 52 letters since the last hearing of people who have their own stories they want to tell that we think that the hearing panel should hear too? Are you guys okay with that?
Well, it's different for the JQC to now go on a campaign and try to elicit.
I'm not talking about illicit, I'm talking about they received in their email, just like you said, they showed up in your box. If that had happened, would you be okay with them submitting all the emailed letters they may have hypothetically gotten in their inbox since the
We've
last
got to be
hearing?
concerned of a precedent. These proceedings are so rare, as you know.
They
Right.
are. Fair enough. And I think the question is fair. I mean, I don't really know how to respond to it, to be quite frank. I can understand the point. Having said that, I do think it's important to at least mark them and identify them for the record. I think it's important to know that we haven't gone on some letter campaign asking for people to come
Oh,
in
sure.
and support. And so the way it's happened now, if the JQC intends to do that and they intend to supplement the record based upon reaching out to certain people, I would have a definitive problem with that. So-
Okay. All right. Well, based on what I've heard, and I know the rules to be, you've marked them, they're identified. I'm not going to admit them into evidence over your objection. I understand that. So I will note that for the
Okay,
record.
thank you.
And I do recognize that may lengthen our time together, but that's okay.
Okay.
Go ahead.
If I may, Judge, have members of the community been here in support of you during these proceedings?
Yes, yesterday and today.
Okay. And,
Members of the community and the bar.
okay. What about members of the bench?
Yes.
Are you a good judge?
Yes.
Not perfect?
Not perfect.
All right.
I'm a good judge who tries to get it right, who tries to do the right thing at all times, who is not infallible, but who strives to be a better judge every single day with every single case.
You understand and appreciate that.
Hold on, you sound like you're wrapping up and there's a question that you haven't asked me yet. And I'm sorry to interrupt and hijack your props, but,
Okay.
I mean, your direct, but
Yeah. Well, what question didn't I ask you, Judge?
the children piece?
Oh, I sure didn't. So you heard Brittany Green, your staff attorney, talk about you closing the courtroom or restricting certain kids from your courtroom. Can you explain that?
I have never banned a child from the courtroom. What I have said is when folks are getting into sensitive testimony, I have asked the lawyers to come up and ask them if they wanted the children present in the courtroom. Sometimes it's about felonious or adulterous conduct of the parties. Sometimes, especially in felony cases, the kids are in there and they're about to go into sexual conduct, or they're about to play a video of somebody being murdered or shot. And so in that case, I will call the lawyers up. The lawyers make the decision to remove the children. I just wave the flag and say, hey, is this something you want to
Is
do?
that children of the parties or children?
Across the board, depending on the type of situation.
What is the specific authority for you to do that? Even I'm a grandfather, so I understand, I empathize with that, but we have to follow the law. And I'm not familiar with any law that allows you to do that.
I didn't say I specifically said I don't ban the children. What I said was I will say to the lawyers, because oftentimes the lawyers are not paying attention to who's in the back. That's one of the benefits of sitting in the front. You can see everybody that's in
You
there.
said you were going to ask the lawyers if they want the children in there.
Pardon?
You
I said what
you-
I do is I bring the the lawyers up to the bench, or I have a sidebar or whatever the case may be, and I say to them, hey, there are children back there. Do you want them? I do not express an opinion one way or the other. I just say, I understand you're about to go into this. I understand that. Do you want them in the courtroom for that? I am not aware of any authority that says that that is against the rules to say, hey, just want to make sure you know that those children are back there.
And then what if they say, no, I don't want them in here?
Then they say it. Oh, no, I don't want them in here.
Uh-huh.
Then they have the children leave out. I don't. If they say that they are fine with
Okay.
the children being in there, the children stay in.
So you've advocated your control of the courtroom to some lawyers to violate clear precedent from the U.S. Supreme Court.
These are their clients' children, sir.
I asked you any children or just the party's children, you said any children.
I was giving you the gambit because I also talked about the criminal and civil cases as well as the domestic cases. I have never ever told a lawyer to take a child outside unless they were a witness. I have never ever banned a child from the courtroom. Never ever done any of that.
Sounds like you're just alerting the parties or the lawyers to the fact that there's about to be some maybe
Correct.
not child appropriate stuff
Correct.
coming so that they can govern themselves accordingly, whatever that means for them.
Correct.
And if they don't choose to excuse the child, even if it's something wholly inappropriate for a child to see, you're not kicking that child out of the courtroom.
Correct.
Is that
And in
right?
fact, in my last murder trial, the defendant's children were there for every single day of the trial, and the video was
Okay.
played of the defendant shooting the victim, and the children were in. My point in telling you that is that the children were in there the entirety of the hearing. I mean, the trial. Excuse me.
Okay, I've just heard 3 or 4 different answers, but go ahead.
What's your next question, Mr. Bates?
If I can just have a moment,
Sure.
Hey, Judge, I want to, and very briefly, can I move now and wrap this up to
Yes, sir.
your service in the community beyond your public service as a judge? Are you a member of a church here in Fulton County?
Yes, sir. I am.
And what
I'm in
church do you attend?
Impact United Methodist Church.
Okay. And
In fact, my pastors were here yesterday.
sure. We know from your earlier testimony that you're a member of Delta Sigma Theta Sorority Incorporated.
I am.
Do you actively participate in that sorority?
Yes, sir.
Okay. What about any other organizations that you are involved in here in the community?
I'm a member of numerous voluntary bar associations. I'm also a member of numerous community organizations. I volunteer with several different organizations in the community, to include WAVE, which is We All Value Excellence. It's a nonprofit for at-risk children. I bring kids into my courtroom by reaching out to schools and ask them if they want to, and they'll bring the kids in sometimes on a Saturday, sometimes during the week, and sit and talk with the kids. I show them, tell them about the system. I also,
You participate or preside over any mock trial proceedings?
oh, yes, mock trial, a slew of things. Easter egg hunts, you name it, I do it. I'm on lots of different committees at my church. So I'm on the care team. I'm on the, I'm a worship facilitator. So I do multiple things at the church too.
All right. Those are my questions.
Okay. Ms. Veal, I'm assuming you probably have a fair amount of questions on cross. Is that
Correct.
correct? Okay. And I know I have a few questions I'm going to want to ask, and probably the panel members. So to try to keep us on time schedule, why don't we just go ahead and break for lunch now, and we'll start back at 1 o'clock, okay?
Mr. Banks, will you have a lot of witnesses after the judge? 3.
3? Thank you. All right, we'll see everybody back at 1 o'clock then. Thank you. Ready? Ready? Mr. Banks? Okay, I think we can start, Mike. All right, go ahead.
All right, Judge Williams, good afternoon.
Good afternoon.
I want to start off by touching just briefly on your experience that you went through extensively earlier.
Ms. Phil, I don't mean to interrupt you. I can't really hear you.
Okay, I'm going to start off touching on some of your experience that you went through extensively earlier.
Yes, ma'am.
When you came to Georgia, how many years did you have as a civil litigation, and then how many years did you have in criminal prosecution?
Approximately total, or you want me to break it down?
Total years civil when you came to Georgia.
Approximately 1 year.
Okay. And then total years in criminal prosecution when you came to Georgia.
Approximately 3 years.
Okay. And then I believe you testified that at the time you ran for judge, you had about 10 years total in prosecution, correct?
Approximately, yes, ma'am.
Okay, so you would have gotten the remaining 7 years in prosecution here in Georgia.
Yes, ma'am.
Okay. And then, all right, so your last job in prosecution was at the DeKalb County DA's office, correct?
Yes, ma'am.
All right. You were in Fulton for a shorter amount of time than you were in DeKalb.
Yes, ma'am, by a matter of months.
Okay. Did you just have a better opportunity in the DeKalb County DA's office? Is that why you left Fulton?
No. Well, yes and no. That's not why I left Fulton. I wouldn't say it was a better opportunity. Certainly it was more money, but that's not why I left Fulton.
Okay. So when you left Fulton, you were in the homicide division, correct?
Yes, ma'am. Major case.
Okay. And then you went into, I don't know, was it CWAC or Crimes Against Women and Children in DeKalb?
No, ma'am.
Children's?
No, ma'am. I went into the trial division.
Okay.
DeKalb structure is different than Fulton. So in DeKalb, the trial division handles everything up to a murder except for specialty cases.
Who was the DA in DeKalb then, Judge?
DA Robert James.
All right. So so you got a pay increase. You were in major case in Fulton, and you got a pay increase to go over to DeKalb to do trial division work.
Yes.
Okay. And you said in part it was a better opportunity. What was the other reason?
So I left the Fulton County DA's office because I had a dispute with the then DA over a case. And so I decided that it was a good time for me to leave and go to the DeKalb DA's office. Well, I got an offer, I should say, from the DeKalb DA's office. I wasn't even interviewing. They reached out to me.
Okay. And the dispute that you had was with former District Attorney Paul Howard, and it was about whether or not to proceed on the prosecution of a homicide case, correct?
Put very simply, yes.
Your opinion was that the case should not be prosecuted or that the evidence was not sufficient to proceed, correct?
So it was a co-defendant case. So for one of the co-defendants, that was the case. That was a person who was not involved in the shooting, who was sitting in the back seat of the car or the truck or whatever. It was a PT Cruiser, rather. And so after the shooting had taken place, as the car was speeding away, that young man who was about 17, 18 years old stuck his arm out of the car, reached upward based on all of the witness testimonies, and shot 3 shots in the air. But this is after the actual shooting. That young man was also charged with murder. I had a disagreement as to whether or not that should have been charged as murder and whether or not it should proceed to trial as murder. Mr. Howard and I disagreed, and so I left because for me it was very clear. The case subsequently went to trial, and the jury found the person not guilty of murder, that particular guy. The other defendant was found guilty of murder.
Okay.
And the cases were severed, so that was part of the issue.
When you were in family division, I know you have a lot of prosecutorial experience. Did you, on occasion, when you began your court calendars, did you let everybody know about your prosecutorial experience?
Say that for me again?
When you would, you know how judges sometimes they come out, they get on the bench and they do a little speech before they call through the calendar and court
Okay.
gets started. You would do those speeches occasionally, correct?
I had a preamble, yes,
Okay.
ma'am.
And was part of that explaining that you were a former prosecutor?
Not regularly. If I said that, it was based on something related to either something somebody said to me or something going on.
Okay. You wouldn't announce to calendars and attorneys that are there waiting for the cases to be called that you were a former sex crimes prosecutor and that you had experience in interviewing children and those kind of things?
Oh, that's different. That's not that was not part of the preamble.
Oh.
When folks would ask me about talking to children, I would give them my background so that they could make an informed decision about whether or not they wanted me to do it in camera. I would tell them essentially that I worked in CWAC, that I was child first certified, and I would give them the procedure for how I did in cameras so that they can make the informed decision about if they wanted me to do one or not. But that was not a regular announcement, no ma'am.
But
Okay.
would you agree there's nothing inappropriate for you to do that, or you shouldn't have done?
No, sir, I don't agree there was anything inappropriate. I don't believe there was anything inappropriate. It just was not a part of my regular preamble.
Okay. I know that in Ms. Dennis's matter, the hearing panel has a transcript where you pretty extensively talk about your background and your family as you are interacting with her. Was that something that you did frequently, talk about your family and your family relationships to people that came before you?
I wouldn't say frequently, I would say occasionally if there was something in the case, because I always had this thought process that I didn't want people to think I was sitting high and judging low, so to speak. And so I would tell people, listen, I understand, and here's some of the experience I'm coming from to help them also orient not only my experience but my decision. And again, that's part of that, as Judge Russell used to say, when you try to help people, that's when you start going wrong. So that's the thought process with that.
Have you changed how much that you talk about your personal relationships and your background?
Yes.
Do you do that any longer?
It depends on the circumstances, but I don't do it as frequently. I also saw family court as a little bit different than regular criminal civil court, and in my mind, it was more social work involved than with regular criminal and civil court.
All right, we heard from two witnesses yesterday who you had tell us about your lack of furnishings in your chambers when you took office. Isn't it true that each of the Superior Court judges in Fulton has a furniture budget?
No.
That's not true?
We don't have a furniture budget. We have a budget that we can use for various things. I actually have the pictures over there. Mr. Banks opted not to introduce them, but it wasn't that it was sparse. It was literally there was nothing in the... He was trying to be concise. I get it. He's streamlining it. I'm not saying anything bad. But it was literally that there was nothing in the office, not even a chair. We went to go get a chair.
Had you gone, I'm interested in that. Had you gone to that office before taking office? Because you got elected in the spring, you took office.
Yes, but not after I was elected. Of course, because I'd been a prosecutor in Fulton, so I knew the previous judge in there. But I know.
I call it, you didn't go measure for drapes. You didn't go say, I'm going to put this picture over here, and I'm going to put Mr. Banks' picture on the wall over here. You didn't kind of size it out?
The day that I went to go look at the space is the day that there was no furniture in there.
Okay.
And so it is not, so I know in other counties it is the custom that when the judge comes in, they buy all new furniture or they get to buy new furniture. I know in DeKalb they have that practice. Well, maybe not in state court.
Judge Lopez.
Maybe not in state court.
Burleson either, right?
But I know in DeKalb Superior Court, they have that option. That is not the case in Fulton. So every chambers is supposed to come furnished. So even if judges come switch out furniture, they're supposed to put the furniture in their chambers into the old chamber, so to speak, so that there's no unfurnished chambers. So I have also moved chambers since I've been at Fulton, and again, that's the rule, the requirement. When I got there that day, there was absolutely no furniture, not even a chair, in my actual office. My staff, because they had previously been there, they had to fight to keep their furniture, and there was actually an altercation prior to me starting that I had to rope court administration in on. And in the vestibule or the lobby area, there was absolutely no furniture. So there's normally a sofa in there and things of that nature. And the reason I know what I testified to is because I also, first of all, some of my colleagues told me, but second of all, I can tell you where the furniture went. It's in certain people's chambers right now. So it's not that it got lost. It was that it was given to those folks. And they came and apologized.
Given to those folks by who?
Judge Reeder.
But that, I thought I understood yesterday, that wasn't Judge Reeder's office, that was Judge Krause's office.
And that's part of the misunderstanding. So Judge Reeder was in 4B as in boy. Judge Krause was in 4C as in Charlie. Once Judge Reeder vacated, because of the seniority issues, whenever somebody leaves, we can change chambers if we like. So Judge Krause moved to to 4B. Yeah. Judge Krause took all of her furniture with her. So the furniture that was in 4B should have been transferred to 4C. It was not, because it was given away prior to the move. So that's why there was no furniture in 4C as in Charlie. Judge Krause kept her furniture.
Which she was, of course, entitled.
Correct. And the rule is that the furniture stays with the chambers. That's the rule.
Isn't that a little presumptuous?
Of me or?
No, well, whoever says that, I don't like that couch, why'd I get inherited somebody's couch? Who knows what?
It's because you have the option, as Ms. Ville just alluded to, you have the option to buy furniture. So for instance, the furniture that is currently in my chambers, and I am now in 4A. So I moved from 4C to 4A when Judge Newkirk retired. All of the furniture that was with Judge Newkirk went to 4C. All of the furniture that was with me came to 4A. There were certain pieces of furniture that I did purchase out of my chamber's budget, but because I had no furniture at the beginning, court administration went into their budget to purchase the furniture. But furniture is supposed to come out of your budget if you want to buy new pieces. But because I didn't have anything, they paid for it out of their budget.
And when you're saying this, the items stay with the chambers, you're using chambers interchangeably with the judge, not the chambers meaning 4B, 4A, 4C.
No, I mean 4B, well, both. Let me say that.
Well,
both.
I mean, if the furniture stays at the chambers, then it sounds like Judge Krause wouldn't have taken all of her.
No, so when I say both, I mean if the judge is no longer on the bench, it's supposed to stay in that space. If the judge is on the bench, that judge takes their furniture with them because they have also purchased it out of their budget.
I see.
Did you understand that the furniture, at least some of the furniture that Judge Reeder had been given to her by another judge?
It had not. It was furniture that she purchased.
How would you have known that?
People
Just
told
curious.
me, and I can tell you where some of it is,
Okay,
including the artwork, etc. Like there was not even artwork on the walls.
okay.
And when I say people, to be clear, I mean other judges and staff, because there were some of the judges who came and apologized to me because they said they didn't know. The television was taken off the wall and given to a particular person. Televisions go with judges, not staff members. So some of the staff members actually went and repossessed that television from that particular person and carried it back to me because they said, hey, this is where it was, here it's back to you.
Okay, so there's money in the budget for you to get some new furniture, correct? You had a computer, right?
The first day I did have a computer and a laptop, yes.
Great. You had a courtroom, right?
Yes.
Wonderful. After you won the election, you actually went and observed Judge Reeder in court, correct?
No,
You didn't do that?
did not.
Okay. Did she offer that to you?
I don't remember talking to Judge Reeder until right before she was about to leave. And I don't believe she was having court then, so I don't recall that.
Do you recall her sending you the Superior Court judge's winter training conference materials so that you could look over them?
No. I'm not saying that didn't happen. I don't recall that, though.
Do you recall when Judge Reeder dispersed her campaign funds when she was leaving office? Do you recall that some of those funds she gave to you?
Yes, she gave them to, I think, everybody on the bench, but certainly multiple folks on the bench.
How much?
I think it was $500. I think it was less than 1,000. Let me say that.
Do you have any reason to dispute the fact that it was $750 if I told you that was the amount?
Again, I don't remember. I know it was less than 1,000.
There's nothing wrong with that, though, right?
Nope.
It happens all the time.
Yep. And she also left me a very a note. So it was a note saying good luck on my tenure.
I want to make sure the hearing panel very clearly understands. There's been a lot of talk about the fact that you were a new judge and you were put onto the family law division, and there's been a suggestion that perhaps that is abnormal or it hadn't happened before it happened to you. It is true that not every time that a new judge joins the Fulton County Superior Court bench, there is an opening on the family law division, correct?
Say that for me again.
It is true that not every time that a new judge joins the Fulton County Superior Court bench that there is at that time an opening in the family division.
I don't know. What I do know is, to my knowledge, no one has come in and gone straight to the family division. What I also know is that judges in the family division can come out early. In fact, Judge Reeder came out early. Went in early because Judge Brasher came out early. So I don't know about openings at the time someone comes on. I can't answer that question.
Terms are supposed to be 2 years, correct?
Yes, ma'am.
Okay. And generally, judges that go into the family law division will serve at least that first 2-year term. Is that fair?
Yes.
Okay. Do you know whether Belinda Edwards went straight to the family law division?
She did not.
And what happened with Alice Benton, who was recently appointed to the Fulton County Superior Court bench?
She wanted to go into the family division. However, there was not an opening at that time, and nobody was willing to come out. So she went straight to general civil, and general jurisdiction. Excuse me, not general civil. And she is now in the family law division because it was her turn to go in.
You agree with what Mr. Summerlin testified to yesterday, which was that the rule for who goes into the family law division when there is an opening in that division is that the most senior and the most junior judges will go in if nobody volunteers, correct?
Correct.
We've spent a lot of time talking about the caseload you inherited, and I don't think anybody disagrees with the fact that it was a large caseload, and it was larger than any of the other family division caseloads. But you would agree with me, and so, I'm sorry, Judge Farmer went into the family division. He was the judge that went in immediately before you, correct?
No,
Who went in immediately before you?
I don't know. Judge Farmer and I started on the same day.
Okay. So you would agree with me that Judge Farmer was senior to you in terms of being on the Fulton County Superior Court bench, right?
Yes.
You would agree with me that any judge looking at these case numbers, if presented with, all right, we've got an opening in family 1 and we've got 501 pending, we've got an opening in family 3 and 636 pending, any judge would select the 501 caseload, correct?
No.
Who would select the one that is 130 cases higher?
Well, sometimes judges will select the caseload based on who the previous judge was because they know how that judge managed their docket. So, yeah.
Okay, so it is your testimony that there is a judge out there that would have been like, you know what, yeah, I'm going to pick the one with 130 more cases.
That's not what I said. What I said was there are, and this is the case, it's not my assumption. I know that there is a judge who selected a particular docket because of who the previous judge was, and they knew, and this is in Fulton County, and they knew how that previous judge ran their docket, managed their docket, et cetera. So though that person had more cases, certainly their thought process was that that judge's docket was probably better maintained despite the number. And the same thing has happened since I've gone into civil. Like Judge Farmer and I came out of criminal at the same time. Judge Adams, who has one of the lowest dockets on the criminal civil division, Judge Farmer opted to take her docket, and then I got Judge Benton / Judge Eaton's docket, which is historically Judge LaGrua's docket.
You testified earlier that when you were talking about getting rid of Ms. Bowles, you testified that there was somebody else that you had to let go in August of 2022 from your staff?
Yes.
Who was that person?
My former JA.
Is that also known as a
Judicial assistant, my apologies.
secretary?
Yes. You asked me not to use acronyms. I apologize. Yes.
How many JAs have you had since you've been on the Fulton County Superior Court bench?
I am on my 4th one.
So 3rd staff attorney and 4th JA?
Yes.
Is that a lot or a little for the Atlanta Circuit turnover?
It's on par. I can tell you about some of my colleagues who came on. Okay. What I was about to say is that there are other of my colleagues who are in the same exact position, if not having more.
When you were in the family division, how many different judicial officers did you have?
3.
And do you hire those directly?
The judicial officers, yes, sir.
Do you know what they're paid?
$500 a day. And they just got a raise last year to $650 a day.
Kind of like a senior judge.
Correct, but our senior judges make more, yes, sir. So my second JO left to go back into private practice. So that's why he left.
Is that a finite term that they serve, or is it that they
No.
can re-up, or how does that work?
So what happens is they sit in designation for the elected judge for as long as the elected judge says. So every couple of months, I believe it's 2 months, we have to do new designation orders. And I want to correct myself. I said it was a House bill. That's what we were trying to get through a couple of years ago. It's actually that it was approved, it being the JO position, was approved by way of the Supreme Court, and it is a local rule. But I'm trying to work on getting that for you, but it wasn't a House bill.
They have
The
a
House
copy
bill
of them.
one applies to the state court judicial officers.
And the
In
panel
Fulton
has
County.
Yes, yes, sir.
the panel has a copy of the local rules. We provided those.
We do, yeah.
All right. Not that we need to spend more time talking about sealing, but I want to be clear.
Talking about what now?
Sealing,
Oh,
the
sealing,
sealing of
okay.
cases, records. I want to be clear, in your exchange with Mr. Hyde earlier, what you said was that you had never sealed a case. So I want to be clear, have you ever sealed individual documents within a case?
Yes.
Okay. And have you, when you have sealed individual documents, What is the process for doing that you followed?
Depends on the type of document. There are some documents that just as a matter of course are put under seal. If it's something that the parties request to be filed under seal, depending on what the document is, my process is that they have to send it to me directly, unredacted, so that I can review the document. And this is generally after a motion and after a consent motion in general. If it's not a consent motion, then it just goes to a hearing. If it's a consent motion, again, they have to send the documents to me. If I have any questions, then certainly Ms. Green will either send back questions or we'll schedule it for a hearing depending on what's going on.
Okay. Ms. Bowles is the one who raised the issue about sealing cases. And to your knowledge, did Ms. Bowles seal any cases?
No, ma'am,
when
she
was
did not.
employed with you?
That's why I said I think she was confused because there were two cases that my predecessor had sealed. And so I think those are what she was talking about. For instance, even when she was talking about child abuse, I don't separate child abuse cases. I think she was talking about a particular case that was sealed wherein the child was going through gender reassignment surgery and the parents were fighting over that and the child was 11 years old. That case was sealed, but it was sealed by my predecessor.
All right, the delayed orders, there's just a few things that I want to touch on. And so Mr. Banks asked you about the first time you got notice from the investigative panel about the delayed orders in cases, and that was in July of 2023, correct?
Yes, ma'am.
All right, and we have referenced that notice a few times. You all talked about it earlier, and so what I would like to do at this point is tender a copy of that notice into evidence, and I've marked it P11.
Any objection to P11, Mr. Banks? All right, in.
All right, Judge, I know there's not any possible way for you to remember the cases that were contained in this notice.
Actually, I have my copy of it. Can Mr. Banks give it to me? If it's okay.
I don't have an issue with that.
It's the one with the letters, is that?
If you need to step off and show him, that's fine. If it's
Is that
easier for
okay?
you to locate it, yeah,
Okay.
that's fine.
Get that straight there.
That's the oddest one. That's the oddest one.
Yeah.
Correct.
Just start putting inscription on it now.
I'm going to ask you about the one from January 9th. It's 24, but it says 23 on it. No. All right, so the July 20th, 2023 notice from the investigative panel, you would agree with me, it lists out 11 different cases in this notice. You want to count through them?
Yes, ma'am. Yes, ma'am, to the 11th. Thanks.
All right, and as part of this notice, you were asked to respond in writing, correct?
Last page, yes, ma'am.
All right, and you did respond in writing through Mr. Banks.
Yes, ma'am.
In your response, you provided some explanation about the cases that were contained in that notice, and then you, together with Mr. Banks, identified several of the cases that you would be entering orders in within, I believe the response was the close of business next week. So essentially, you represented to the panel that you would be entering orders in August of 2023. Do you recall that?
I recall the letter. I don't recall what the date was.
Okay. Would it help to refresh your recollection to look over that response letter?
Yes, please. I didn't bring that one up here with me. It's on the table, though. Thank you. What page? Oh, okay. Yes, ma'am. Says by close of business next week.
And your response to the investigative panel was dated August 11th of 2023?
Yes, ma'am.
Okay. And among the cases that you indicated in your response, you would enter orders in, Slate versus Green was included, Alan Miller versus Lori Miller, James Klein versus Penelope Klein, Michael Thompson versus Nadia Hawk, Corey Ritter versus Helen Lopez, Grace Diffley versus Thomas Moore, and Juliet Cullen versus Alan Storch. Does that sound accurate?
Yes, ma'am.
Okay. All right, so that is August 11th of 2023. Did you complete all of the orders that you represented that you would have done in August of 2023? Did you complete them at that time?
Not all of them. So Miller versus Miller was entered on 8/3/2003. Klein versus Klein, which was a 28-page order as far as the base order, and then 3 other orders. That was entered on September 29th, 2023. Diffley versus Moore was entered on December the 3rd, 2024. What was the other one you said? Cologne? I don't have the date for Cologne, but I do recall entering an order on that and then entering a recusal.
Okay, and the panel, I know there's a lot of dates here, and I'm not going to walk through all of them specifically, but you have admitted the delayed decision, both the allegations contained in the formal charges and then the charges, at least the 2.2 violations related to those, correct?
Yes, ma'am.
Okay, so you have admitted that to the dates that are outlined in the formal charges.
Yes, ma'am.
Okay. You, after your response in August of 2023, the investigative panel sent you follow-up correspondence because there were still some outstanding orders that had not been entered, correct?
That was January 2024? Is that what you're talking about?
Yes, ma'am.
Yes, ma'am.
All right, so I'm showing you that notice and I would note, and I've marked this P12, I would note that the date at the top is January 9th of 2023, but this was in fact sent to you in January of 2024, correct?
January of 2024, yes.
Okay. All right, and so in the follow-up notice that was sent in January of 2024, that notice identified 4 cases in which you had represented that you would enter orders in August of 2023, but you had not by January of 2024, correct?
Yes, because one of those cases had to have a hearing, so that was the reason for one of those. And another case was the one I distilled from 130 plus pages to 26 pages.
Who sets the hearings? Does the clerk do that, or do you,
It depends on what type of hearing. If
on
it's
this case?
me.
And who decides if they're gonna have a 30 or 135 page order?
The lawyers.
So the lawyers write the orders.
Those were proposed orders that were submitted.
So
So-
on these, the lawyers had written proposed order, yet they still didn't get out for months after you were notified?
Not all of them, no, sir. I was specifically talking about Ritter versus Lopez. So not all of these had a proposed orders, no, sir.
Which
And-
one is the one that you said still had a hearing that needed to happen?
Green versus Green.
It is,
A case in 2020.
but here, but in Green versus Green, my understanding was that a final hearing had already happened, and they were waiting on that. And then because they were waiting on that order, they ended up filing a motion for an emergency hearing. And is that the hearing you're saying hadn't happened yet?
Correct, because we had not received a courtesy copy pursuant to local rule 6.1, so we didn't even know that that existed.
But I guess what I'm getting at is we can agree that at the time, whoever the lawyers were in Green versus Green filed that emergency motion that you're talking about that you either got or didn't get, the 90 days had already
Yes, ma'am.
run. That's what triggered them filing that pleading, right?
I wouldn't say that's what triggered them filing that pleading based on the pleading, but yes, the 90
They'd already
days.
had their final hearing. They were just waiting on an order.
Correct, which was
Okay.
the same, if not substantially similar to the temporary they were operating on. So I discovered the emergency hearing when I got the notice and looked at the case and had them schedule it, them being the staff.
So I guess my question is, like on counts like that, and I think those are the counts that were still sort of outstanding on the directed verdict that we talked about last time. I mean, if I have my final hearing in front of you, and on day 91 I still don't have a final order, and we all agree if someone files a motion that necessitates an evidentiary hearing, it sort of restarts the time clock, right? I mean, is it really fair to say I didn't violate those counts, or I'm not guilty of those counts because they happened to file a motion that asked for an evidentiary hearing, when the fact is the harm of the final order not being entered within 90 days had already happened? Does that make sense what I'm asking?
Yes, ma'am. Candidly, I don't know what counts those are, so I don't know if we admitted or did not admit those.
Well, I thought I understood on the directed verdict motions, aside from the Brandy Alexander credibility issues, that the reason why y'all were making a directed verdict on those counts was because those had motions outstanding that at some point in the motion asked for an evidentiary hearing or temporary hearing or whatever. But if you look at the record as a whole, those folks had already had final hearings and were just awaiting final orders. It was the lack of a final order that seems like it eventually led to these other motions.
No,
being filed.
in this specific case, they would have had to file a new case because of what the emergency hearing requested asked for, because of the nature of that. But what I'm saying is, I don't know what counts those were, so I can't tell you if I admitted or did not admit them because I don't have it in front of me.
It's count 7 in the 24 set of charges.
Candidly, that's a question for Ms. McFadden and Mr. Banks.
She did not admit.
Okay, that's what I was gonna say. I don't know. I don't have it in front of me.
Okay. But I mean, we can all agree that whether or not they filed some other motion later, as far as the violation of the statute and the timeliness of a final order, that had already happened by the time they filed whatever this other motion was.
The order was not entered within 90 days. I can't say if that's a 1.1, 2.2, so that's the reason I didn't address the statute part.
Gotcha. Okay.
All right, so I understand that you're saying that on Green versus Green, you did not enter the order as you indicated you would in your response to the initial notice, because according to you, there was a hearing that had to happen, correct?
Okay, yes, ma'am.
That was not explained in your August response to the investigative panel's notice, correct?
I don't know. If you hand me my copy, I apologize. You're asking me specifics, and I just don't recall. It should be the one that says Banks Weaver. Thank you. Yes, ma'am. Okay, what's your question, Ms. Bill?
There was no information or explanation given in your response to the investigative panel's notice that, hey, the hang-up on Green versus Green is that I still have to have a hearing? Correct?
Hold on one second. What page is that on?
Well, it's not anywhere, but
Oh, okay. If it's not in here, then no.
It's not in there because you didn't write it, correct?
Correct, I didn't write this. I did not write nor cause it to be authored.
well, did you review it before it was submitted to the investigative panel?
I'm sure it did.
Would you have had Mr. Banks submit a response to a JQC complaint without first reviewing that response?
No, that's why I said I'm sure it did.
Okay.
We had multiple drafts going back, so that's why I said I answered the way I did.
All right, so we've talked about Green versus Green. The second one, Thompson versus Hawk.
Mm-hmm.
Is that the one that you were referencing that had a 130-page proposed order?
No, ma'am, that would be Ritter versus Lopez. Thompson versus Hawk did not have an order. One of the parties was pro se, the other one was not. I actually reached out and asked for a proposed order on that one. And then Mr. Beaudry submitted the proposed order. I edited the proposed order and got it filed. And that was a 7-page, his order was not 7 pages, but it was a 7-page order plus the child support addendum and child support worksheet.
So you represented in your written response through Mr. Banks that you would have these orders done in August of 23. They weren't done. What did you do to prioritize the orders in these cases getting done at that point?
Are you talking about the 11 or the ones in the January letter? Because
The one-
only 4 are remaining as of January. I've
Right.
done 7.
Right.
Okay.
The 4 that were remaining when the investigative panel had to send you another notice
Gotcha.
because you hadn't done them. What did you do at that time to prioritize getting them done?
In January, I did them. Like, so I canceled some other stuff and did them. So, Thompson versus Hawk, that one was filed January the 18th. Ritter versus Lopez, that one was filed January the 19th. Diffley versus Moore was filed January the 18th. Yeah.
So it sounds like they were all, you got them done pretty quickly after we wrote you again. So what were you doing on these cases between August and January?
Candidly, some of them were already done, but when my mom died, I was out for a period of time. And so, they had just not made it to the filing space.
Can your JO do any of these?
No, because they didn't hear the case. You said J.O., right? No, sir, they
So
couldn't.
you have to hear the case.
They would have to hear the case,
It's not a
correct?
transcript.
Correct.
So if
Correct.
you get hit by a bread truck, the JO can't, that case has to start over completely.
Correct. And candidly, unless the parties agree to another, and I did have this situation happen when I took over a caseload, unless the parties agree that the judge shall review the transcript, that they didn't preside over the hearing and enter a ruling based on that. There were several hearings that I had to redo. Let me say it that way.
Ones that you inherited from
Correct.
the previous judge?
Correct.
Gotcha.
All right, at the time you submitted your response to the initial notice, so when you sent the response in August of 23, Ms. Green, your current staff attorney, would have been working with you by that time, correct?
Yes.
Okay.
But I didn't involve Ms. Green in any of this. And one of these cases was hers.
So you didn't think when you were dealing with whichever family issue was going on at the time, you didn't think, with the exception of the one that she had represented the party in previously, you didn't think, hey, let me get her help because the JQC has already written me once about these cases?
No, because I had her working on other things
Okay.
that I was trying to also triage.
Can you see how it looks like you just kind of blew off the investigative panel?
I can see how one would take that thought process, but I think not to put Ms. McFadden on the spot, but I think context is key. There's a lot going on during this time, including a I was still in trial. I was still actively doing my job.
But you get a letter from the one body in the state that regulates your conduct, and there are months and months that go by before most judges I know, after 21 years, they get a letter like that, they cease all other work and they get those cases out right then.
And I did for some of them, but these were the ones that were remaining. That's why I said I got
understand
7
that.
done in the first one, and some of these were cases that I had to recreate / request proposed orders / actually draft orders.
That's a risk every judge that has a case takes every day, though.
I don't disagree with you.
I'm struggling to see, I need to be convinced that this doesn't happen again.
It hasn't happened. This is 2020. This is January 2024. I don't have any outstanding orders. Have not had any outstanding orders. In fact, as I stated earlier, my oldest outstanding order that is ripe right now is 2 weeks old, and in part, candidly, that's because I was in a jury trial, and then I came straight to this week preparing for this hearing. But please believe, next week, I'm presiding all week. That order will go out next week.
All right, Judge, you have come into the hearing. I know that on day 1, there was a document that was prepared that set forth the counts that you admitted to, and that document related to the delayed decision cases. But there's also been some mention by your attorneys, though we've not gotten this on the record from you, that there are some other things that you admit to. And so I think that needs to be clear for the panel. Is my recollection correct that you all have represented that there are other things that you admit to?
I think so. I don't know. I think so. I don't know what you all discussed specifically versus otherwise, because you all worked on the stipulation. So I think so.
Okay. So I'm not talking about any of the delayed decision cases.
Okay.
Okay. So outside of the delayed decision cases, so let's start with the Brandy Alexander, the formal charges, the 24 formal charges, the, if we will, Brandy Alexander complaint. Do you admit to any of the violations of the Code of Judicial Conduct that are alleged in relation to that complaint? And that would be counts 1 through 6?
Paragraph number 101.
Correct.
Thank you.
I don't have the formal charges in front of me, so I can't answer that question. Nor do I have the stipulation in front of me.
So for the record, the only written stipulation that has been presented to me and the only one that I agreed to was the one on the delayed cases.
Right, that's my recollection as well.
Which is what count? Just what count?
The failures to rule.
Okay.
They started at 7, I think, in the first one. Sure, yeah.
Can you bring me the yellow sheet that I was studied? Okay, thank you. I appreciate you. Thank you, sir. All right, I'm ready.
All right. You have the formal charges from the 24 case in front of you?
I have both of them in front of me. Yes,
Okay.
ma'am.
Let's start at page 26 of the 24 charges, paragraph 101. All right, that's count 1, and again, this relates to the phone call with Miss Alexander. You were charged with violating Code of Judicial Conduct Rule 1.2a in relation to that call. Do you admit to that count?
I take exception to the language in the count, but it looks like we've admitted to it.
When you say,
Looks like we admitted to it. I don't know what that means.
We
Did-
being-
Did all of us admit to that?
No, my lawyer, sir.
Okay, but you're admitting to it.
Yes.
Okay.
But I'm talking about the document, so that's why I'm saying it looks like, because I'm referencing the document, the stipulation.
But in
As
your
well as the
answer,
complaint.
you affirmatively denied it and required strict proof, I guess, as
Correct.
opposed to just proof.
But that's why I also said I take exception to the language. I did not schedule it differently than other cases. There are other cases that I've scheduled in this way. And then again, at the time, my recollection and my directive was for Ms. Bowles to notify. I learned that she did not. And I did not know about the petitioner's inquiry about why, et cetera.
okay,
So you're
I-
asking me about the answer versus today. So I guess that's where
The answer I'm not worried about,
Okay.
but I'm confused because I also had a note to myself that you admitted count one in its entirety from our previous
Correct.
dates. But what I thought I heard you just do is sort of walk that back and say that you don't exactly admit to it. I
No.
mean, I guess my question is, do you admit to count one in its entirety or not?
I take exception to the scheduling it differently than other cases, but as a whole, so I guess admit in part, but admit, yes. I didn't schedule it differently than other cases, but I admit it.
you admit that you violated Rule 1.2A of the Code of Judicial Conduct in the manner that count one alleges. Yes or no?
I said yes.
And I'm not talking about admit with explanation, and I'm not talking about an offered plea. Admit as alleged.
Well, this is not a criminal proceeding. I mean,
It-
come on.
Yes, I understand, and it's not, but it is sort of, it seems to be, we admit, but then we want to say, but this sentence doesn't apply, or this set of facts doesn't apply. I mean, either, and if she doesn't want to fully admit count one and the allegations contained therein, that is okay. I mean, that's what the hearing's for. But I mean, it is sort of a yes or no question without explanation. Do you or do you not admit count
And
one?
all of that is fair game, but what she's not accused of doing is committing crime.
I agree.
So that's what I take issue with.
I agree with that, and I'm not sure that's helpful commentary at all anyway, but I understand the director's desire to nail down, because
I said yes, Judge.
Okay,
Now,
so you-
I didn't mean to interrupt you.
so
But
you
yes.
admit count one in its entirety,
That's right.
as drafted? Okay.
Yes, ma'am.
All right, and Judge, you've referenced the stipulation document you have up there. Has that been presented to the hearing panel, or what is the document that you're reading from regarding stipulations?
It says stipulations and admissions to formal charges.
Okay.
Yeah, I don't think I've ever seen that.
Well, I might be able to clear it up if I may.
Sure.
So we agreed to certain stipulations at the outset, and then during the first phase of this, we agreed to certain other stipulations. So we have updated our stipulations. We haven't had a chance to communicate with the director's office about the updated stipulations, but we're clear on what they are based on the transcript. So we do have the amended and updated list of stipulations.
So it sounds like if the director continues down the path of sort of ticking through the counts, Judge Williams ought to be able to easily sort of say yes, no, yes, no.
Yes, ma'am. That's why I asked for my notes.
Okay, got it.
All right, so I'm now at paragraph 102, count 2. This count alleges that you violated Rule 2.4B of the Code of Judicial Conduct by permitting a relationship to influence your judicial conduct and judgment.
That is not admitted.
All right, count 3 alleges that you violated the Code of Judicial Conduct Rule 2.9A, which is the rule prohibiting ex parte communications. By having that phone conversation with Ms. Alexander, do you admit count 3?
I take issue with the wording, but I admit the conduct.
If I may, Your Honor, this is new territory for JQC proceeding, the admissions in the middle of trial. And I guess I need to know whether or not the hearing panel is going to treat that statement as an admission of this count, because it's alleged the way that it's alleged.
And I'll say this is not today. This was admitted on the first day. What we did was we went back through the transcript, because if you recall, the very first day there was a stipulation. They had some handwritings on it and some additions. So the panel asked for everybody to submit an updated one.
Sure.
This is that document.
No, I have, again, in my own notes, that you admitted count 3. I think where it's just starting to get fuzzy is it is the taking exception with wording.
Okay, I said I admit it. So do I take exception to the wording? Yes, but I admit the conduct.
So you admit count 3 in its entirety then?
Correct.
Okay.
All right, paragraph 104, count 4. I know that count is denied. Is that correct?
Counts 4 through 7 are denied.
Okay. All right, I'm going to move to the formal charges, the 25 formal charges, and I'm at paragraph 70 there.
7-0.
Correct.
17.
Counts 70 through 72 are admitted. Or excuse me, paragraphs 70 through 72 are admitted, which are counts 1, 2, and 3.
Okay. So as to count 1, paragraph 70, you admitted that you violated the law when you had Miss Dennis arrested and thrown in the holding cell, correct?
Well, what law is she saying she violated?
Well, the way that this is alleged is disregarding Georgia constitutional provisions when you had her taken from the courtroom and detained. So I'm wanting to ensure that you agree with the way that it's alleged.
All right.
Are you talking to me?
Yes.
Oh, I'm sorry. I thought you were still talking to Commissioner Hyde. You want to make sure that I am agreeing with the way it's alleged, or that I'm admitting the conduct? I've admitted the conduct. Is that what you're asking?
Do you admit that you have violated the Code of Judicial Conduct Rule 1.1 in the manner that it is alleged in count 1?
Correct. You said the law. That's not what this reads. So that's what I was correcting.
The constitutional provisions aren't the law?
You used the word law, and to Commissioner Hyde's point, that's not what that said. That said constitutional provisions. Okay.
I was asking because I don't know.
I understand.
All right, you admit count 2?
Correct.
And count 3, which alleges a violation of Rule 2.8B.
Correct, that was based on Molly's testimony. Certainly, I didn't yell, scream, or anything like that, but given her presentation that she felt like it wasn't courteous, certainly, yes, I admit that.
Okay. I'm moving to paragraph 73, which is going to relate to the complaint regarding your uncle's case and Ms. Stenson.
I believe counts 3 through 6 are denied.
All right, I thought we just talked about count
Excuse
3.
me, 4 through 6. You said
Okay.
73, and so 3 was in my head.
Okay.
4 through 6.
So even though you testified pretty extensively earlier about recognizing that the phone call was wrong, you deny that any of that conduct related to that phone call violated the Code of Judicial Conduct.
I don't have Rule 1.2B in front of me, but it looks like whatever the denial was based on that, or the paragraphs. I can't answer that specifically without having that in front of me.
All right, so the Rule 1.2B is contained in count 4, failed to maintain and enforce high standards of conduct and failed to personally observe such standards of conduct so that the independence, integrity, and impartiality of the judiciary is preserved.
Hold on. Let me go to paragraph 17 through 24 and read 17 through 20. Hold on. 17 through 27 and read those. It may have been a factual dispute. I'm not sure. Hold on. I believe that was because some of the language, but I would need to confer with my lawyers to confirm that.
Okay.
I admit to the call, I admit to the conduct. I believe it was some of the language, but again, I'm not sure, so I need to confer with them.
But, I mean, you would know if you admit to the facts or not, right? I mean, it doesn't really matter
I
to me
sit-
why you deny it. I mean, you're denying those counts, right?
No, as I sit here, I don't recall the conversation we had and why that was not a part of the stipulation, and I don't want to answer out of turn because it might have been because of something within that statute, which I don't, not statute, because of that rule that I don't have before me, and I don't remember candidly what the conversation was, so I don't want to admit out of turn.
But how do you admit something out of turn when, this is personally about, the person who's in the best position to know whether they admit to the conduct or the facts or the counts or not would be you, right?
I don't have Rule 1.2B in front of me.
I've got it if you need to look at it.
Yes, ma'am, to say that part. With regard to, and I don't recall why we did or did not admit that, which is why I said I would need to confer with counsel because I don't recall the rationale. Certainly, I can. If you want me to go paragraph by paragraph, I can certainly do that.
Well, it's important for us to know what you admit, what you're admitting to.
I agree.
I believe it is.
Uh-huh.
Can we have 5 minutes? We think we might be able to short circuit something.
Sure. Give me 1 minute though, because I want to show her the one thing that she was asking about.
Okay, I've read the rule. Thank you.
Sure.
Are we still taking the 5 minutes, or do you want me to answer?
If you can answer the question as best you can, and then if we need 5 minutes to try to clarify.
Do
that's
I
fine.
admit the violation of the rule? I think so, yes. Do I admit the paragraphs, the allegations as alleged in the paragraph? Some of them yes, some of them no, which is why I said I can go paragraph by paragraph if you
What
prefer.
paragraph number?
17 through 27.
I just don't recall, which is why I wanted to talk to them about what the rationale was, because I'm looking at the stipulation. So that's what I'm saying.
And for the record, I have not, there's been no stipulation or agreement. I understand they came in
They
and
have a
say,
draft, I
hey,
gotcha.
we admit this, but I just want that to be clear.
Well, so to Ms. McFadden's point, rather than just talking to Judge Williams, why don't all of y'all talk? And if y'all can nail down those stipulations, I don't mind giving y'all 5 or 10 minutes to just nail it down, and then we don't have to go count by count. If y'all, I mean, talk to your client and then talk to each other, and it may be that y'all can just zip through all of this and get a better understanding of being on the same page. So we'll take a 10-minute recess to give y'all a chance to do that. Thank you. right? Ms. McFadden, Ms. Beal?
So, we have worked through stipulations on the 24 set of formal charges
Okay.
that include her admitting to certain counts and admitting to certain paragraphs. That one's out of the way. But on the 25 set of formal charges, we have not completed working through that set. We were going to ask to speak to the panel about navigating that. I told Ms. McFadden that I don't know that I have to agree or stipulate. Again, the space that we're in, there's not guidance in the rules for this particular issue. My thought would be ultimately if Judge Williams wants to admit, any count and tell the hearing panel, I admit this count as alleged, it would be up to the hearing panel to make a finding about whether or not it's actually been admitted. Again, I don't know that I have to agree, but the issue that we're having is in the 25 set of charges, the way I alleged each of the counts was to relate back to the paragraphs
Right.
in the charge. And so in order to admit the count in the 25
She has to
set,
admit the underlying factual assertions. I got you.
And that's the problem that we're having, consistent with Judge Williams' testimony about disputing some of the language in the paragraphs that support the counts, how we do that with having her admit generally to a violation of the rules, but not the specific language. Because there are a few allegations in each of the paragraphs that maybe one sentence of the allegation is agreed to, but the other two are not. And so what we're wondering, why we want to talk with you all, is what would be satisfactory. I don't think we disagree about what needs to happen. We just want to figure out how to accomplish it in a way that works.
Well, I mean, I'll invite the other panel members to chime in and disagree, but the way I see it is the director and the JQC investigative panel has elected to draw their formal charges in a particular manner, alleging certain factual allegations that go with those charges. And then it's up to the judge, having read those charges and answered those charges, to either admit them or deny them. I don't know that there's a way to sort of admit a rule, but not this fact, but admit this fact. I mean, I don't know that you can pick and choose. That just gets really messy, and that's fine if she don't want to admit to all the facts. Then I don't think that counts as a whole admission. I mean, I don't know that there's an easy or a neat way for you guys to say, okay, on this she admits to everything but paragraph 18 of 17 through 27, and she admits to the rule violation. She can just say whatever she wants to say about those counts, and then we'll sift through. Maybe I'm just thinking about that wrongheadedly, but to me, it's either you're admitting to the allegations as charged and drawn, or you're not, and we just take it from there. I don't know. I mean, what do y'all think?
What's the civil rule on this?
Sorry.
So in the civil world, we could not dispute the allegations for purposes of agreeing or accepting or admitting to the counts. We just don't dispute. We don't agree with them. We don't admit the allegations, but we just don't dispute them for these purposes.
Well, there's no other purposes going on right now, are there?
No, we don't dispute them. We don't dispute the specific allegations for the purpose of admitting to the rule violation. So we were trying to work on something that would allow for Judge Williams to admit to the count, but not admit to the allegations in the paragraphs as alleged, not dispute them.
because the problem is some of her testimony now would be contrary to
Right.
her now coming and saying, well, I admit this paragraph. She can't, based on the testimony and the evidence, the way that it's come out.
Right.
If I may, too. So I think a part of the problem is the challenge that we're having on behalf of Judge Williams is simply that there are some allegations in the factual component of the complaint that we do dispute. and that, in fact, the witnesses that they put up on the stand have, I mean, literally, they should dispute it too. They should be agreeing with us on certain facts. And so we just don't want, frankly, the judge not to get the benefit of accepting responsibility when, she is doing that. I mean, from day one, she has admitted to conduct. And so when there are paragraphs that are referenced in the counts that essentially the count references paragraph going back to paragraph 17 through 27. Well, if certain paragraphs 17 through 27 are not something that we can agree to, it's not to say that we're not admitting to the violation of the rule. It is to say, however, the facts are a little bit different based upon the testimony that's been elicited, not just from us, but also from the JQC.
But do you guys agree, and I don't know if you've gotten this granular with it, but I mean, for example, a criminal defendant could plead guilty and admit a factual basis for a plea and not necessarily agree with every single fact in the case. I mean, in other words, they could say that the material facts that matter for supporting the charge, they agree exist and agree that the law was violated. Do you guys think you could get to the point where even if you didn't agree with every single fact, that you all could get to the point of agreeing that whatever the material facts are that support the violation of whatever particular rule, that those facts are true and accurate, and therefore the rule was violated?
This is my frustration. It's just not true that she's admitted since day one. Like, she has come into this hearing and admitted, we talked about the delayed rulings in advance, and we had an agreement on those, the paragraphs, the counts, but then she came here, and after testimony happened, then she's like, I admit. And now the position I'm in is, I understand they're trying to work something out, and we're trying to make this easy for the hearing panel, but this is not neat based on the way that it's happened.
It isn't.
And I'm not comfortable going back and even despite her testimony to the contrary, putting something in writing that she admits this paragraph when there's clear sworn testimony that is different.
Well, I'll just say this. She was the first witness that the JQC called. And she did fall on the sword about allegations complaining in the form of charges. And so she has globally come in and accepted responsibility for the conduct that she can accept responsibility for. But to sit here and say that we're going to admit that Brandy Alexander was telling the truth about certain things, we are not. And we should not. And so you have to understand, I mean, it is messy. And I get it, and I get the hearing panel's concern, I get the JQC's concern, arguably. Having said that, on behalf of Judge Williams, she shouldn't be punished for the JQC alleging certain facts that are not true. And by way of example, Janelle Bowles wasn't even talked to, and statements are attributed to her.
I think you mean Tangi Bush. Janelle was talked to like 5 times, I thought
Whoa,
she said.
5 times immediately before this trial,
Okay.
before the charges were filed. She is named in this complaint. They had not talked to her. The initial inquiry came in February of 2022. The formal complaint was filed on June 6th of 2024.
Mm-hmm.
They had 2 years to talk to Janelle Bowles, who they attributed statements to. And ultimately, they didn't do that. And so we can't, in good faith, come up and just say, oh, just because the JQC has referenced it in account and attributed it to certain paragraphs that are not factually accurate, that we agree to it in the sense that we agree with those facts. But do we agree in principle and in theory that she's violated certain canons? We do agree with that. We do agree with that, and that is what her testimony has been from day one. And so that is my...
Well, it doesn't sound like you guys have an agreement. So let's continue with the cross-examination. The JQC investigative panel through the director can proceed to prove their case however they see fit, and Judge Williams can defend it however you all see fit to defend it. So continue with your cross.
But y'all did reach agreement as to the 2024 charges, is that right?
That's correct. So
So-
there's no dispute about anything related to the Brandy Alexander complaint at all as far as the counts in the paragraphs.
So this is all 2025 charges?
That's right.
Okay.
Wait
Okay.
a minute, I don't think that's what we're saying. We do, just like, I'm sorry, Judge Burleson. As Mr. Banks just said, we definitely dispute allegations related to the counts related to Brandy Alexander. There is a dispute about those, unless
I
I've
mean, the
heard.
ones that she's saying that she admits.
So maybe we need to be specific about the counts, yeah, in the paragraphs.
Well, I think she was. I think she said that she admitted, I think, 1, 2, 3, and denied 4 through 7 is what I have. So, all right, if you'll proceed with your cross.
Hold on, did I say two?
No, not two.
I didn't say two.
Counts 1 and 3 are admitted.
My apologies, 1 and 3.
All right, Judge Williams, paragraph 73 of the 2025 formal charges, count 4. Do you admit or deny,
I don't have that in front of me. Can someone,
is it up on the screen?
candidly, Ms. Bill, I have in my contacts, and so that screen is difficult to read, which is why I'm asking for a paper copy.
Where's her paper copy that she had?
It's on the table. I only have the first one up there with me. Thank you. Thank you. Okay. Paragraph what now?
I'm at paragraph 73, count 4. And this is the complaint related to your uncle's case. Do you admit or deny violating the Code of Judicial Conduct Rule 1.2A, or I'm sorry, 1.2B, as alleged in paragraphs 17 through 27?
I admit violating the rule. I do not admit all of the conduct alleged in 17 through 27 as worded.
So that's 10 counts that we don't know, or at least I don't know what you're saying you do or don't.
10 paragraphs, sir? Is that what you're talking about?
Yes, ma'am,
17
sorry.
through 27?
10 paragraphs.
Oh, wait, did you say count 4? Again, I admit the conduct. I guess my understanding of civil practice is a little bit different. Like, you can admit in part and deny in part. So I'm a little bit unclear, but I'm admitting the conduct. I'm admitting the rule violation. I am not admitting certain things as alleged in the complaint. That's what I'm saying. I don't know how to put it.
Well, paragraph 17 is one sentence.
Correct. That's why I said I'm not admitting to all of the paragraphs as alleged. That's 10 separate paragraphs, and some of these are are written with compound sentences. So paragraph 17, yes. Paragraph 18, that's not my recollection, but to me that's 6 1/2 dozen. So that's not something that I quibble about. Paragraph 19, yes, I've now learned that. Paragraph 20.
You admitted that in your answer,
Yes.
20.
Again, I don't know about the 40 minutes, but I'm not quibbling about that. So everything else, yes. Paragraph 21.
You admitted in your answer.
Yes. Paragraph 21. Paragraph 22. Yes. Yes. Paragraph 23. So the language is what I take issue with. But again, like I said, I'm not admitting to the violation of the rule. I'm just saying 23 is not, as I recall it happening. Paragraph 24, excuse me. In part, the last line is what I take issue with. Paragraph 25.
So when you say you take issue with it, you explicitly denied saying to Ms. Stenson that you all should work something out in your testimony at the beginning of this hearing in May, correct?
Say again?
You denied saying to Ms. Stenson that the parties should work something out, correct?
Correct. That's not what I said. That's why I said I take issue with the wording.
Okay.
What I said was that if what he's saying is true, they should be able to work something out, which is different than they should work something out. There was a caveat on there, and I know it may not make a distinction to you, but it does to me, which is why I said I take issue with the last sentence and gave explanation. Paragraph 25. That's not my recollection, but I'm not denying it one way or the other. That's just not my recollection. I do recall her saying send an email to her, but again, I'm not quibbling with that. Paragraph 26, we disagree about certain, but in the general, paragraph 26, yes, I'm fine with. Paragraph 27.
Well, let me ask you, did you argue the merits of the case during the phone call?
I don't believe I argued the merits, but which is why I said I'm not quibbling. Did I discuss with her what he told me? Yes. But arguing to me sounds like what I just heard, and that's not what I did.
Would it have mattered either way? If you discussed it, it's inappropriate also, isn't it?
Yes, but sir, I'm talking about the specific language in the charges.
Okay. Well,
So that's
I'll
what
change my copy to discuss.
That's fine, and that would be an accurate assessment of
All
the
right.
facts. 27. Yes. So that's why I said I agree with some of the language as charged.
All right, great. So paragraph 74, count 5, do you admit count 5?
Yes, with the same exceptions I just said for 17 through 27. Or with the same commentary, let me say that.
All right, respondent 6 was a list of some continuing judicial education courses that you have taken.
Mm-hmm. Yes.
You indicated on direct that you have actually taken more than what is displayed on this list, correct?
Yes, ma'am.
How many additional courses?
Right. What's the last one on there?
Hey, Mike. Can you read this?
There you go.
Maybe 2 or 3, I'm not sure. And this is just for the National Judicial College. While I was in the family division, I also took courses with the National Council of Family Law and Juvenile Court Judges. Those are not included on here. Additionally, my transcript from the Council of Superior Court Judges, those classes are not included on here either. And that's for the entirety of my tenure on the bench, not just the last 6 months.
You testified on direct that you were open to taking more continuing judicial education courses. So my question to you is, in what areas do you think you would benefit from additional training?
Across the board. I think that we're all growing vessels. And so, I mean, they don't call it the practice of law for nothing. Every day I learn something new. In fact, some of the things that we specifically discussed in the procedural fairness course, I have experienced and observed while in these proceedings. So I learn something new every day, Ms. Ville.
Is that it?
One of the last things that you talked about was your community involvement, and you specifically mentioned your church membership. Does the leadership and/or the congregation of your church know that you're a judge?
Leadership, yes. Congregation, I can't answer that. Are there some folks who in the congregation know that I'm a judge? Yes, I can't say as a whole. I don't know.
Have you done any, have you given any speeches or talks to the congregation at your church?
Yes.
And during those, did you ask for financial contributions?
No. Wait, are you talking about ever? Let me back that up. I have been at my church for 15 years. During the course of my 15 years, yes.
Okay. When was the last time you spoke and asked for financial contributions for your church?
My recollection is prior to me being a judge. I am a worship facilitator at my church.
All right. That's all I have. Mr. Banks?
All right, you got any questions, Mr. Lopez? What about you?
Nope.
I was about to get up.
I did have just one or two questions. On the failure to rule timely, were any of those on that list in the charges, were those, any of those holdovers from your predecessor, or were those all ones you had heard?
When you say holdovers, do you mean
Meaning-
cases that I had to rehear?
Right.
Let me see.
In other words, a final hearing had been had and an order never entered, and so you inherited and had to kind of pick up wherever it had left off? Or were they all ones you sort of started from scratch on?
Oh, no. All of these cases are, hold on, let me, before I say all. Only 2 of those cases were filed after I took the bench. All of those other cases preceded me.
But did you hear the final hearings in them?
Oh, the final hearings?
Right.
Let's see.
I realize they may have been filed before you took the bench,
Okay,
but in
yes,
other
ma'am.
words, did you hear all the final hearings that
yes.
the orders were due on?
Yes.
You did, okay. Okay, and of the, obviously we heard Ms. Bowles' testimony yesterday and the challenges that she experienced. On that list of cases in the charges, how many of those were ones that had been assigned specifically to Ms. Bowles where she was responsible for the order versus ones I know that you kept to draft yourself?
12 of the 15.
12 of the 15 were,
I directed Ms. Bowles to do the order.
okay. Okay. And then, and this is not a criticism, it's truly a question, but when you I can't remember exactly what your words were, but that there was a time that I think the way you put it was you just had to step away with everything that was going on. At that point, did it ever occur to you to ask for a senior judge to step in and cover for you for a month or two, or go to your chief and just say, look, I'm dealing with these family issues, but I need help? And it sounded like you tried to kind of keep doing it, but did you ever have the thought of asking anyone to step in and help you in any way, or just take over for a month or two so you could just sort of?
I did have a senior judge sitting for me in addition to me. So I was handling, so certainly I handled most of the cases, but I was also having senior judges come in to handle cases too. So both were going on at the same time.
Okay.
And Judge Glanville was very gracious. He, like, if I needed something, he also would help out if I needed something. But, like, sometimes I did hearings from the hospital. So I never canceled court or anything like that. But yes, ma'am, I did have other folks helping me.
Okay. Okay. And then with the uncle, the situation with your uncle, as I understood it, I thought you told us last time that you didn't tell him what to say, that you just had a conversation with him and he sort of took what he took from that and then put it in this email that got sent to the shoemaker firm. But I thought I understood you to say today that you did actually sort of dictate to him what to say. So just trying to understand
Yes, ma'am.
what happened.
So what I said last time was that I did not write the email, which I understand from talking to my lawyers and certainly reading the transcript that I guess the assumption was when I said write that I didn't tell him. And I thought I remembered saying I dictated, I told him what to say. I dictated, I told him what to say. I did not physically type, write, scribe the email.
So it's not like you typed up the email, sent it to him, and then he just forwarded what you wrote to
Correct.
the shoemaker firm.
Correct.
So do you know who would have typed it up for him that caused him to forward it to the shoemaker firm?
He, as I understood it, he and or his wife wrote it. Like, I told him what to write. I told him what to do. I had him read it back to me. So that's what I'm saying. I never denied that the words in the email were words that came from me. That's never been my position. My position.
You told us you didn't write it.
I didn't write, and that's what I meant by that. And then certainly.
But you could have, wouldn't the full answer have been, I didn't write it, however, I directed him to do it, which is ultimately what your testimony was.
I thought I said that.
Okay.
Candidly, I don't have the transcript in front of me to tell you what the exact words were.
But do you know who wrote it for him that then he forwarded?
I thought he wrote it. So if it was forwarded, I don't know.
Well,
I thought he wrote it.
I could be wrong because I'm not the tech geek here, but if we look at the exhibit, which is 31,
May I see it, please?
I have it in my notebook. I don't know if we can put it up on the screen.
No, I mean, I think it's over there, if I'm not mistaken.
Do you have it, Ms. Field, by chance? I can give you my
Put it up on
copy.
the Oscar.
So the way I understand email is if I were to write you an email and then you were to
Oh, you're
receive
talking
my
about the
email
subject?
and forward it to someone else, that FW would pop up. So it looks to me like someone authored an email for him and then he forwarded it on to Ms. Stinson. I'm just wondering, you're saying you didn't write it. Do you know who gave him this language then that you say you're dictating that somebody apparently, I guess, sent to him and then he forwarded it to Miss Stinson?
I gave him the language. I told him what to write. I told him how to format it. I can tell you specifically, I did not write it. I distinctly remember sitting at my grandmother's bedside. I did not have my computer. When they called me and told me that she would not make it through the night, I was at work. I got up and left. I didn't even have my computer. So the only thing I can surmise from this is either he forwarded it to himself. I mean, he wrote it and forwarded it to another email, or his wife wrote it. I don't know. But I did not physically sit down at a computer, type this email.
But if I understand your testimony right now, someone read it back to you over the phone, and so they typed it out and read it to you? Is that what you just said?
Not someone, he.
He.
Yes,
okay.
I told him, and then I think he might have called me back to clarify some things. But again, everything was over the phone. I
But
was
if
not.
I'm just trying to figure out, if he's typing while you're talking, I don't understand the forward piece.
I
That's
don't
where I'm
know if
getting
he was
lost.
typing. That's what I said at the first hearing. I don't know if he was typing or writing. I don't know who drafted this email. Candidly, I have not talked to my uncle about this situation, period, since I got notification of it. So, because I also did not want to be accused of anything else. So, I do not know who typed it. I do not know if it was him, if he was typing on somebody's computer and he had to, I don't know. I don't know if his wife typed it. Like I said, his wife is a school teacher. So, I mean, my uncle's not dumb either. So I can't answer the logistical questions of who typed it.
Well, I guess just to clarify Judge Burleson's concern, it sounds like you drafted it, you may have dictated it, but the word, you said the words are yours, they just took them down, and someone read it to you, and you, I guess, okayed it before it was sent. Is that a fair assessment?
For the most part, yes.
Okay.
So, some of the things in that email I didn't say, but for the most part, yes.
But it was read to you,
Correct.
and you
Correct.
sort of okayed it.
Correct. But that's not, I don't know when it was sent. Let me say that. So,
That's fair.
Okay. And then last question. Did I understand you to say, I know you didn't remember whether Judge Reeder gave you the notes from the winter conference or whatever, or the book. You didn't remember that?
I don't
That didn't
remember.
happen, or you don't remember?
I don't remember. That's why I said I
Okay.
can't say one of it.
But you said she gave you a campaign contribution, I guess from her campaign, and then also, I guess, left you kind of a nice note of just good luck in your position or something like that. So, I mean, setting aside the furniture issue, which we've sort of gone through, I'm trying to understand, because if I understand sort of the theory of your case, you sort of have felt like because of Judge Reeder losing, you were targeted. But I mean,
I didn't.
it sounds to me like when she left, she sort of left on a classy note by giving you a campaign contribution and giving you a nice sort of wish you well note. And so I'm trying to understand why that put you in the position of feeling like a
Understood.
target was on your back when she sounds like she kind of left in a pretty classy, respectful way.
The only piece that I've ever said or attributed to Judge Reeder is the furniture piece. Have people told me things that she said and things that she did? Yes, but I didn't say those things, and that's not that's not my position. So when I'm talking about the target, it is political retaliation for running against an incumbent, and people have said that, for running against an incumbent, unseating an incumbent. It is retaliation against the family, from the family law bar. They were soliciting folks to file complaints against me. So that's another piece. It was, there are so many things that go into that. Other judges who were involved. So notice, I never said, when I was talking about the stuff that has happened since I've been on the bench, other than the furniture piece, I never attributed any of that stuff to former Judge Reeder. I said that there were other judges and members of the family bar who were behind those things. I will tell you another example. Not like every single time. There were multiple occasions where the JQC, by way of the director, somebody would call them directly. My attorney would get a call. I would then get a call saying, oh, well, so-and-so is saying that you did X, Y, Z, i.e. you didn't grant their paternity leave. Well, the rule is 17.1, and they didn't comply with the rule. They were not even on the case when the case got set. Every single time that I got that call, my attorney would have to call me, and it was the director making those calls, Director Veal, to my attorney, just because an attorney would call and say things like that. These were family law attorneys.
What
There
would
was
you
one.
have had her do?
I don't think that it was the director's place to call and tell me that I had to grant or I needed to grant somebody's leave when it was in violation of the rule. Second of all, One of which was the gentleman kept calling my office for a hearing that wasn't for another month or so. They told him I was not available. He then calls the director. The director calls my lawyer and goes off, and I don't know, let me not say goes off. They have whatever conversation they have. My lawyer then calls me and tells me the situation. And literally his words starting were, "I apologize for calling you. I know your mother just died." This was the week that we buried my mother. And the lawyers knew that. And they were still calling saying, well, we need an answer, we need this, and then calling the JQC, and then the director would call my lawyer. Now, I'm not saying Ms. Veal knew that my mother had literally just died less than a month before, but it was widely known. In addition to that, with these charges, they have been posting stuff in their blogs about me, like literally, and when I say me, I mean these charges. My face has been plastered all over the news, not like other judges who have had these types of hearings. Literally, this was on Channel 2, and I know that because I don't watch the news, but people call me, like people who are not involved in the law. And there's been this just targeted attack, targeted attempt to discredit me, to slander me, to shame me, to harass me, etc. So again, I did not say and have not said that former Judge Reeder was behind that. There are some actions that I know people have told me about with different folks, but I didn't even say that.
Okay. Do you feel like, and understand, we don't make our decision on anything that may have been on the news or any of that. I don't read any of those blogs or anything like that. We're making our decision based on the evidence presented here. So I understand what you're saying about what's going on sort of out there. Do you feel like any of the charges that have been brought in the first set of charges or the second set of charges that we've been dealing with, that you've been unfairly targeted in these charges being brought?
Yes, from the standpoint of literally, and I understand the director's position. From day one, I've tried to take responsibility. I don't know what she's talking about as far as a public reprimand, because I would have taken it. I have spent so much money on this. Again, all the media stuff I just said and everything else that's going on in my world. I would love to close this out so I can just focus on being a judge, so I can focus on being a good judge. And being a better judge, becoming a better judge.
But do you feel that it was unfair?
Yes, because removal. I'm sorry.
I'm not talking about the resolution. The lack of y'all being able to have a meeting of the minds about the sanction. I'm just saying, do you feel that you were unfairly targeted in these charges being brought at all?
Brandy Alexander, yes.
Okay.
The rest of them, no.
Okay. Thank you.
Thank you.
You got anything else? Anything else? Anybody want to ask
Sorry.
any follow-up?
Yeah.
Okay, go ahead.
There was a lot about me in there. So, you said that the family law bar, you said they were actively soliciting people to file complaints against me. Who is they?
The family law bar.
Who in the family law bar?
Various people.
What are their names?
Well, one is William Alexander, the person you kept calling whenever he called you by way of Mr. Banks. My understanding is Kyla Lyons was part of that, and there were several other people who, again, this is what people told me. I was not directly involved in those conversations. I'm just telling you what people told me. And then apparently, again, they keep posting stuff in their blogs about me and telling people about this.
Who's they and who's
the
there?
family
I
law
don't
folks.
know.
Some of them post anonymously and post things like things to the extent of, okay, so we're watching this. Here's the next install on Judge Williams and things like that. So there has absolutely been a targeted attempt, a target attack, excuse me.
But those didn't end up in the charges.
I don't know.
As far as we know. I mean,
I don't know. I don't know. Some of these charges, I don't know. Let me rephrase that. Some in the discovery, some of these charges don't have a complaint. Some of them are brought by the director based on information received by her. So I don't know
But
where
isn't
they.
that the process?
It's a complaint, I thought.
And the director's a
No, I
complainant.
mean versus folks who actually file there's a form called a complaint. That's
I'm
what
aware,
talking
but
about.
why does that matter?
You asked me about solicit. If Judge Burleson asked me if some of those complaints made it to the formal charges. What I said is I don't know, because I don't know if those folks were solicited or not.
No, but you said the director added charges that were not complained in somebody filing a complaint.
Correct?
And I asked, why does that matter?
Because she doesn't tell us where they come from.
Is that a requirement?
In fairness, I would think so, because you don't even have the opportunity to confront your accuser. So as a matter of fairness, I would think so.
What if the complaint is not, what if it's a confidential complaint or an anonymous complaint?
Okay, then you don't, if it's anonymous, you don't know who it came from. If it's confidential, people will say stuff is confidential. That doesn't mean it is. I just don't know. That's my point. And if we're talking about a process that is supposed to be transparent and fair, because my understanding, and call me naive, my understanding of the purpose of the JQC investigation panel is to investigate, right, certain things. The purpose of the hearing panel is when folks can't come to a resolution for the hearing panel to make a decision. As I told you all on day one, I'm not here because I'm not admitting to violations. I'm here because the only offer that has been made to me and conveyed to me is removal. I do not believe that any of the sanction or any of the conduct in the formal charges, either set, amounts to removal.
What do you think it amounts to now that we're kind of at the end and you've admitted more stuff as we've gone along? What do you think is the appropriate sanction if you're sitting in our chairs?
If I'm sitting in your chair, I would look and say, you know what, this is somewhat, in my mind, removal is for folks who have not redeemed themselves, who are not redeemable, who are bad judges. There are some folks who don't need to be on the bench. I do not believe I'm one of those people. In fact, I know y'all aren't going to read the letters, but several of those. So for me, if I'm sitting in your position, I would say I'm going to give her a public reprimand, even though clearly this has been publicized everywhere. So functionally, I've already had that, right? So I would give her a public reprimand, and I know my attorneys are over there cringing, but my request would be in lieu of a suspension, in that I have been paying my legal fees, and they are not cheap. Mr. Banks and Ms. McFadden are not cheap. In my humble opinion, the purpose of a suspension is to impute a financial penalty to the judge. Well, I've endured that financial penalty. I do believe that a long suspension would hurt the citizens of Fulton County. We have a voluminous docket. And so to say we're going to suspend her for 3, 6 months, whatever the case may be, that's going to cause a lot of problems.
But last month you said you wanted the director to reimburse you for your fees.
You asked me about the answer, sir, and I was responding to that question. And what I said was,
that.
yes, sure. But Judge Burleson just asked me if I was sitting in y'all's seat right now.
Right.
So I'm answering the question present day as of right now. So certainly I would not remove me, because I don't think that's appropriate, nor do I think it's warranted. I would give me a public reprimand, and if you did a suspension, then I would not do more than a 30-day suspension, because again, I've already had a financial penalty, which is part of what I understand to be part of the reason for the suspension. Now, I would ask, in lieu of suspension, pay my own fees, which I've been doing. And my last name is not Kardashian. I didn't come from money, so it absolutely is a financial sacrifice for me.
Well, you made the choice to hire two very good, high-priced lawyers, though.
I did.
Yeah.
And as I tell lawyers litigants who come before me all the time, certainly it's your choice if you want a Rolls-Royce lawyer or a Toyota lawyer. They're both good cars, but it's your choice. I went with the Rolls-Royce. If I'm fighting for my job, again, because removal is the only thing that's been offered to me, I have to fight.
But that's not the only option we have.
Right, that's why I said what's been offered to me, not you all.
Well, that's irrelevant right now.
Oh, okay.
Whatever they offered you is absolutely irrelevant.
Well then, yes, sir.
Judge Burleson asked you what you thought the appropriate sanctions should be, and
You've answered. Thank you.
you said several things. Yeah.
Concisely, Commissioner Hyde, public reprimand, because a private reprimand gets out the bag, right? That doesn't even make sense. Public reprimand and the financial penalty, which is tantamount to a fine, so to speak. And if you are not inclined to do that, then a 30-day suspension.
Okay.
Do you understand that the JQC's rules require me, they say shall when the director comes into possession of information that would constitute a violation of the code, if true, the director shall conduct an investigation? Do you understand that?
I understand that, and I also know that there are other things that have come to your attention that have not risen to that level.
Okay.
Can we take this down, please? I'm trying to focus on you, and it's in my peripheral.
What are those things?
Well, I certainly testified about some stuff at the very beginning of this hearing. I don't know that anything has been done with that. I've
The
heard
things
other
you didn't report to the JQC.
I'm not going to go tit for tat for you, Ms. Ville. So you keep your commentary to yourself, please. I'm going to
Okay,
answer your question.
we're not going there.
So-
All right, we can stop the examination if we're going to go there. So ask a question, answer. If we need to take a 5-minute cooling off break, that's fine too.
What are the things that have been reported to the JQC and not investigated?
The things I reported on the very first day. Also, things that I've seen in other folks' trials that nobody's seen anything happen with, so I don't know if anything has happened with that.
No. My question was, what are the things that have been reported to the JQC that nothing has been done with?
I just answered your question, ma'am. I don't know how otherwise to answer it.
So you said the things that you mentioned during the trial, which were about Judge Schwall, that's number one, correct?
That's one of them, yes.
Okay. Who is the other one that you believe the information that you conveyed, if true, would constitute a violation of the code?
At this point, I mean, look, I understand that there's been some back and forth, but none of this is relevant to what's important here.
That's true, but that's really not, we didn't open this door. So I'm going to let you ask a question and then let's just put this to bed. Go ahead.
Who is the other judge that you conveyed information that, if true, would constitute a violation of the code?
I'd have to look at the transcript, ma'am. But it's in the transcript, whatever I said the first day.
Is this information you convey to the JQC in the form of a complaint?
Well, no, I'm talking about my testimony. What I understand the rule is if the director comes into knowledge of information, then they have a duty to investigate.
And
That's
you're
what I
saying
understood
something
she asked
that
me
you
about.
said on day one of this hearing
Correct.
in May is something you believe
Got it.
rises to that
Correct.
level. I
Okay.
gotcha. Okay, thank you.
Correct.
What's your next question?
You indicated that Mr. Banks told you that I said that you had to grant somebody's leave?
No.
Okay.
What I said was I don't believe it is the director's role to tell me that I have to grant somebody's leave. What I understood was that you were calling Mr. Banks because Mr. Alexander called you and made a complaint even though he had not followed the rules. And there were times where you did send correspondence through Mr. Bank that I needed to recuse from certain cases. Again, I don't believe that that's appropriate, and nor is that your role.
So,
And you sent even follow-up emails for other attorneys in that firm saying, well, these attorneys, their cases need to be recused on too. And they would call you, and then you would be the mediator, I guess, or the buffer for whatever reason. I don't think that that's the role of the JQC director.
So, do you understand that oftentimes when myself or a member of my staff makes a phone call to either a judge or a lawyer about a recusal issue or a leave issue, that what we're trying to do is resolve that issue instead of it ending up as part of a formal charge? Do you understand that?
That was not the tenor of what I received. Let me say it that way. Nor was it the email that was forwarded. And when the lawyers would call, they would say the JQC director said. This is what they would say to my staff. Again, I never talked to you, Ms. Ville, so I don't know what your words to those folks were.
Okay, I don't want to cut you all off, interrupt. Does this have anything to do with any of the formal charges that are in front of us? Because if it's not, I'm going to ask y'all to move on, because it's 3:37, and we've been here all day hearing stuff about things that are not in these formal charges. I want to focus on the formal charges and the actual things that have been alleged.
And my term's up next week.
I'm sorry.
just-
It's
It's
about
okay.
me,
I understand
and
what you're
it's-
trying to do, but I mean, we've rehashed a lot of this stuff, and I just want to get to things that are relevant to the charges, or at least stay focused on those things.
You said from day one you've wanted to accept responsibility. Do you think that you and what you came into the investigative panel meeting and said of May of 2022 was indicative of acceptance of responsibility.
Specifically what? I don't recall everything as I sit here right now that was said. But what I do recall is telling you from day one, before I even sat for the interview, when I talked to you on February 14th twice, I specifically recall telling you, yes, I had a conversation with Ms. Alexander. We did not discuss the substance of the case. I told her the process for a senior judge. That's what I recall saying to you from day one. And if I was not trying to cooperate, I would not have even called you.
So you've mentioned that you knew nothing about a public reprimand. You have probably heard me say, and I know I've said it to this panel in a prior version of this panel, that you were always free to come in and argue disposition in this case, meaning admit to the counts, and then we just argue sanction. You understood that that was always an option, correct?
Say that for me again?
You understood that
Are
you
you
could-
talking about before the hearing panel or the IP panel? I wanna make
before
sure
the
I'm clear.
hearing panel. You always understood that you could have come in and all we argue about is sanction,
I thought
correct?
that's what we were doing. There are some things that I disagree with, correct, i.e. the bulk of Brandy Alexander. However, the rest of the things, what I recalling from reading the transcript, we did admit to those things, many of those things on the first day. First, second day.
All right, and the last thing, you testified that you have been paying your attorney's legal fees
Mm-hmm. Yes, ma'am.
to both Ms. McFadden and Mr. Banks?
Yes, ma'am.
Okay.
Mr. Banks, anything for this witness?
Yes, just very quickly. Judge, did you, through your attorney, submit an open records request on the JQC inquiring and asking them to produce information concerning the vote that represented? I got to get the question
Well,
out.
let me hear the whole question first. Go ahead.
Concerning the vote that Representative or Director Veal indicated that the investigative panel took to recommend a public reprimand. Did you do that through the
Yes.
open records request?
Open records and discovery, yes.
Okay. And did at some point the JQC respond to that request?
Yes, I believe it was Wednesday night. Tuesday or Wednesday.
And in the response,
Objection, relevance.
Okay, what's the relevance, Mr. Banks?
well, I don't know why we're trying to hide about certain facts of what transpired, but I mean, have you been provided the date that the investigative panel allegedly made this public reprimand offer?
No, Director Veal specifically said that the Open Records Act did not apply to the JQC and that it was not discoverable.
Wait, there's an objection. What's your objection?
She is repeating something that was sent by me on behalf of the investigative panel in a letter to her counsel, and it's hearsay.
Agreed.
I mean, they don't stand by their letters?
I'm sure they stand by their letters. I'm just going by the rules of evidence, and if it's a letter that you're offering for its truth, then it is an out-of-court statement that you're offering for its truth. It's hearsay unless you got an exception.
Well, these are letters that are made contemporaneous with their scope of work, and so it's a business record almost. But having said that, let me just, did you receive any information from the JQC concerning that vote, Judge?
I did not.
Those are my questions.
Thank you. You can sit.
Thank you.
Thank you. Just watch your step.
Yes, ma'am.
All right, next witness.
Judge Williams called Mike O'Hagan.
Mike O'Hagan.
You said 15? Counsel, can you please raise your right hand? Do you swear or affirm that the information you shall give this hearing panel shall be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Okay, thank you. You may have a seat. Can you please spell and state your name for the record?
Michael, can,
Yeah, if you'll
Wanna pick this
pull,
up?
if you can, yeah,
sure.
bend it to your preference. There you go.
Michael, common spelling, Michael, O'Hagan, O''Hagan.
Okay. Good afternoon.
Good afternoon.
I know you've been here for a while, and I apologize about that. But please tell the members of the panel whether or not you are a member of the Georgia Bar.
I am.
Are you licensed in any other state?
No.
How long have you been a member of the Georgia Bar?
November 2003.
Okay. Can you describe the nature of your practice as it exists today?
Currently, I do domestic relations and criminal law. Criminal law defense, obviously.
Okay. And have you been how long have you been doing criminal law defense and domestic relations?
20 or so years.
Okay. Was there a different aspect of your practice that,
Yeah, when the firm that I first went to did insurance defense, workers' comp, and some general liability.
okay, fair enough. And is your practice specific to a particular county or circuit?
No, I'm out in Beaufort, but I go where the clients come from.
Okay. Do you know Judge Williams?
I do.
When is the first time that you met Judge Williams?
Back in January, I think, of 2014.
Okay. And what were the circumstances, if you will, share with the hearing panel how it came to be that you met Judge Williams back in January of 2014?
Okay. She was an ADA with Fulton. Myself and a friend of mine were defending an individual who had been charged with murder. His cousin was also charged with murder. I don't want to get too much into the facts, but our client could not be or shouldn't be culpable for the murder in any way based upon the facts as they were.
Okay. Was she the prosecutor assigned to the case?
Ultimately, yes. Well, right before it went to trial, yes.
Okay. And what happened? Did she remain the prosecutor on the case?
No.
And are you aware of the facts and circumstances as to why she didn't remain the prosecutor on the case?
She had some ethical concerns that you get a jury messes something up, and this kid, he's 20, would go to jail for murder. And based on the facts, it did not make any sense. Legally, he should not have been, convicted, but also probably charged.
Okay. Do you believe, when you say ethical concerns, did she communicate with you in some way that she did not believe she had facts beyond a reasonable doubt to establish your then client's guilt?
I'm trying to remember back then, to that effect, yes. If I remember right, it was the Sunday before a Monday trial. Because I was down at my trial partner's office down in Fayetteville, doing last, minute things.
And so, did you actually communicate with her about her ethical concerns?
She was my trial partner was the primary, but he and I were sitting, I could hear the phone.
I see.
If I remember this right.
Okay. And at some point, did the then district attorney get involved in that matter?
Yes, we appeared for court the next day.
For trial?
Yes, and it was before Judge Manis, who used to do the backlog.
Stephanie Manis?
Yes.
Okay.
And my trial partner had worked in Fulton County for a period of time, but he was in the backlog section. He had gotten to know Judge Manis very well. And we were sitting there, and Paul Howard himself came into the courtroom.
Okay. Did Judge Williams accompany him?
No, not that I can recall, no.
Okay. Do you know what happened to Judge Williams?
I believe she quit.
Okay. And when Mr. Howard came into the courtroom there with you and your law partner as well as Judge Manis, what happened?
He asked for we had a speedy demand already filed. He asked for,
Objection, hearsay. I'm not sure why this is relevant to what's going on. He can say what his opinion is.
I do sustain the hearsay objection. I'm assuming this is the same case that the judge just spoke about with the PT Cruiser and all of that.
Yes, ma'am.
Is he being offered as a character witness
He
in
is.
this regard? Okay,
He
so
is.
overrule the relevance, but sustain the hearsay.
Okay. Was a continuance granted in that case?
no,
Okay. Did the case go forward?
not that day, no.
Okay. At some point, was the case tried?
Yes, it was re-indicted and then tried sometime a little bit later in the spring.
Okay. And what was the result on behalf of your client?
Not guilty on all of the murder-related charges, guilty on ag assault and several reckless conduct misdemeanor offenses.
Okay. All right. During your scope of work as an attorney who practices both family law and criminal law, have you had an occasion to appear in front of Judge Williams?
The answer is very briefly, and I don't even know if I had filed an entry as a counsel of record. It was if I can explain, it was a custody modification where there were some concerns that there might be a criminal component to it. And since I had some criminal background, I was brought in to assist. The respondent in that case, did end up being charged, and he found somebody different to represent him.
Okay. Do you currently have any active cases before Judge Williams?
I don't have that many Fulton cases. I cannot remember who's assigned what. I don't know why I would, though.
Okay. Have you appeared in front of Judge Williams within the last year or two?
That one case I was just talking about, that all we did more than anything was scheduling and get a guardian.
Okay.
And now, obviously, I've had cases that were hers ultimately, but they were resolved by the judicial officer.
Fair enough. At some point, when she was a prosecutor in DeKalb, did you have any cases with her when she was a prosecutor in DeKalb?
Not that I can recall, no.
Okay. In your 20-plus years of practice as a criminal defense lawyer, have you ever known a prosecutor to quit a job because of ethical concerns?
I have not, no.
At some point, once you found out about the formal charges against Judge Williams, did you write a letter of support on her behalf?
I did.
Okay. May I approach?
You may.
Counsel, I'm handing you what's been marked as Respondent's Exhibit number 15, and ask whether or not you recognize that letter, sir. I'm not John Litter.
Yes, this is the one I drafted. I'm trying to see if there was any language that could explain the murder charge a little bit better, but I don't know that I went into detail with it here. But yes, this is a letter I wrote.
Okay, does it fairly and accurately depict the letter that you sent to her counsel in connection with the formal charges of this case as a letter of support?
Yes.
I move for its submission at this time.
And marked as what?
Respondents 15.
15? Okay. And you do have an objection or you don't have an objection? No objection? Okay, it's in. Thank you.
Do you recall how old Judge Williams was when you first met her back in 2014?
I mean, obviously younger. I think that she was, sorry. And I think that she was I was a little bit older when I went to law school. I think that she had more of a straight path out of college into law school, if I remember right. So by that point, I had 13 years legal experience, and then I had had another job for 5 years prior, so I was very much older than she was.
Did you get the impression from what you understand about her stance concerning the ethical concerns she expressed to you and your law partner that she and Paul Howard bumped heads?
Yes.
Okay. And did you get the impression that she was just starting out, or if not having only started out for a couple of years or a few years, her career as a prosecutor?
She was in like one of the major felony divisions, but that's not uncommon to not have much practice and be in those sections down in Fulton.
Okay. Were you surprised that she took the position she took?
Yes.
And why so?
I just did not. I just did not think that anybody would do something like that. She's an employee of the DA's office. The DA's office is serving the people. Try your case.
Right. Do you believe she did the right thing?
Yeah.
Okay.
And if the panel wants to hear more of the facts, I can tell you. But there's I'm not just bolstering for my client.
Sure. Did it make an impression upon you, given the fact that she was a young prosecutor at the time, to take that position and, in my words, would you agree with, butt heads with the district attorney who had been a long-time incumbent?
Yes.
Okay. Certainly a favorable one?
Oh, sure. Yeah.
Okay. Is there anything that you want to share with the panel concerning Judge Williams, just your thoughts about her general character and fitness to serve on the bench?
I've just always known her to be knowledgeable, to be friendly. I don't know exactly what went on I don't know all of the allegations. I didn't feel like I needed to. But I've just never seen her mean to people, cruel to people, just needlessly.
Right. Are you a Fulton County resident?
No, I live up in Gwinnett.
Okay. Those are my questions. Thank you.
Thank you.
So is she cruel when she needs to be, though? You just said needlessly.
If she needs to, yes. As
Okay.
far as I know, she hasn't been mean to me
Very
so
good.
far.
All right.
Questions of this witness on behalf of the investigative panel?
I just want to be clear, your experience with her is based on something that happened 11 years ago?
Yeah.
Okay, and you have not observed her conduct on the bench, is that correct?
Not as far as trying cases or anything of that. Like I said, the one time we were there, it was more of a schedule. The case was a mess, and we were talking about getting guardians and things like that. I don't know that any actual testimony went on that day.
Okay, I don't have anything further, thank you.
All right, anything else for Mr. O'Hagan?
No.
May we excuse him? All right, thank you, sir. You're free to go. Next witness?
I'm Mark Bryce on behalf of Judge Williams.
Okay.
Good afternoon.
Good afternoon.
We will swear. You can raise your hand. Do you swear or affirm that the testimony that you're about to give is the truth, the whole truth, and nothing but the truth?
I do swear.
Thank you. Would you please state and spell your name for the record?
Mark Bryce, M-A-R-K, B-R-Y-C-E.
Mr. Bryce, are you a member of the Georgia Bar?
I am.
Will you tell the panel about the nature of your practice?
I am a family law practitioner. Been practicing mostly family law for the last 11 years or so. Sorry.
Been practicing mostly family law for the past 11 years?
Yes.
As part of a firm or?
Yeah, I started off as an associate, became a partner in a law firm, and then branched off on my own around 2021, 2022, somewhere in there.
Let me dig right in. At some point, you worked for Judge Williams as a judicial officer. Is that right?
That is correct.
When was that?
That began in January of 2022.
And when did it end?
Around March or April of 2023.
Okay. This panel has had a lot of questions about the work of a judicial officer, and so we're hoping in part you could answer a few questions to help educate us about the work of the judicial officer. First, one question has come up about the statutory authority for the work of the judicial officer. Can you talk to us about that?
Yeah. My understanding is that, and I don't know off the top of my head, but there's in the Georgia Constitution, there's the definition of what a judge is. List out Superior Court judges, state court judges, juvenile court judges, and then there's that last part of that sentence says something to the effect of other judicial officers as may be appointed or something like that. So I think that is part of the legal framework that makes judicial officers possible. And then there's another statute in the chapter dealing with courts. I think it's Title 15 something, which talks about when a Superior Court judge can ask for assistance for help, and provided that the judges in a particular circuit agree, they can ask for temporary help or permanent help. So I think those two provisions in tandem is what allowed for the creation of the family division way back when, in the 90s.
That's what you got? That's the best argument?
That's what I got.
Okay.
Well, thank you for that, Mr. Bryce. Commissioner Burleson asked, who is watching the JO? Who do you report to in your role as a judicial officer?
Okay, ultimately, I reported to Judge Williams. On a day-to-day, though, the person I was interfacing with the most was the litigation manager. How I went about performing the duty, a lot of what happened as a JO happened via Zoom. So many JOs, as I understand it, opted to perform their duties virtually. They'd be wherever they were. I decided to come to the courthouse for the majority of the time. So I was there in the jury room, which was across the hall from chambers. So I'd go in the morning, I'd speak to the litigation manager, she'd have a copy of the calendar for the day. I'd log on, start hearing cases.
Well, explain to the panel what you did. What was the work of the JO? What kind of cases? You said you started hearing cases.
Yeah, so I'm sure y'all know by now, there's a 2-track system because of the volume that happens in Fulton County. Generally speaking, when a case is filed, the cases will come on for a 30-day status conference. The purpose is to keep cases moving. That was the intended purpose. So I would hear 30-day status conferences to see if discovery had been exchanged, if service had been effectuated on the respondent. If those things had happened, the parties may look for direction for the next step. A lot of the times the next step would be ADR, going to mediation. I would do mediation orders. I handled primarily a lot of the pro se litigants and the uncontested divorces and stuff. As time went on, though, I would hear more cases that had lawyers on both sides. So.
And in your work as a JO, how did you interface with Judge Williams?
If I had a question I never wanted to have any decision I made be too disparate from what I thought she would do. So if I had a question about what I should do in a particular case, I would ask her, these are the facts, what do you think about it, what would you do, kind of a thing. So I would interface with her if I had questions about, a particular case, if the facts seem hard or unique. So there's that. When I was finished with my work or hearing cases and maybe I was doing orders or something like that, sometimes I would watch her courtroom on Zoom. Sometimes I would go sit in the courtroom and I would see her in chambers.
Why would you watch Judge Williams?
Because I wanted to see, I wanted to make sure that while I was working for her, our judicial philosophy was aligned, to see how she thought about things and handled cases.
Did Judge Williams provide you any instructions about moving cases along?
Yes. I started working in January. I think prior to the first day, we had a meeting, and I was directed to make sure that for cases for which the case was ripe for disposition, that I had to turn in all orders within 2 weeks of the disposition. I could talk more about that if I'm led to answer that question.
Okay. Any other instructions the judge provided about moving along the cases?
Yeah, sometimes, for instance, on a 30-day status conference, many times the respondent had not been served yet. There's a lot of pro se litigants, they don't know that they have to do that. Or sometimes there were cases where they could not find the respondent and they didn't know how to go about the publication, the service by publication. And there are some people who their philosophy is to just dismiss the case for lack of service. And I remember asking her about that, and she, especially with the pro se litigants, would instruct me to give them an opportunity. Here's the resource that you can access. They had like a free family law clinic where they could ask for legal advice. She told me early on to just direct them there, to give them an opportunity to, do their case.
Instead of just dismissing the case outright?
Correct.
Okay. During your time as Judge Williams, JO, did you also maintain an active family law practice?
Yes, I tried my best.
Okay. Did you do 50-50? About how much of your time was spent on JO work versus your practice?
It was about 50-50. There were some months where it was 60-40.
What circuits mainly did you have your practice in?
I go where the wind blows, sir. Cobb, Fulton, DeKalb, the majority of the metro counties. I had some stuff in Muskogee, had some stuff down in Savannah.
So you're sitting as a judicial officer in Fulton County at the Atlanta Judicial Circuit.
Yes, sir.
Yet you're trying cases and appearing as a lawyer doing domestic practice in the Atlanta Judicial Circuit.
No, sir.
Well, you just said Fulton County.
Oh, so I misspoke. While I was a judicial officer, you're not allowed to practice law.
I'm aware.
Yeah, so I was not trying any cases in
Okay,
Fulton
because
County.
that's what I thought you said.
I'm sorry, I misspoke.
Okay.
So, separate and apart from your work as a judicial officer, you have served as a guardian ad litem?
Yes.
Okay. In which courts have you served as a guardian ad litem?
Fulton, but not while I was in jail. Cobb, DeKalb, Douglas, Clayton, Gwinnett, Paulding.
That's plenty.
Yeah.
Yeah. Have you had ex parte conversations with judges in your work as a guardian ad litem?
If by ex parte you mean a direct conversation between myself and
One-on-one
One-on-one,
conversations? with
yes.
judges? Okay. Was it uncommon?
I wouldn't say it's uncommon. It's not something that happens every day, but it happens.
Okay. So, in your practice, in your family law practice, what has been the scope of your experience in Fulton County while you were not serving as a JO?
I've appeared as a guardian ad litem in Fulton, and I've represented litigants in Fulton.
Do you represent litigants in Fulton now?
Yes, I do.
Have you ever appeared in front of Judge Williams in the representation of litigants?
I have.
About how many times?
Maybe once or twice. Primarily, what I was mainly doing, it just so happened that in front of Judge Williams, for the portions of time that I was not a judicial officer, I appeared as a guardian ad litem in front of her.
Okay. Based on your experience appearing in front of Judge Williams and also working with Judge Williams, what are your impressions of her as a judge?
I think that she's very smart. I think that she is compassionate. I feel my impression of her was that she was very community-minded and community-focused. She wanted to, I think she saw herself as a representative of her community and wanted to do a good job.
What gave you the impression that she saw herself as a representative of her community?
She is from Atlanta, and she's, when she took the bench, she had to have been in her 30s, because when I was there, I remember we celebrated her 40th birthday in the jury room. And so I think that her career in the law progressed quicker than most. And I think that, I know that many of her family and friends, I've seen her while she's on the phone with them, congratulating her during the time when I was there, just expressing their pride and, the fact that she was on the bench. I had occasion to meet her mother on that same birthday thing that we had in the jury room, and her brother, and just in conversation, how she, the concern that she showed for people, especially, everyone, but there were some special moments with a lot of pro se litigants.
It sounds like you've gotten to know Judge Williams pretty well. How did you initially meet her?
I appeared in front of her after she took the bench in 2021 as a guardian, and I think I reached out via email or something and offered to take her out to lunch, and then we had lunch.
Okay. In your work as a family law practitioner, have you experienced delayed rulings? In Fulton County, the rule is 90 days. An order has to be issued within 90 days after the final hearing, just roughly speaking.
Mm-hmm.
Have you experienced getting orders after 90 days had expired?
Anywhere or just Fulton?
We'll talk about Fulton first.
Fulton, yes.
How about in other counties in which you've practiced?
Yes.
Name some of them.
Cobb, Forsyth, DeKalb, Douglas, Clayton.
Okay. Is it a pretty common experience?
Yeah. It's not, I mean, 90 days, yeah. Yes,
Over 90 days.
absolutely.
When you say over 90 days, do you mean like it took 4 or 5 months versus 2 or 3 months? Or do you mean it didn't take 2 or 3 months, it took 2 or 3 years?
Let me give you an example.
Sure.
I tried a case, a 2-day special set, towards the end of 2023. I think we were there like 2 days in September, and then the judge brought us back in the early part of 2023. The judge made an oral pronouncement either January or February, if my memory serves me correctly. I don't have an order yet. Another example, I filed an emergency hearing for a lady who was financially dependent on her spouse in September of 2023. Her house was in danger, so there was a marital asset, hanging in the balance. And we didn't get called in on that emergency matter until March of the next year. I don't want to make a representation that every judge, you're waiting a long time for an order, but it happens. It does happen.
But the ones that, like the one you described, where you've been waiting, it sounds like for 2.5 years, if I have my math right. Is that, do you see that more often than not, or is that sort of the outlier, sort of really, really severe example?
That would be towards the upper limit of what I've seen. I don't think that if we're talking about three months or 4 months versus 5 or 6 months, I think is what the question was.
I'm wondering if what you described, where you said you've had a hearing in 2023 and you still don't have an order, right?
Mm-hmm.
If that's 2.5 years.
It's a long time.
Is that the outlier that you see? The once in every few years something like that happens, or you?
It happens for me. It happens. It's an outlier, but it's not so uncommon for me that it in my career. I've been practicing for about 11 years.
Because I think it shocks our conscience that, especially in a family law case where issues are hanging in the balance with children and money and people are just sort of, their lives are on hold. So it's disturbing to hear from you that it's more common than we thought.
I think part of what I think was happening, if I could just be candid, I think that COVID created special. We all lived through it. So there was a backlog that happened in almost every circuit that I was practicing in during that time. So coming out of COVID 2021, 2022, we all had problems getting hearings, getting orders. Cases might have been heard prior to the judicial emergency, and there were backlogs. I can't say. I don't have knowledge as to what's happening in each individual chambers as to what the reasons are. But there are certain places where, as a family law practitioner, you might be waiting a while for a hearing or an order. You file a motion, there's no ruling. You might, get a rule nisi for 6 months after that. You know what I mean? When in the community of family lawyers, it's known that certain circuits are tougher than others.
In the community of family law attorneys, do you have any opinion, one way or the other, about whether Judge Williams has been attacked by lawyers within the family law community?
I have an opinion.
Will you
Yeah.
share that?
Yeah, I think, I believe that sometimes, and I don't know what it is, to be honest with you all. I think that because of the nature of family law, it's personal, right? And I think that a lot of family law practitioners take on the characteristics of our clients. So there's that dynamic. Also, it's a relatively small community, especially in the metro area. So the people that you see on a case today, you will see them again, you know? The dynamic is there are a lot of, people are friendly with certain cliques of people, and, there's a lot of gossip that happens sometimes and that kind of a thing. So in certain of those circles, I'm aware of, certain attacks on certain judges, not just Judge Williams, but since we're here talking about her, yes, Judge Williams.
Can you share an example or two pertaining to Judge Williams?
Yeah, there's there are certain folks in the community who have made certain posts, for example, on social media that I thought were less than becoming, either on their personal Facebook page or on, group pages. When there are judges who their demeanor or their decorum that they try to impose are outside of the norm, whatever, the consensus of lawyers deem that to be. Some of us, it's not just they, I'm a part of the community, but some of us can say things and do things that feel more personal than professional, in my opinion.
Okay. Did you write a letter on Judge Williams' behalf?
I did.
Okay. Now approach.
This will be marked as R16.
Thanks.
Yes, it's a letter I wrote
It is. What is the date on the document?
September 10th, 2024.
We would ask that this document be admitted into evidence.
Any objection? Sin?
Mr. Bryce, why did you write that letter?
I wrote the letter because Judge Williams asked me to, and I agreed to write the letter because I, wanted to support her. I think these words that I wrote reflect my thoughts about her and the job I think she did at the time I wrote the letter.
Do you think Judge Williams is a good judge?
I do.
From your perspective, what would be the impact if Judge Williams were to be removed from the bench?
I think the citizens of Fulton County would be losing someone who is, I found to be a very conscientious person, somebody who really cares about people and about kids. Most of the time, when I was sitting as a JO, I was in my set up in the jury room, you know, across from chambers. But there were some times where the case called for a hearing in person. That's generally when somebody might or might not be arrested, right? Because failure to pay child support or whatever. The very first time I actually sat in the courtroom to preside over a case, there's something I noticed, and I've not forgotten it. This would have been in 2022 at some time. And I'm going to butcher the quote, but to my recollection, this is what I remember seeing. Judge Williams has all these trinkets on her desk, right? But I do remember that she, in her writing, she wrote herself a sticky note. And the sticky note said something to the effect of, the sword of a parent must never be stained by the blood of their child. And I'd never heard that before, you know. She strikes me and struck me then as somebody who takes it seriously, you know. I think that Fulton County would be losing somebody who cares about people. And somebody told me a long time ago when I first was starting out that, you know, when you're a litigator, when you're a judge, the practice of law is 10% law and it's 90% people. And that's something that I've tried to live by. I might not know all the statutes off the top of my head, but you try to treat people fair and treat people right. And what I've experienced of Judge Williams is nothing short of that. She exceeds that standard, in my opinion.
Thank you. Those are my questions.
Any questions, Ms. Stone?
Good afternoon, Mr. Bryce.
Good afternoon.
I know we've spoken a couple of times, but my name is Alex Stone, and I'm a staff attorney with the investigative panel of the Judicial Qualifications Commission. I have a couple questions about the things you testified to, and then I want to ask you more about your job as a judicial officer, okay?
Okay.
You mentioned other places where you've experienced delayed rulings: Fulton, Cobb, Forsyth, DeKalb, Douglas, Clayton. Did you ever make any complaints to the Judicial Qualifications Commission about those delays that you were experiencing?
No.
Okay. And I wanted to talk about the specific case that you talked about. I think you said that the trial was the end of 2023, and we spoke about this case the other day on Tuesday, correct?
That is correct.
The trial started at the end of 2023, and then I think you misspoke and said it concluded the beginning of 2023, but you meant the beginning of 2024. Is that correct?
That is correct.
Okay. When we spoke about that case and that delayed ruling and that you were still waiting, you didn't give me the name of that judge. Is that correct?
That is correct.
Okay. And why didn't you tell me who that judge was?
I believe in our conversation, I told you that I'm not big on throwing people under the bus. In that particular case, the parties are living under a temporary order, and that's what they're doing right now. I just don't, I've not felt it to be I don't think it's appropriate in that particular situation to file a JQC complaint.
What is the remedy you would suggest?
Sometimes, if a motion is filed, I believe that there's statutory authority for a writ of mandamus. A lawyer can file a writ to get a judge to rule on a motion that's pending.
So every time it's day 91, a lawyer's supposed to go to the courthouse and file an extraordinary writ and charge their client several $1,000s instead of you calling and making a complaint? Is filing a complaint on a judge or expecting a judge to obey the Code of Judicial Conduct throwing them under the bus?
I don't think so.
You just said that.
Well, what I'm suggesting, sir, is I don't, from my part, the way I operate, I'm aware that certain people, certain of us that, practice, some of our judges, I was a JO, which is kind of like a judge. We're not perfect, and we make mistakes. I myself, when I was a JO, despite the directive from Judge Williams to get my orders in 2 weeks after hearing a case, I fell short of that standard several times. There probably were several times where I fell short of the 90-day rule. I think that every practitioner of the law should do what they see fit according to their own conscience and what they think is appropriate. For me, I don't think it's appropriate for me in that particular case to file a JKC complaint.
I guess if you noticed a pattern with one particular judge and it was happening often, would that change your mind on how you would address that?
Probably not.
Okay. Generally, what was that case about that you talked about that you're still waiting on the order? I don't need you to get into any facts. Like, is it custody of a child?
Yeah, it was. It's custody.
Okay. And what's the impact? I know they're under a temporary order right now, but obviously people are asking for something different than what's in that temporary order. Is that correct?
That is correct.
Okay. And so what is the impact to those children and those parents, and your client in particular? What impact is that having on them?
I couldn't say specifically because I don't know. We're all waiting for the order. I haven't spoken to that particular client in quite a while. But I think generally speaking, litigants are looking for a resolution.
Okay. You indicated that, I guess you had, the family law bar talks a lot, and there had been a lot about Judge Williams, but surely she's not the only judge that the family law bar is complaining about or has complained about. Is that correct?
That is correct.
Okay. All right. I want to talk about all of what you were doing as a judicial officer. So we talked a little bit about how often you were in court. So what was your understanding of how often you would be in court?
You mean hearing cases?
Yes.
Okay. So I think my recollection is what we worked out is I would sit 3 days per week. I believe that my people organize it differently. My predecessor, as I understand it, I think did like Monday through Friday and then took a week off. So, that person was only hearing cases 3 weeks and then took a week off. Some JOs do 4 days out the week. So when I initially started, I was hearing cases 3 days a week.
Okay, and that's every week?
Yes.
Okay, and what types of cases were you hearing?
What types?
Well, let me ask you. Sorry,
Yeah.
I can rephrase and ask specifically. Were you listening to child custody disputes?
Yes.
Were you listening to child support issues?
Yes.
And asset division?
Yes.
Okay. Were you having to make determinations about people's income so then you could decide about child support?
Yes.
Okay. Those were all things that fell on you to make that decision in the end. Is that correct? for those cases that you heard?
Yes.
Okay. And how many cases a day would you say that you were hearing?
A typical calendar for me, starting out, was somewhere between 18 to 20, sometimes 25 cases starting out. Not all of those cases are like final hearings. That would be ridiculous. A lot of the ones in the morning, the way the calendars were structured, were uncontested. And then status conferences followed. And then in the afternoons, if there were contempts or more substantive issues, those were typically heard in the afternoon.
Okay. And then at some point you started hearing cases 4 days a week. Is that right?
Yeah. The litigation manager would ask me, she would say, hey, these people need to get in. Are you available to hear a case on a Monday or a Friday or, whatever. And as time went on, because of, the volume and all that kind of stuff, I would agree, to hear cases more, to try to resolve cases.
And were you hearing cases that were at final disposition? You were making that final determination and entering that final order?
As time went along, increasingly, yes. I believe that so there's some, and maybe y'all stop me if you've heard this before. There are these local court rules in the family division. There's a rule that all the lawyers know. It's called a 1004. We're nodding our heads. We know what that is.
We do.
Okay. So the judicial officer who preceded me, there were a lot of 1004s filed. So that had the effect of cases that otherwise would be on the JO track got pushed to the elected track.
And when you started, those kind of dissipated because people realized that you were capable and competent of handling those cases. Is that correct?
Yeah.
Okay. Is that sort of what you explained to me the other day?
Yeah.
Okay.
I think, because I also practiced, I had a kind of a sympathy and empathy for lawyers in the practice. So we're just trying to get it to the finish line. I'm not trying to yank anybody's chain or make life hard, or have a God complex or anything. Like, look, what do we need? And I think I developed that reputation in the community.
Okay. And how many cases were you closing out per month, would you say?
I don't know the specific number. It would depend from month to month.
Okay, I guess the other day you told me about 50 to 60 a month. Was it somewhere around that ballpark without giving us
Probably, yes.
Okay. And did you have a staff attorney?
I did not.
So were you drafting those orders yourself?
Sometimes yes, sometimes no. For the pro se litigants, there's a system where you can do these little quick orders. All the lawyers know when you're filing something, we do it on Odyssey. That's a system that's used in Fulton County. There's a back end to Odyssey that the staff can see, which you can audit, and it has think about it like merge documents. It imports information, and it's got forms in there where you can generate quick orders more quickly. However, if there were lawyers on the case, and the case was a little deeper than just a pro se litigant, I typically would ask the lawyer to draft the order, and they would submit the order.
But you mentioned earlier that you were handling a lot of pro se cases. That's correct?
Yeah, that's correct.
Okay. And so a lot of times you were having to do that order yourself. Is that correct?
That is correct.
Okay. And then what would you do with that order once you finished it?
Once I finished the order, I would send it to the litigation manager for her to file.
Okay. Were there ever times that you filed them yourself, or was that always something that the litigation manager did?
That was always something she did. I never filed them.
I don't have anything further. Thank you.
Anything else for this witness?
Just one.
Okay.
In general, Mr. Bryce, as a JO, you weren't hearing complex, protracted, or high asset cases, were you?
No.
That's all I have. Thanks.
Thank you. May we excuse Mr. Bryce? Any objection? All right. Thank you, Mr. Bryce. You're free to go. Just watch your step. Next witness?
Yeah, we would call Attorney Pennywell.
I think this might be their last witness because they said 3 after.
Thanks. Did you read that stuff I sent you? No, thank you. No, thank you.
Can you please raise your right hand? Do you swear or affirm that the information you provide this hearing panel should be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Okay, please have a seat. And if you could spell and state your name for the record.
Certainly. Shauna Webb Pennywell. Shauna, Shana, Webb, Webb, Pennywell, Pennywell.
Thank you for being here this afternoon. I'm going to try to be brief with you because it is late in the hour. Are you a member of the Georgia Bar?
I am.
And how long have you been a member of the Georgia Bar?
It will be 17 years in November.
Okay, are you licensed to practice in any other state?
No.
Okay. Describe for the hearing panel the nature of your practice.
Certainly. So I am in a family law firm. Excuse me. We exclusively work on family litigation cases. There's some overlay in juvenile, some overlay in probate court.
Has that always been the nature of your practice?
So, well, no. Initially, when I got out of law school, I was in a large law firm, and then we all had 2008 hit us like a ton of bricks. So that reorganized my life a bit, and so really, since I'd say about 2009, 2010, I've been solely focused in family law.
Okay. I want to turn to the scope of your experience with the family division in Fulton County.
Certainly.
Have you had an occasion of appearing in front of all 4 divisions that make up the family division there in the Atlanta Judicial Circuit?
Yes, for the better part of a decade. So I've seen many judges that have come through the family law bench.
Okay, and do those appearances include appearing in front of Judge Williams?
Yes.
And how would you describe the family division in Fulton generally?
So,
from judges to caseload to just, yeah.
Well, certainly. So Fulton County being one of the largest counties in the state, there are a lot of family law cases. I would hazard a guess that probably about 35 to 40% of my caseload have cases in Fulton County. So those judges are extremely, extremely busy. I know that as of 2019, 2020, I understood that each of those judges were juggling anywhere between 500 to 800 cases. And you have to think, the way that we can figure out how many cases have been filed is based on the case number in and of itself. And so with Fulton, they try to be a little bit more regimented on the litigation side, where we have status conferences at 30 days, 60 days, and 120 days. Those dates have no correlation with the actual dates and filing, but there are mechanisms to try and make sure that cases are moving forward towards a final hearing.
Yeah. Did you experience, or have you experienced delays there in Fulton County?
And delays in terms of?
In terms of when a judge would rule on a motion that didn't necessarily require a hearing, or in terms of completing an order in a final matter after a final hearing has occurred?
Well, so as a attorney, I don't necessarily know that I characterize it as delays because it's with the court. And whether or not it's a motion that is going to need to just be heard on the pleadings or whether there's going to be oral arguments, once it's with the court, it's there for determination. And so whenever it comes back to us is when it was supposed to come back to us. Now, were there times that we would need to follow up about the status of orders? Certainly. And so at that point, with any of the divisions, my office, I may call into chambers and speak with a judicial assistant. My paralegal may do so to just get a status on that. And that, of course, is for, as a private attorney, client management and helping clients to manage expectations.
Okay. I want to turn to your appearances specifically before Judge Williams. Tell the hearing panel the types of cases you had before Judge Williams.
Certainly. So I have had divorces in front of Judge Williams and custody modifications.
Okay. And how many times have you appeared in front of her?
Probably over 24.
Okay.
Over the course of her time on Division 3.
Okay. And when is the first time you appeared in front of Judge Williams?
Probably it would have been shortly after she assumed her roles in maybe early 2021. I believe that Judge Williams, separately from what we didn't necessarily see in any other division, was that she would actually come to court and handle status conferences for us. I understood that to be that she was trying to get a grasp on the cases that were before her because, especially with Division 3, there was a significant amount of cases that were in that division when she assumed the role.
Okay. In what capacity? I mean, did you appear in front of her? I know you appeared in front of her as a litigant, but did you also appear in front of her as a Gale at any time?
No, I was never appointed as a guardian ad litem, and I was a litigator. Promise, I have not been a litigant in front of Judge Williams.
Okay. During the appearances, how would you describe her overall judicial demeanor and temperament?
Extremely measured, very professional. And so one of the things that I have always appreciated is patience. It never felt like it was a burden for myself and my clients, my opposing counsel, to be bringing our issues before her. You know, we're family law attorneys. We are dealing with people in chaos. There are times where we're able to resolve it between the parties and counsel, but most of the time we need court and judicial intervention. And it always appeared as though she was happy for us to be there and asking and seeking the court's advice. And that is something that is very different, because there are other times where I've been in other courts that it almost feels as though seeking judicial intervention is a burden on the court.
What about your understanding, or at least your observations and perceptions of her concerning the knowledge of law as it concerns family law matters?
Oh, absolutely. So Judge Williams really was impressive in terms of, I am old enough now to try and, I think, get away with those old litigator tricks from time to time when you're presenting a case and you may want to move forward quickly over facts or issues that don't necessarily comport with how you want the law to be read. Judge Williams was extremely quick on her feet and would quote case law back to us to make sure that she was understanding exactly what my argument was. Anecdotally, I can tell you that there were times where I would be in the middle of an examination. There was elicited a objection. So we're arguing about the objection. Admittedly, by the time we had finished arguing, I had forgotten necessarily what the question was to begin with, and Judge Williams would recount verbatim the last 90 seconds of what had been said in testimony when I couldn't necessarily remember, and that will always be impressed upon my mind as just being extremely impressive and extremely focused on the matter that was before her.
Did you have an occasion to receive various rulings from Judge Williams?
I did.
Were they always favorable to you?
No.
Speak to me about the thoroughness of her rulings and how they impacted your cases.
I mean, certainly. Two cases, seminal cases that come to mind. Judge Williams heard a modification matter that I believe we started at 9:30, and we did not walk out of that courthouse until about 11:45 that evening, because she was determined, as well as the attorneys, that we were going to see this through to its conclusion because of the needs of both parents and the minor child that was involved. Her ruling was extremely detailed. It was thoughtful. Her oral announcement from the bench was thorough and complete in helping both my client, who I represented, the mother, who was the respondent yet counterclaim petitioner, and the opposing party, to understand the rationale and to really come to terms with family law, again, is people in chaos that aren't necessarily acting in their best selves. And so helping them to really come and recognize what their behaviors were and how it was going to be impactful, not only for their co-parenting relationship, but how it's going to impact their child. And so I very, very, very much appreciated the level of detail that she went through, because that also makes my job easier on the other end when walking out and trying to explain, here's what the judge said. The second case that I can think of was a 3-day trial on a modification of custody that took place in August of 2024. I represented the respondent in that matter. We did not prevail on our requests for a modification of custody. Nevertheless, Judge Williams remained extremely engaged. When she made her ruling, it was very clear, and it was just another example of going through and meeting the litigants for where they were at. We're not talking over people's heads with legalese that only the attorneys and the guardian ad litem would understand. It was to the individuals, to moms and dads who were looking at her to solve extremely intractable disagreements between them.
Do you have an overall opinion about Judge Williams and whether or not she's a good judge?
I do. I find her to be not just a good judge, but an excellent judge. So to give you just a moment, I have been in courtrooms across this state. Family law is not necessarily an easy practice because it requires the knowledge of family law. It's going to require the knowledge of some tax law. It's going to require the knowledge of business law. It's basically every other piece of law, and criminal law sometimes in that as well. And so I have been as far north as Catoosa, as far south as Chatham, and I've seen a lot of judges and been in front of a lot of judges. And Judge Williams stands out in my mind as being one of the best. And when I say one of the best, I'm qualifying that with a judge who wants to do a good job, a judge who is engaged with counsel, who is professional and allows counsel to present their case, a judge who remains even-tempered and is not overly
I guess I'm losing my word here. There's not, you come in with a sense of impartiality. So,
Do you have an opinion about the impact of removing her from the bench, what that would do to the citizens of Fulton County?
it would do a grave injustice to the citizens of Fulton County. I am a citizen of Fulton County. My husband is a citizen of Fulton County. We both work in the city of Atlanta. I'm in my practice. He's at the State Bar of Georgia. We raise our children right down the street in the General Grant Park area. And I voted for Judge Williams. My husband voted for Judge Williams. And we voted again. And that is with me knowing the scope that there was an investigation, because she is a credit to our community. And I believe that we need judges that are just like Judge Williams, people who actually are invested and care about the constituents that come before them. Whether or not it's going to be favorable, that's based on a host of other things, facts, circumstances, and the law. But there has never been a moment in my viewing of Judge Williams, and that in which my clients and I have both shared in, knowing that she was invested and cared for the best outcome. Whether that was their outcome or not remains to be seen.
In the event that the hearing panel decides not to remove Judge Williams and she submits her name for re-election, would you then vote for her again?
Without a doubt. And, I don't not the person who goes and stumps or waves signs or anything like that, but I absolutely would, without reservation, make sure that not only myself, but every social circle that I belong to, every social group that I belong to, also understands and knows my feelings, because my feelings, they're not just mine. I truly believe that that is the reality, that she is a credit to our community. And I'm not the only one who would have known in the last election that there was a pending JQC investigation. Yet again, as a voter and a stakeholder who, again, is raising her family here, this was my choice for who was going to serve our community in the best, highest, and most prescriptive ways, I believe, in having the law be impartial and without a doubt, I would vote for her 1,000 times again.
Would it surprise you to know or learn that Judge Williams had little or no experience related to family law matters before she took the bench?
It would, because she's always been extremely poised, and like I had mentioned earlier, very quick on her feet with applicable case law, and was extremely abreast of the change of law. So whether she read McConaughey's front and back, which would be impressive in and of itself, I had no concern about her acumen.
Did you, at some point, write a character letter or a letter of support on behalf of Judge Williams?
I did last fall.
May I approach you?
You may.
Handing you, Attorney Will, and what I'm going to mark as Respondent's Exhibit number 17.
Thank you.
Do you recognize that, ma'am?
I do.
Is that a letter you wrote on behalf of Judge Williams?
It is.
And do you stand by that letter?
Absolutely.
And why'd you write that letter?
Essentially, I wanted to make sure that the investigative panel that was looking over the complaint from the JQC had an opportunity to understand who Judge Williams truly is. And in this, I put in here that I have
no reservations about her ethics. I have never had any reason, and our family law bar is a very insular type of group that once you've been practicing, everybody knows everybody real quick, and everybody knows everybody's business real quickly. And again, outside of this issue that we became aware of at the end of last year, I had no reservations and had no knowledge that really most of my colleagues had any reservations.
All right. Thank you for your time, ma'am.
Certainly.
Did
Question.
anyone,
Oh, sorry. No, go ahead.
did anyone ask you to write this letter?
No.
Thank you.
Questions of this witness?
Good afternoon, Ms. Pennywell. My name is Courtney Beal. I'm the director of the commission, but I am prosecuting this case on behalf of the investigative panel of the commission. This is our hearing panel. I appreciate you being here. I've just got a few questions for you. You mentioned earlier, so there were some questions about whether or not you had experienced delays in receiving orders. And what I understood you to say was, I took it that you must be very patient and also understand that sometimes delays happen with judges and getting orders, especially in high volume jurisdictions. Is that accurate?
Sometimes I would say a fair amount of the time, based on the fact that I am in multiple jurisdictions.
Okay.
It's not uncommon.
Okay. So in your experience, and I just want to talk about final orders, like orders
Certainly.
that are the result of a final hearing, what kind of delays have you experienced?
Wondering if we need to throw a first birthday party for waiting for a final order.
Okay.
That was in a metro county, a metro Atlanta county that was not Fulton. That was in multiple, actually, metro counties that are outside of Fulton.
Okay. And so it sounds like at about the year mark, that sticks out to you as circumstances where there was a significant delay.
Oh, certainly. A year, 15 months, 18 months, because 18 months is usually about halfway through the gestational period of a elephant. So, you know, we have to kind of figure out and get some levity in here because, again, we do have clients that we need to make sure that we keep abreast of where things are.
About how many times do you think you've had delayed orders that have been a year or longer delayed?
Do you want to quantify within how, like, within the last year, within the last couple of years? Because I don't know that I could count.
Do you find that length of time, a year, do you find that to be acceptable for your clients to have to wait that long for finality?
I don't know whether I can say acceptable or not. It's difficult. It is difficult. It can pose challenges. Those challenges are going to be very specific to exactly what type of case was being heard. Is it difficult? Is it difficult if it's a divorce matter? Yes, it would be. Is it difficult if it's a modification? Possibly, but people are operating under the last order of the court anyhow. So again, depending on, it's going to be fact dependent. Now, I can also tell you, in thinking of this very specific case that is not Fulton County, it's a termination of parental rights. That order should not have taken almost, I think it was right at 17 months to come out when you're terminating someone's parental rights. And so, again, that's problematic. Now, I happen to be representing the individual who's had their rights terminated, so it wasn't necessarily in his or her best interest for me to be banging down the court to figure out the status of that order.
In the occasions in which you've had delayed orders, let's say just a year or longer, short of doing what you mentioned on direct, which was that, you would reach out to the judges' chambers and inquire, have you done anything additional?
No, outside of telephone calls and emails. There may be some emails following up, but there's nothing further.
Okay. Have you ever considered filing a complaint with the JQC?
No.
Why not?
So it kind of goes along the lines of, as an attorney, there are methods that I use or strategies or just volume that I may not get to things as quickly as possible. Does that mean that I would ask all of my clients to go ahead to the state ethics bar if there's not an ethical issue? No, I don't find it to be an ethical issue about the timing of orders, as long as I understand and know that it's still on the court's radar, which everyone has always been appropriate, including Judge Williams' chambers with us. I have no further issue.
Okay. Are you aware of the statute in the state of Georgia that requires judges in counties that have a population size such as Fulton to rule on certain motions within 90 days?
Certainly. I believe it's over 300,000 individuals or something along those lines, because I had to look that up for the TPR that I was just addressing, because wondering why we didn't have that. I am aware of that. But I think as we all are in the legal profession, understand that we don't operate in a vacuum. We practice law. I think the same practice kind of goes, that doesn't stop when you hit the bench either. So there are contingencies that none of us necessarily can plan for beforehand.
What duty do you have to your clients in that regard?
In keeping them informed and up to
That it's going
date.
to take 2 years to get a motion?
Well, sir, I wouldn't necessarily know that from the outset. And so what I would do is follow up and let them know we followed up with the court, make sure and check in with them. And if there was, I've not had this encounter, but I would assume that if there was some sort of urgent or circumstance that needed to be addressed, we would have a way to either file a request for a status conference, ask the court for even if it's a status telephone conference with counsels to address whatever interim matters happen between the final hearing and the final order.
What if you had called and sent emails and asked for another hearing and you had not gotten a response from the judge's office? How long would you allow that to be the case?
Well, I've not done that. So I've not had to ask for another hearing. So I don't know that I could say anything. Now, what I can tell you, especially in my instances, is that it was not in my client's best interests to continue to push necessarily for a final order. And in that respect, I have to continue to keep my client's best interests at the forefront, because that's my ethical duty.
Okay. Are you aware that the Code of Judicial Conduct contains a rule that says judges are required to dispose of all of their judicial matters promptly and efficiently?
I am not aware, but it absolutely sounds like that would be something in there.
Okay. You testified just a minute ago that you don't find the delays with orders and decisions to be an ethical issue. Understanding that there's a rule that requires judges to resolve their matters promptly and efficiently, if you had a judge that repeatedly failed to resolve their matters promptly and efficiently, to you then, would that be an ethical issue?
I guess the question would be, what are we defining as prompt?
Okay.
Because everything on the efficient side, I would say that the orders comported with all of the rulings and were probably even more clear than the time that Judge Williams would take in making her oral pronouncements to the court.
Do you find a year to be prompt if parties have to wait a year to get an order?
I would find it unfortunate, but I also know that that is not unusual, whether it is Fulton, whether it is Cobb, whether it is Paulding, whether it is Coweta, whether it is Spalding, whether it is Troop, whether...
Well, just anywhere in the state, is it prompt for a court to take a year to issue a final order, in your opinion?
I would say no. It would not necessarily be prompt.
Okay, so kind of with that as the guideline, right? A year is not prompt. If then back to our rule, if you had a judge that repeatedly failed to promptly resolve their judicial matters, then would that be an ethical issue? Would that be a judge that presents an ethical issue to you?
So, and I guess I want to make sure that I'm clear in what I would consider prompt. Many judges require that attorneys provide proposed orders to them, and when those orders are submitted, the judges will review them. Now, the orders, in my experience specifically with Judge Williams, was that Judge Williams wrote all of her own orders. It was not either myself or my opposing counsel's work product. That in and of itself is an exercise that takes a lot more time and diligence. So my question of whether it's prompt when someone is actually writing their own orders versus reviewing and marking up attorney submitted orders, that's two different inquiries. And that would then implicate, I guess, two different questions about ethics.
Okay. You indicated, you testified on direct that you had read, or at least I understood that you had read the charges that were out there at the time Judge Williams stood for re-election in 2024. Is that correct?
I did.
Okay. So that would have just been the one set, that first set of charges
Yes,
that was out there?
that is correct.
Okay. Understanding that at the time that you read them, and even now still, they're just allegations.
Mm-hmm.
If you had, in your reading, accepted those allegations as true and proven, would there have been anything in that set of formal charges that concerned you about Judge Williams?
Well, certainly. I think any time that there are discussions potentially of any ex parte communications, you get a little weary as to, well, what exactly is happening here. Nevertheless, I'm a trained attorney, and apart from that, I'm also wildly, I have the ability to see, okay, well, that didn't have any impact in and of itself on any determinations that were in that case based on what I've read on the docket. So because, again, this family law bar that we belong to, while it is wonderful and tight-knit, it is also very, very insular group. And so understanding that all of those things being true, I still believe that she is the best person to continue to occupy her spot, because I have sat at those council tables with individuals who have less than a high school education, and she is able to meet them where they are, just as though I have sat with clients who have multi-million-dollar trusts. She is able to meet them where they are, and that is not a skill set that is prescriptive of many individuals, let alone those who occupy the bench.
Did you read the second set of charges that was filed, and they would have been filed after?
It was after the election, I believe.
Correct.
I do remember reviewing them, but I could not necessarily tell you what was contained in them because I have not looked at either truly since probably when as close in time as when they came out.
Do you remember there being an allegation that Judge Williams improperly detained somebody that was present in her courtroom for a hearing?
Yes.
Okay. Again, understanding they were allegations when you saw them, if that set of allegations were true, is that something that would have been concerning to you?
No, I mean, I have sat at counsel table and had a judge yell at my client for chewing on ice that was, by the way, provided in the picture from the court, and had a deputy stand next to him to tell him if he was chewing on ice one more time, he was going into lockup on a family law modification matter. I have had judges threaten, scream, demean, be horrible to my clients. So in terms of, I would want to have more context as to why she was in lockup, what was the purpose of that, because...
What if the purpose was just to shock or scare the 21-year-old?
To the extent that it doesn't fully capture Judge Williams' intent, I would object to the question.
Okay, overall.
Certainly. So I have also sat from time to time in juvenile court. And so unfortunately, and I think we are all of the age to have seen Scared Straight and shows of the like. I trust that I would trust that if there was that occurrence that happened, that there was a reason, and that reason was not just to shock or scare, but to ultimately have a change of behavior and or perspective of that individual. I don't believe it to be malicious, and there's nothing that I've ever seen in the last 4 years from Judge Williams that would lead me to that conclusion without additional facts.
What if it was intended to scare straight, as you referenced, but it was also not legal?
So, again, I can't necessarily opine on the legality versus the illegality, but I can tell you, as working in this area with people who are in crisis, who are acting sometimes appropriately, but then sometimes very, very, very much inappropriately. I've threatened my clients to say, you could get thrown in jail for this. You could be taken into custody for this. So I don't necessarily know, it's a little different, obviously, that they don't necessarily, some of them have gotten picked up. But again, I would believe that if it was coming from Judge Williams, it was for a higher and better means than just to be horrible and retributive.
Okay. It sounds like even if that second set of charges had been filed, and even if those things had been true, you would have still voted for her again.
Yeah, I would, because I'm in our community. Okay. And I know the very, very specific needs. Now, I don't live in North Fulton. I live in Grant Park, and my kids go to Atlanta Public Schools. And I understand the number of pro se litigants and just litigants in general who are going to come before the court. And we need individuals who are sensitive to that. And I have seen nothing but the highest regard from Judge Williams in being able to deal with the day in, day out constituency of Fulton County.
the election that you've referenced, the recent one in 2024, you said that you voted for her as well as your husband. Judge Williams ran in that election unopposed, correct?
Correct.
Okay. All right. That's all I have. Thank you.
No worries.
Anything else, Mr. Banks?
They could have put somebody up against her and run against her if they wanted to, couldn't they have?
They could have.
If they had done that, would you have still voted for her?
I would have.
Okay. To the extent that you were asked about some delayed rulings, let me ask you this. If a judge has a case count of 650 and there are some delayed rulings in 16 cases or 15 cases, do you think that that warrants removal, ma'am?
Oh, absolutely not.
Thank you.
Anything else for this witness?
No, Your Honor.
May we excuse Ms. Pennywell? Mr. Banks?
Yes.
Any objection?
No, Your Honor.
Thank you, ma'am. You are free to
Thank
go. Just watch your step.
Thank you.
I'm almost scared to ask this question, but are there any more witnesses or evidence?
We don't have any
I
more.
thought that was your last one. Any
That was
other
my last one.
witness or evidence to present?
No, Your Honor.
No?
No.
Okay. So then evidence is closed, and so we're ready for closing argument. Are we doing that tonight?
Yes.
Give us 5 minutes.
We asked the attorneys, what would you all prefer to do?
I already know what they would prefer to do, but go ahead. Somebody go first. What's your preference on closing?
Oh, no.
Evidence is closed. We're done with that. We just have closing left. So what's everybody's preference on closing?
To not do it today because we've been here all day and it's been a long day.
I'll defer to the panel. Whatever the panel wants me to do, I'll do it.
Okay. Would we be allotted the amount of time that we previously discussed?
That's my question. How long does everybody think their closing arguments will be?
Well, that's a difference.
So we can kind of, we're going to step off and decide, but just give us an idea of what are you thinking? I realize it's an estimate, but what are you thinking, just generally from what you know?
So
that
I have
you
the
need to-
burden, and I know in our previous discussions I had said about an hour.
Right. Mr. Banks, you think about the same?
Yeah, it's going to be about an hour.
Can you do it in a pleading?
I don't write as well as I talk, and so
Just asking. That's okay. I agree. I turn into a pumpkin on Monday, though. My term's up.
well, I would move that you stay on the panel. You've been very attentive. You've asked very astute questions. I don't know why your term couldn't be extended for this.
Because I don't want it to be.
We're
21 years.
All right. We're getting off track. Give us 5 minutes, okay? Thanks.
And if it's between a pleading and doing it now, I'd like to do it now.